Yeah, lady.
No, I'm not seeing. Really? Yeah.
So,
Okay.
my copy. Owner's appeal tomorrow, Lordship. Challenging a contributor negligence. EP has been filed only tomorrow. Tomorrow, day.
ಯಾವ ಇಯರ್
Fresh matter, 2024.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
Fresh matter.
ಅಡ್ಮಿಷನ್ಗ
Admission, please.
Preliminary hearing,
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಏನು ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ.
The applicant was appointed as Anganwadi teacher, my lord.
ಹಾ
In the year of 2001, the respondent challenged that order, my lord. The single bench has quashed that order. Till 2021 to up to he is working Anganwadi.
ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಏನು ಅರ್ಜೆನ್ಸಿ ಇದೆ
My lord, read petition, my lord. Read petition, my lord. Challenging the KT order, my lord. Day after tomorrow, my lord. Fresh matter, my lord.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
Yes, my lord.
ಅರ್ಜೆನ್ಸಿ ಇದೆನಾ
Yes, my lord.
ಏನು
The respondent number 2 has initiated the contempt, my lord. Day after tomorrow.
ನೋಡ್ಕೊಳ್ಳಿ.
One fresh matter for tomorrow, my lords.
ಏನು ಅರ್ಜೆನ್ಸಿ
The appellant is the CEO of the society. He has suspended without considering his reply to the show cause notice, my lord. And
ಸಸ್ಪೆನ್ಷನ್ ಎಲ್ಲ ಇದೆ ಏನು ನೆಕ್ಸ್ಟ್ ವೀಕ್
Lords, on contempt, Lords, fresh matter, Lords.
ಹಾ
Fresh matter, Lord. Time bond promotion.
ಹಾಕೊಳ್ಳಿ ಕಂಟೆಂಪ್ಟ್ ಎಲ್ಲ ನೋಡ್ಕೊಂಡು ಹಾಕೊಳ್ಳಿ ಕಂಟೆಂಪ್ಟ್ ಎಲ್ಲ ಏನು ಅರ್ಜೆನ್ಸಿ ಇರ್ತದೆ ಬ್ರದರ್
Kindly press matter, madam. Review petition in contempt matter. Review petition in contempt matter, madam. Press matter.
ಮ್ಯಾಟರ್ನಲ್ಲಿ ರಿವ್ಯೂನ
Yes, madam.
ಹಾಕೊಳ್ಳಿ
Yes.
One matter for my lord,
ಹಾಕೊಳ್ಳಿ ಯಾಕಂದ್ರೆ ನಮ್ಮ ಮುಂದೆ ಮತ್ತೆ ಧಾರವಾಡಕ್ಕೆ ಬಂದ ಬೆಂಗಳೂರಿಗೆ ಬಂದ ಬೇಡ ಇಲ್ಲೇ ಹಾಕೊಂಡ್ಬಿಡಿ ಹಾ
extension of interim order, my lord. Attachment warrant has been issued.
ಕೊಡಿ ಕೊಡಿ ಅದೇನು ಬಿಟ್ಟು ಹೋಗಿದೆಯೇನು ಅಥವಾ ಎಕ್ಸ್ಪೈರ್ ಆಗ್ತಾ ಇದೆಯಾ
No, my lord, this honorable court has granted 4 weeks time. The corporation, I mean, subsequently they have deposited the amount, my lord. Please.
ಹಾ
Lords, MFA series case, my lords, LSC.
ಹಾ
MFA LSA series case, my lords. Connected matters have been listed on 25th, my lords.
25th?
25th. These matters may be listed. 20.
ಇದು ಇದೇ ಇಂಥವೇ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಅದು
Yes, please, my lords. MFA, my lords. P&C.
P&C
Please,
MFA
please.
ಏನು ಅರ್ಜೆನ್ಸಿ ಇರ್ತದೆ P&C
Lords,
ಅಪ್ಲಿಕೇಶನ್ ಒಂದು ನಿಮಿಷ ಮಿಸ್ಟರ್ ಕಟಾವಿ
Yes, ma'am.
ಕಟಾವಿ ಇಸ್ ಆನ್ಲೈನ್
Yes, ma'am.
ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ
I have unmuted.
ಹಾ
Plus serial number 6.
Serial number 6.
6
Section 37, my lords.
37 management.
Management has filed review, my lords.
ಯಾವುದು
Lords, the Lords age matter, my lords. Review has
58 years to 60 years enhancement.
My lord, this is a case where your lordships had passed an order which is
ಡಿಟರ್ಮಿನೇಷನ್ ಏಜ್ ಆಫ್ ರಿಟೈರ್ಮೆಂಟ್
Please.
age of retirement. The other day before your lordship sitting in Bangalore, we had moved an application during which I had submitted that there is a review pending against your lordship's order. That review, along with the review preferred by the workers' union, is also listed today. May I just suggest that my lordship we can have it along with the other application which your lordship heard and posted it to 24th of October 2024. So that this can also be disposed of.
ಆಲ್ ರೈಟ್ 24th ಹಾಕೊಳ್ಳಿ
Serial number 6.
6 and 37.
6 and 37.
6 and
37. Today is
37
37.
ನಮ್ದು ಕೃಷ್ಣ ಭಟ್ರ ಜಜ್ಮೆಂಟ್
Please, please, my lords.
ಹೌದು ಸರ್ ಅಲ್ಲೇ 24th ಡಿವಿಷನ್ ಬೆಂಚ್ ಟೂ ಮ್ಯಾಟರ್ಸ್ ಯುವರ್ ಸೆಲ್ಫ್ ಅಂಡ್ ಆನರಬಲ್ ಜಸ್ಟಿಸ್ ಪ್ರದೀಪ್ ಪೆರೂರ್ ಅವ್ರ ದೇರ್ ಇನ್ ರಿಟ್ ಅಪೀಲ್
Last Friday, my lords.
in RP both honorable judges are there.
ಓಕೆ ಬಟ್ ಈಗ ಇದು ಈ ಆರ್ ಪಿ ನಮ್ಮ ಮುಂದಿದೆ
ಹೌದು ಸರ್
ಅವತ್ತ ಎರಡು ಆಗ್ತದೆ ಅಷ್ಟೇ
ಅಂದ್ರೆ ಬೆಂಚಸ್ ಆರ್ ಚೇಂಜಸ್ ಮೇಲೆ
Ugly, since it has to come before your lordships, my lord, it can always be constituted at Bangalore.
ಅದು ಕೃಷ್ಣ ಭಟ್ರ ಸಾಹೇಬರು ಮಾಡಿದಂತ ನಾನು ನಾ ಮಾಡಿದಂತ
ಹೌದು ಸರ್ ಹೌದು ಸರ್
My lord is the author of the judgment.
ಪ್ರದೀಪ್ ಪೆರೂರ್
Extension of time
management
has
has
been
filed the extension time in writ appeal, my lord. In writ appeal, the honorable court appointed the honorable justice Pradeep Perur and yourself, my lord, your good self. In the in both RP petition, the honorable chief justice has appointed both of you your good selves.
ಇದು ಅಲ್ಲೇ ಬರ್ಬೇಕಾಗತ್ತೆ ಬಟ್ ಅದು ಆರ್ಡರ್ ತಗೋಬೇಕು ನಾವೇನು ಅಲ್ವಾ ರಿಜಿಸ್ಟ್ರಿ ಟು ಪೋಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ before appropriate bench after obtaining.
Writ appeal 100.
250.
After obtaining orders at the hands of Honorable the Chief Justice. Since the companion writ appeal is before the bench comprising of justice and ನೋಡ್ಕೋಬೇಕು ನೋಡ್ಕೊಂಡೆ ಇಲ್ಲಪ್ಪ ನಮ್ದೊಂದು ಅದೊಂದು ಎರಡು ಕಡೆ ಆಗ್ತವೆ ಎರಡೆರಡು ಬೆಂಚ್ ಆಗ್ತವೆ.
Serial number 6 and 37. Obliged.
My lords are calling it on 24th, my lords?
24th ಗೆ
Obliged, deeply obliged.
No, you take a chance. We do not know. We are outgoing judges.
See, I hope both my lords are sitting in Bangalore.
Chief orders ಆಗಬೇಕಾಗ್ತದೆ ಅದರಲ್ಲಿ 24th ಅಲ್ಲಿ ಬೇರೆ ಇನ್ನೊಂದು ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಹಾಕೊಳ್ಳಿ, ಯಾಕಂದ್ರೆ ಚೀಫ್ಸ್ ಆರ್ಡರ್ ಬೇಕಾಗ್ತದೆ. ಎರಡು ಬೆಂಚ್ ಮುಂದೆ ಹೋಗಿದೆ ಅದು ಅದಕ್ಕೆ.
24th ಬರ್ದೇ ಇದ್ರೆ ಪರವಾಗಿಲ್ಲ. Any other matter is listed before your lordship. On that day, lordship can consider this, posting it along with the other application which my lord is obliged, deeply obliged.
One small clarification we needed, that of course we have treated it on our own, we have worked out that, just we want to ensure that we do not commit mistake. No review is filed in that global?
Review is filed.
Filed. Where is that?
In our compilation itself.
Review petition number?
Please. Against the global mill, against initially, one submission.
Review is also dismissed.
Review, please. After the global mill, matter has been taken to Supreme Court. Please.
SLP went against Honorable Justice Nagaratna bench judgment.
Please.
Then you withdrew that.
Please.
Whoever.
Please.
Withdrew that.
Oh,
perhaps you have withdrawn that.
Oh, yes.
While withdrawing at page 3,
Please.
unnumbered para 2,
Please.
Apex Court said
Please.
that you were saying appealability under the 1894 Act is not considered.
54. Yes. Correct.
Therefore, they permitted you to urge that point.
Please.
Against that, review was filed.
Please.
Review also came to be negative.
Please.
Thereafter, matter went to Supreme Court.
Please.
And there it is pending.
Please.
That's how we have structured.
Correct. Actually correct.
And there is no stay.
No stay. No.
The facts ಮೇಲೆ ascertain ಮಾಡಿಕೊಳ್ಳಿ.
Correct. Please.
Correct.
Correct.
Okay. We have followed judgment of Honorable Justice Nagaratna's judgment.
Please.
We have referred to some judgments of the Apex Court as to what is meant by appeal, what is meant by right of appeal, when right of appeal accrues. Apex Court said in two judgments, very tall judges of the Apex Court, the right of appeal accrues when the original proceedings are instituted, although they become coherent and exercisable after appealable order is passed in those proceedings. In all these proceedings, they were taken up under the provisions of 2013 Act, not under 1894 Act. All right. From that way, we held the subsequent legislation has nothing to do with this appeal. That is one aspect. The second one, both of you very fairly said, we asked you, everything is available on online also. That's a good thing actually. You said that it's a matter for consideration by the larger bench. Therefore, much of your argument was on section 7 of the Karnataka High Court Act 1961. From that angle, we have considered. Twice we asked, Do you think that any presidential errors in the judgment? Do you feel that presidential value of the judgment is affected by some circumstances? And your answer was that no, no sub silentio, no per incuriam.
Because there is no earlier judgment.
That's what.
Question of per incuriam does not arise.
Will not arise at all. Therefore, you have said that also, that paragraph. And review is already considered by the coordinate bench. And matter has been concluded there. Therefore, we only concurred with that view. We have referred to Thomas Cooley of American constitutional law jurist, Cooley's constitutional limitations, which Keswananda, etc. referred to. We have referred to Glanville Williams when we can go for reviewing the judgment that way, reviewing the presidential value of the judgment, not 47 review. We have referred to that. We have referred to what has been referred and discussed by Honorable Justice Nagaratna Madam in that judgment. Just one paragraph. Why we do not want to refer the matter to the larger bench? We have said the pains taken by that bench. I'll come to that one. See, how many legislations have been considered in that judgment? Land Acquisition Act 1894, Limitation Act 63, Indian Easement Act 82, Representation of People Act 1951, CPC 1908, Arbitration Conciliation Act 96, Rajasthan Premises Control of Rent and Eviction Act 1950, Special Courts Trial of Offences Linked to Transaction Securities Act 1992, Central Excise Act 1944, Companies Act 1956, Companies Act 2013, National Investigation Agency Act 2018, Electricity Act 2003, Foreign Exchange Management Act 1999, Bihar Industrial Area Development Authority Act 1974, Sikh Industrial Companies Act 1985, UP Motor Vehicles Taxation Act 1935, Assam Value Added Tax Act 2003, Surface Act 2002, Recovery of Debts Due to Banks and Financial Institutions Act 1993, and the 2013 Act. There are three more legislations, very frugally they have been referred to, therefore we have not this. So all these legislations have been considered. So many legislations are not considered even in Keswananda. We just I examined empirical study I took to see that Keswananda attracts me very often. So I did that. So many legislations are not considered. The coordinate bench has scanned as many as 35 decisions of the apex court. One decision of Bombay High Court, Madras High Court, Kerala High Court, and Delhi High Court each. 4 High Court judges. It has referred to Halsbury's Laws of England, volume 28, page 266, which discusses philosophic justification for the statutes of limitations. The bench has invoked a commentary on the Constitution of India by D.D. Basu. Article 300, capital A. Doctrine of eminent domain is discussed, duly adverted to at paragraph 60 of the judgment. It was a celebration to read that judgment. That apart, the following are the maxims which have been referred in that judgment. Interest repudicae up sit finis litium. It is for the general welfare that a period be put to litigation. Then vigilantibus non science. Law assists those who are vigilant and not those who sleep over their rights. Why we have said this is last paragraph. Nagaratna Madam said, you should not sleep over your rights. And that judgment was rendered in 2020. It was rendered in 2020. Why you did not get alerted by that judgment? By legislation, you do not get alert. The interpretation placed by the division bench of this court, affirmed by the apex court, you don't get alert. What else can be done to you people? We cannot do anything. Therefore, then law is hard, but it is the law. another that is dura lex sed lex, then verbis legis non est residendum. From the words of law, there must be no departure. So 4 maxims have been referred to in that. See, it is not that one fine day judges gave dictation and the judgment came out. Judgment was reserved. Then so much material, jurisprudential material is woven into the bone, flesh, blood of that decision. Therefore, we said not a case for invoking section 7. That way we have structured the judgment. We may be wrong also. We do not know. We may be. This is what honestly we felt. Okay. In the above circumstances, the application in IA number 1, another aspect. In the application, not even one single sentence condone the delay. Strangely, we come across that such applications. Your application coupled with affidavit of 3 pages, it says, give permission to file the appeal. Under which law? Under which law permission is required? Under which law we should grant permission? We have said 2 sentences on that. That will reflect on the bar, but we could not resist our temptation to write it, because at least you should have said, this is the delay. This application is supported by affidavit. In the application, we have prayed for condonation of delay. In one of the paragraphs in the accompanying affidavit, we have prayed for condonation. Nothing like that. We have not said that it's a very dubious way of, structuring the pleadings, but we have said that strangely it runs that way. Okay. So in the above circumstances, the application in IA number 1 of 2022 seeking condonation of delay is liable to be rejected, and accordingly it is first off. As a consequence, saw that it was argued for 93 seconds. That is a case for review, rightly, because already it was review was rejected. But still you have dedicated 90. But you have assisted very effectively. We learned a lot from you. As we do on a daily basis. Rest of the, Mr. Nargundu, we have treated every aspect. Only thing is, except one decision which you have quoted, all your decisions are considered by Justice Nagaratna Madam. Except one decision. All decisions are considered. They are considered in other names. Those decisions which you have quoted, those decisions which are referred to in another judgment, those judgments are referred to by that bench. We examined that also. Therefore, in so many words, we have not treated this one. Yes. And all these connected appeals, except one appeal which was under the old act, that we have separated, and we are putting it for further hearing, but we will say we have not before release from parted might be. All right, that was the order release from parted. Matter was wrongly listed, clubbed with other matters, and it arises under the 1894 Act, and therefore no judgment is made in this matter, since it requires deeper consideration. First off, release from parted, post before appropriate bench. Obligement. All. Thank you so much.
Great look.
Especially Nargun Saab and Gangadhar.
They have deposited 50% and somewhere 100%. It was permit the claimants to withdraw.
Correct. You are right. Since as a precondition, certain sum of money has been deposited in this appeal, the same be transmitted to reference court for being released to the concerned land losers, claimants, in accordance with law.
My request,
Ha.
stay is the, some till appeal, may I seek your lots of
Where is
indulgence?
that? Where is the matter for stay? Stay cannot be granted for mere askance. Make out a case for stay.
No, my lord, in
My
the
lord,
other matter,
others
lordship
are-
has observed that liberty is reserved to the claimants for execution.
Where should I reserve liberty? It's your right to execute. It's your right. We have said all executions should come to an end within 1 year in that Rahul Shah versus so and so, which came to be affirmed by the apex court, the reported judgment.
Till
All
the appeal
executions
period,
should come to an end.
Till the appeal period, my lord, some protection may be given.
What
Till the appeal,
protection?
because heavy financial burden is involved. Suddenly, if they start doing the execution petitions, it will be very difficult, my lord.
You are for the appellant
Yes, my lord.
in these appeals.
Yes.
Why difficulty? You pay that money. No difficulty.
Not one case, my lord, hundreds of.
Hundreds of lands you have taken, hundreds of lands. When you have taken hundreds of payments, you have to make. The request for grant of any reprieve against the judgment pronounced today is rejected, since no ground is made out. Therefore,
With kind permission,
ah,
the serial number 32,
32,
where additional chief secretary is present before this honorable court, madam. My request to
Principal Secretary,
additional chief secretary, madam.
Chief Secretary,
Please.
for being spoken to matter.
No, that is the payment of the compensation.
Payment,
Please,
yes.
sir is present.
Yes. Yes, Mr. Chief Secretary, what you want to say? At least we'll understand what has happened. Let people know. Let people know.
Yes.
You have acquired land.
Yes.
And compensation as per the award appears to have been paid. Then enhancement was sought for, and the jurisdictional court has granted the enhancement. Then they have been challenged before us. We gave conditional order. We means other coordinate benches, we also. Conditional order to the effect that 50% of the amount should be deposited in the court. That has not been done. We had two options. Number one, to say that the stay stands vacated in our special jurisdiction. The other was that hereafter we shall not entertain appeals of the government, because government is not judiciary. Government is not respecting the judiciary. We are all branches of the state, and our job is complementary to each other. Right from the days of Ram Javaya Kapoor versus state of Punjab, each organ has to do its job not in competition, but in a very complementary way. We have been doing. When you had taken reprieve or some relief at the hands of the court as a litigant, are you not supposed to follow the orders of the court? You mean state? Yes.
Sir, first of all, sir, let me appreciate the concern of the court. And as you have pointed out, sir, this is a very, very important matter. And at the first opportunity, I have made myself available here. And before coming here, I have had number of discussions with learned advocate general and with other advocates related to the case. And also, I have consulted the honorable ministers and the chief minister also. So, sir, just to give you a small perspective of the case, sir. Sir, the Upper Krishna project nalli, sir, normally it's a project which has been there, which was sanctioned in 2012, sir. 2012 nalli.
ಕನ್ನಡದಲ್ಲೇ ಹೇಳ್ಬಿಡಿ, ಎಲ್ಲ ರೈತರಿಗೆಲ್ಲ ಗೊತ್ತಾಗ್ಲಿ. ಯಾಕೆಂದ್ರೆ ನಮ್ಗೆ ಇದ್ರಲ್ಲಿ ಕನ್ಸರ್ನ್ ಇದೆ. ರೈತರ ಲ್ಯಾಂಡ್ ಅನ್ನ ನೀವು ತೆಗೆದುಕೊಂಡಿದ್ದೀರಿ, ರೈತರಿಗೆ ನೀವು ಕಾಂಪನ್ಸೇಷನ್ ಅನ್ನು ಕೊಡಲೇಬೇಕು ಅಂತ
ಹೇಳ್ತೀನಿ ಸರ್, ನಾನು ಹೇಳ್ತೀನಿ.
ಮ್ಯಾಂಡೇಟ್.
ನಾನು ಹೇಳ್ತೀನಿ.
ಹಾಗಾಗಿ ಎಲ್ಲರಿಗೂ ಗೊತ್ತಾಗ್ಲಿ.
ನಾನು ಹೇಳ್ತೀನಿ ಸರ್. ಸರ್, ಈ ಪ್ರಾಜೆಕ್ಟ್ 2012ರಲ್ಲಿ ಸರ್ ಇದನ್ನ ಅನುಮೋದನೆ ಮಾಡಲಾಗಿತ್ತು ಸರ್. 2012 ಇಸ್ವಿನಲ್ಲಿ ಅನುಮೋದನೆ ಮಾಡ್ತಿರುವಾಗ ಸರ್ 51,148 ಕೋಟಿ ರೂಪಾಯಿದ ಒಂದು ಯೋಜನೆಯನ್ನು ಸರ್ಕಾರ ಅನುಮೋದನೆ ಕೊಟ್ಟಿತ್ತು. ಸರ್,
ಕಾಪಿ ಇದೆಯಾ ನೋಟದ್ದು, so that we can also see the notice.
Sir, I am referring to small things from different places. I am not reading, sir. I am not reading. ಸರ್ 51,000 ರಫ್ಲಿ ಹೇಳೋದಾದ್ರೆ ಸರ್ 51,000 ಕೋಟಿ ರೂಪಾಯಿದು ಒಂದು ಪ್ರಾಜೆಕ್ಟ್ ಸರ್, ಅದು ಅನುಮೋದನೆ ಮಾಡಲಾಗಿತ್ತು ಸರ್. ಸೊ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸರ್, ದಿಸ್ ಪ್ರಾಜೆಕ್ಟ್ ಇಸ್ ಎನ್ವಿಸಾಜ್ಡ್ ಫಾರ್ ದ ಪರ್ಪಸ್ ಆಫ್ ಕೃಷ್ಣಾ ವಾಟರ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಟ್ರಿಬ್ಯುನಲ್ 2. The second award which said that the Karnataka can utilize more waters. 907 TMC.
173 additional.
Yeah. So other ಬಗ್ಗೆ sir details ಇರುತ್ತೆ sir. But overall speaking sir, ಅದು ಆಲಮಟ್ಟಿ ಜಲಾಶಯದಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು 519.60 ಲೆವೆಲ್ ಏನಿದೆ, ಅದನ್ನು 524.256 ಮೀಟರ್ಗೆ ನಾವು ಏರಿಸಬೇಕು ಅಂತದ್ದು ಇದರಲ್ಲಿ ಮೂಲಭೂತವಾಗಿರ್ತಕ್ಕಂಥದ್ದು ವಿಷಯ ಆಗಿದೆ ಸರ್. ಸೊ ಈ ಲೆವೆಲ್ಸ್ ಅನ್ನು ರೇಸ್ ಮಾಡೋದಾದ್ರೆ ನಮ್ಗೆ ಸ್ವಲ್ಪ ಮುಳುಗಡೆ ಪ್ರದೇಶ ಸಬ್ಮರ್ಜೆನ್ಸ್ ಝೋನ್ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಆ ಸಬ್ಮರ್ಜೆನ್ಸ್ ಝೋನ್ ಅನ್ನು ಪರಿಗಣನೆ ಮಾಡಿ ತದನಂತರ ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್ ಮಾಡಬೇಕು. ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್ ಸೆಂಟರ್ ಸಲುವಾಗಿ ನಮ್ಗೆ ಜಮೀನ್ ಬೇಕಾಗೋದು, ಅದನ್ನು ಸೇರಿ ತದನಂತರ ಕೆನಾಲ್ಸ್ ಮತ್ತು ಬೇರೆ ಏನೇನೋ ಇದೆ ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್ ಸಲುವಾಗಿ ಬೇಕಾಗೋದು, ಅದೆಲ್ಲವೂ ಸೇರಿ ಸುಮಾರು 1,33,000 ಎಕರೆ ಜಮೀನನ್ನು ಅಕ್ವೈರ್ ಮಾಡುವಂತದ್ದು ಒಂದು ಪ್ರಸ್ತಾವನೆ ಇತ್ತು ಸರ್. ನಮ್ಗೆ ಕಾಮಗಾರಿಗಳಿಗೆ ಬೇಕಾಗಿರ್ತಕ್ಕಂಥದ್ದು ಫಾರ್ ಸಿವಿಲ್ ವರ್ಕ್ಸ್. ಇದಲ್ಲದೆ ಸುಮಾರು 30,000 ಕೋಟಿ ನಮ್ಗೆ ಬೇಕಾಗಿರ್ತಕ್ಕಂಥದ್ದು ಫಾರ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಅಂಡ್ ಫಾರ್ ರಿಲೀಫ್ ಅಂಡ್ ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್. ಎಸ್. ಸೊ ಅಂದ್ರೆ ತಾವು ನೋಡ್ಬಹುದು ಸರ್ ದಟ್ ಇದರಲ್ಲಿ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಮತ್ತು ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್ಗೆ ಸಾಕಷ್ಟು ಮೊತ್ತವನ್ನು ಇಡಲಾಗಿದೆ ಮತ್ತು ಅದನ್ನು ತೆಗೆದುಕೊಳ್ಳುವಂತದ್ದು ಒಂದು ಇಟ್ ಇಸ್ ಒನ್ ಆಫ್ ದಿ ಫೌಂಡಿಂಗ್ ಪಿಲ್ಲರ್ಸ್ ಆಫ್ ದಿ ಎಂಟೈರ್ ಪ್ರಾಜೆಕ್ಟ್ ಇಟ್ ಸೆಲ್ಫ್. ಸರ್ $75,000 acres ನಲ್ಲಿ ಇದುವರೆಗೆ ಅಕ್ವೈರ್ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು ತುಂಬಾ ಕಡಿಮೆ ಇದೆ ಸರ್, 2,500 ಮಾತ್ರ. ಎರಡನೇದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಈ ನಮ್ಗೆ ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್ ಸೆಂಟರ್ ಸಲುವಾಗಿ ಬೇಕಾಗಿರ್ತಕ್ಕಂಥದ್ದು ಸರ್, ಅದರಲ್ಲಿ ವಿ ಹ್ಯಾವ್ ಅಕ್ವೈರ್ಡ್ ಸೊ ಇದರಲ್ಲಿ 6,400 ಎಕರೆ ಬೇಕಾಗಿತ್ತು. ಅದರಲ್ಲಿ 3,400 ಎಕರೆ ಸುಮಾರಷ್ಟು ನಾವು ಇದು ಅಕ್ವೈರ್ ಮಾಡಿದ್ವಿ. ಅಬೌಟ್ 50% ಅಕ್ವೈರ್ ಆಗಿದೆ ಅಂತ ನಾವು ಹೇಳ್ಬಹುದು ಸರ್. ಅಂಡ್ ಉಳಿದೆಲ್ಲ ಸರ್ ಕೆನಾಲ್ಸ್ ಮತ್ತು ಈ ಸಿವಿಲ್ ವರ್ಕ್ಸ್ ಸಲುವಾಗಿ ನಮ್ಗೆ 55,000 ಪೈಕಿ ಸುಮಾರು 23,000 ದಷ್ಟು ಅಕ್ವೈರ್ ಮಾಡಲಾಗಿದೆ. ಐ ಆಮ್ ಟೆಲಿಂಗ್ ಯು ಅಪ್ರಾಕ್ಸಿಮೇಟ್ ನಂಬರ್ ಸರ್.
ಅಪ್ರಾಕ್ಸಿಮೇಟ್.
ಹಾ 55,000 ಪೈಕಿ 23,000 ಎಕರೆ ಅಕ್ವೈರ್ ಮಾಡಲಾಗಿದೆ ಸರ್. ನಾವು ತಾವು ನೋಡ್ಬೋದು ಸರ್, ಇದರಲ್ಲಿ ಸಬ್ಮರ್ಜೆನ್ಸ್ ಝೋನ್ ನಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು ಇದುವರೆಗೆ ಅಕ್ವೈರ್ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು ತುಂಬಾ ಕಡಿಮೆ ಇದೆ.
ಎಸ್ ಸರ್.
ನಾವು ಈ ಸಬ್ಮರ್ಜೆನ್ಸ್ ಝೋನ್ ನಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು 20 ಹಳ್ಳಿಗಳು ಹೋಗೋದು. ಈ 20 ಹಳ್ಳಿಗಳು ಅಲ್ಲದೆ ಕೆಲವು ಗ್ರಾಮಗಳ ಒಂದು ಜಮೀನ್ ಹೋಗುತ್ತೆ, ಅಂದ್ರೆ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ಸ್ ಹೋಗುತ್ತೆ. ಅದು 100ಕ್ಕಿಂತ ಹೆಚ್ಚಿದೆ, 188 ಅಂತ ಹೇಳ್ತಾರೆ, ಬಟ್ ಅದಿದೆ ಸರ್. ಸೊ ಒಟ್ಟಾರೆ ಇದಕ್ಕೆ ಸಬ್ಮರ್ಜೆನ್ಸ್ ಝೋನ್ ನಲ್ಲಿ ಯಾರನ್ನು ನಾವು ವಿಸ್ಥಾಪನೆ ಮಾಡ್ತೀವಿ, ಆ ವಿಸ್ಥಾಪನೆ ಮಾಡತಕ್ಕಂಥ ವ್ಯಕ್ತಿಗಳಿಗೆ ಪ್ರತ್ಯೇಕ ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್ ಸೆಂಟರ್ಸ್ ಮಾಡ್ತಕ್ಕಂಥದ್ದು ಒಂದು ಇದರಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಪ್ರಮೇಯ, ಬೇಸಿಕ್ ವಿಷಯ. ಆ ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್ ಸೆಂಟರ್ ಸುಮಾರು 24 ಸೆಂಟರ್ಸ್ ಸ್ಥಾಪನೆ ಮಾಡ್ತಕ್ಕಂಥದ್ದು ಇತ್ತು ಸರ್. 24 ಸೆಂಟರ್ಸ್ ನಲ್ಲಿ ಒಂದು ಈ ಇವತ್ತು ತಾವು ಏನು ಕೇಳ್ತಾ ಇದ್ದೀರಿ ಸರ್, ಅದರ ಬಗ್ಗೆ ಇರ್ತಕ್ಕಂಥದ್ದು ವಿಷಯ ಅಂದ್ರೆ ಜುಂಜೂರುಕೊಪ್ಪ ಅಂತ ಹೇಳಿ ಒಂದು ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್ ಸೆಂಟರ್ಗೆ ಸಂಬಂಧಪಟ್ಟದ ವಿಷಯ. ನಾವು ಸರ್ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸರ್, ಸರ್ಕಾರ ಇದಕ್ಕೆ ಅಕ್ವಿಷನ್ ಸಲುವಾಗಿ ಮತ್ತು ಪ್ರಾಜೆಕ್ಟ್ ಸಲುವಾಗಿ ಸಿವಿಲ್ ವರ್ಕ್ ಸಲುವಾಗಿ ದುಡ್ಡು ಕೊಡ್ತಾ ಇದೆ ಸರ್. ದಟ್ ಇಸ್ ಕಮಿಂಗ್ ಫ್ರಮ್ ದ ಬಜೆಟರಿ ಅಲೋಕೇಶನ್ ಆಫ್ ದಿ ಸ್ಟೇಟ್. ನಾವು ಸರ್ ಇದರಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು ನಾವು ಏನು ಅಪೇಕ್ಷೆ ಮಾಡ್ತೀವಿ ಸರ್, ಈ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಪ್ರಾಸೆಸ್ ಏನಿದೆ, ಹೊಸದಾಗಿ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಆಕ್ಟ್ ಏನ್ ಬಂದಿದೆ ಅದರಲ್ಲಿ ಒಂದು ವಿಧಾನ ಇದೆ ಸರ್. ಆ ಪ್ರಕಾರ ಒಂದು ರೀಸನಬಲ್ ಆಗಿರ್ತಕ್ಕಂಥ ಫೇರ್ ಕಂಪನ್ಸೇಷನ್ ಅನ್ನು ಕೊಡಬೇಕು. ಆ ಫೇರ್ ಕಂಪನ್ಸೇಷನ್ ಕೊಟ್ರೆ ಯಾರಿಗೂ ಅನಾನುಕೂಲ ಆಗೋದಿಲ್ಲ, ಸರ್ಕಾರಕ್ಕೂ ಕೂಡ, and this also. And as you know sir, the entire project is basically for welfare of the people of North Karnataka. ನಾರ್ತ್ ಕರ್ನಾಟಕನಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ರೈತರಿಗೆ ಇದರಿಂದ ನೀರಾವರಿ ಸಿಗುತ್ತೆ, ನೀರನ್ನು ಬಳಕೆ ಆಗುತ್ತೆ. 10 lakh acresಗೆ ನೀರಾವರಿ ಸಿಗುತ್ತೆ ಅಂತ ಹೇಳಿ ಕೂಡ ಒಂದು ಹೇಳಲಾಗಿದೆ ಸರ್. 10 ಲಕ್ಷ ಎಕರೆಗೆ. ನಿನ್ನೆ ನಾನು ತುಂಗಭದ್ರಾ ಡ್ಯಾಮ್ ನಲ್ಲಿ ಇದ್ದೆ ಸರ್. ತುಂಗಭದ್ರಾ ಡ್ಯಾಮ್ ನಲ್ಲಿ ಒಂದು ಸಣ್ಣ ಗೇಟಿನ ಸಮಸ್ಯೆ ಆಗಿತ್ತು. ಅಲ್ಲಿ ಕೂಡ 9 ಲಕ್ಷ ಎಕರೆಗೆ ನೀರಾವರಿ ಕೊಡ್ತಕ್ಕಂಥದ್ದು ತುಂಗಭದ್ರಾ ಡ್ಯಾಮ್ ನಲ್ಲಿ ಆಗಿದೆ. ಅಪರ್ ಕೃಷ್ಣ ಪ್ರಾಜೆಕ್ಟ್ ನಲ್ಲಿ ಇದಕ್ಕಂತೂ ಹೆಚ್ಚು ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ ನಾವು ಭಾವನೆ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ. ಆ ಉದ್ದೇಶದಿಂದ this very ambitious project has been taken up sir, and it has been taken up at the government level, and if very high award amounts are fixed sir, this would basically derail the entire project. ಯಾಕಂದ್ರೆ ಈಗ 20-30 ಸಾವಿರ ಕೋಟಿ ನಾವು ಏನು ಎಣ್ಕೊಂಡಿದೀವಿ ಸರ್, ಒಂದು ವೇಳೆ ಅದು 1 ಲಕ್ಷ ಕೋಟಿ 2 ಲಕ್ಷ ಕೋಟಿಗೆ ಆಗೋದಾದ್ರೆ the entire project will have to be revisited, because then people are more interested in only taking compensation and not facilitating the completion of the project itself. So sir, just to come back sir, ಈಗ submergence zone ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು ಏನಾಗಿದೆ, ಒಂದು ಹಳ್ಳಿ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು ಮಾಚನೂರು. ಆ ಮಾಚನೂರು ಹಳ್ಳಿಗೆ ನಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು 77,640 ಚದರ ಮೀಟರ್, 77,640 ಸ್ಕ್ವೇರ್ ಮೀಟರ್ ಪ್ರದೇಶ ಎಂದೇ ಅದು ಅಷ್ಟು ಮುಳುಗಡೆ ಆಗಿರ್ತಕ್ಕಂಥ ಪ್ರದೇಶ. ಸೊ ಅಷ್ಟು ಅಂದ್ರೆ ಅದು that will roughly come to around 15 acres or so. ಆ 15 ಎಕರೆ ಜಮೀನ್ ಏನ್ ಮುಳುಗಡೆ ಆಗುತ್ತೆ ಅದರಲ್ಲಿ ಆಗಿರ್ತಕ್ಕಂಥ ವಿಸ್ಥಾಪನೆ ಸಲುವಾಗಿ ಈ ಜುಂಜೂರ್ಕೊಪ್ಪದಲ್ಲಿ ಒಂದು ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್ ಸೆಂಟರ್ ಅನ್ನು ಸ್ಥಾಪನೆ ಮಾಡ್ತಕ್ಕಂಥದ್ದು ಆಗಿದೆ ಸರ್. ಈ ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್ ಸೆಂಟರ್ ಸಲುವಾಗಿ 270 ಎಕರೆ ಅಂದ್ರೆ 15 ಎಕರೆನಲ್ಲೂ ನಾವು ವಿಸ್ಥಾಪನೆ ಮಾಡ್ತೀವಿ, ಆದ್ರೆ ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್ ಸೆಂಟರ್ ನಲ್ಲಿ ಬಹಳ ಲಿಬರಲ್ ಆಗಿ ಅದನ್ನು 270 ಎಕರೆ ನಾವು ಜಮೀನನ್ನು ಅಕ್ವೈರ್ ಮಾಡಕ್ಕೆ ಹೊರಟಿದೀವಿ ಸರ್. ಇದರಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸರ್, ಈ ಜುಂಜೂರ್ಕೊಪ್ಪ ವಿಲೇಜ್ ಏನಾಗಿದೆ ಇದನ್ನು ಆಯ್ಕೆ ಮಾಡಿರ್ತಕ್ಕಂಥದ್ದು ಗ್ರಾಮ ಸಭೆ. ಆ ಗ್ರಾಮ ಸಭೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಎಲ್ಲಿ ನಾವು ಗುರುತು ಮಾಡ್ಬೇಕು.
Now we shall put ourselves in focus.
ಸರ್ ನಾನು ಬರ್ತೀನಿ ಸರ್, ವಿಷಯಕ್ಕೆ ಬರ್ತೀನಿ ಸರ್.
Our question is,
sir,
you have taken an order.
Sir.
We said you should make 50% payment.
Sir.
On that we are.
Sir. Sir, lordships may kindly say, sir, the basic fallacy which has happened, sir, perhaps inadvertently, sir, yenagide, sir, the rates which were for 30-40 plot of land, sir, house site kind of land, sir, that also may be at high because of whatever reason, sir, because they had the prior knowledge of the acquisition, etc. ಅದನ್ನು ಎಕ್ಸ್ಟ್ರಾಪೋಲೇಟ್ ಮಾಡಿ ಏಕರ್ಸ್ ಕಟ್ಲೆಗೆ ಜಮೀನ್ಗೆ ನಾವು ಅದನ್ನು ಎಕ್ಸ್ಟ್ರಾಪೋಲೇಟ್ ಮಾಡಿ ಕೊಡ್ತಾ ಇದೀವಿ ಸರ್. ಅದಕ್ಕೆ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಇಲ್ಲಿ 1 ಕೋಟಿ 2 ಕೋಟಿ 4-5 ಕೋಟಿ ತನಕ ಒಂದು ಎಕರೆಗೆ ಹೋಗ್ತಕ್ಕಂಥದ್ದು ಈ ಪ್ರದೇಶದಲ್ಲಿ ಆಗ್ತಾ ಇದೆ ಸರ್. ನಾವು ಈಗ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಸರ್, ನಾವು ಒಂದು ನಿರ್ಣಯವನ್ನು ತೆಗೆದುಕೊಳ್ಳಲಾಗಿದೆ ಸರ್. ಇದು ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿ ಅವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಒಂದು ಕರ್ನಾಟಕ KBJNL ಕರ್ನಾಟಕ ಭಾಗ್ಯ ಜಲ್ ನಿಗಮ್ ಬೋರ್ಡ್ ನಲ್ಲಿ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು ಏನಾಗಿದೆ ಅಂದ್ರೆ that we will, rather than taking up the acquisition of all this 133 acres of land, 133,000 acres of land in one go, 519.60 meter ಇಂದ 522 meters ತನಕ ಮುಳುಗಡೆ ಹೊಂದುವ ಪ್ರದೇಶಗಳಿಗೆ ನಾವು ಮೊದಲೇ ಹಂತದಲ್ಲಿ ಮತ್ತು ತದನಂತರ 522 ಇಂದ 524.256 ಮೀಟರ್ ವರೆಗೆ ಇರ್ತಕ್ಕಂಥ ಮುಳುಗಡೆ ಪ್ರದೇಶ ಏನಿದೆ ಅದಕ್ಕೆ ಪ್ರತ್ಯೇಕವಾಗಿ ಅಂದ್ರೆ 2 ಹಂತದಲ್ಲಿ ಅದನ್ನು ಅಕ್ವೈರ್ ಮಾಡಕ್ಕೆ ಹೊರಡ್ತೀವಿ ಸರ್. ಸೊ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಈ ಮಾಚನೂರ್ ವಿಲೇಜು ಏನಾಗಿದೆ 524 ಮೀಟರ್ ಹತ್ತಿರ ಇರ್ತಕ್ಕಂಥದ್ದು, ಅಂದ್ರೆ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಜಮೀನು ಒಂದು ನಾವು ಅಕ್ವೈರ್ ಮಾಡಿರೋದಿಲ್ಲ ಸರ್. ಮಾಚನೂರ್ ನಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಜಮೀನನ್ನು ನಾವು ಅಕ್ವೈರ್ ಮಾಡಿರೋದಿಲ್ಲ. ಅದು 524 ಮೀಟರ್ ಅಂದ್ರೆ ಸೆಕೆಂಡ್ ಫೇಸ್ ನಲ್ಲಿ ಬರುತ್ತೆ. ಆದ್ರೆ ಇನ್ ಆಂಟಿಸಿಪೇಷನ್ ಅದಕ್ಕೆ ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್ ಸೆಂಟರ್ ಅನ್ನು ನಾವು ತಯಾರು ಮಾಡಕ್ಕೆ ಹೊರಟಿದೀವಿ ಸರ್. ಆ ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್ ಸೆಂಟರ್ಸ್ ನಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ 200 ಎಕರೆ ಜಮೀನ್ ಏನಿದೆ ಅದನ್ನ ನಾವು ತೆಗೆದುಕೊಳ್ತಾ ಇರುವಾಗ ಸರ್, ಅದರಲ್ಲಿ ಈ ತರದೊಂದು ನಮ್ಗೆ ಅವಾರ್ಡ್ಸ್ನ ಸಮಸ್ಯೆ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು ಸರ್. ಸೊ ನನ್ನ ಇಷ್ಟೇ ತಮ್ಮಲ್ಲಿ ಕೋರಿಕೆ, ತಮ್ಮ ಮುಂದೆ ನಾವು ಏನು ರಿಕ್ವೆಸ್ಟ್ ಅಥವಾ ಅಪೀಲ್ ಅನ್ನು ಮಾಡ್ತಾ ಇದ್ದೀವಿ ಸರ್. The submergence area has not been acquired as yet.
Not yet acquired.
Not yet acquired. No,
Whether those cases are here?
no
They are
sir.
not
No
here.
sir. No sir. It is the acquisition process ಏನಿದೆ ಅದನ್ನು ರೆಫರೆನ್ಸ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಅಥವಾ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಆಫೀಸರ್ ಮಟ್ಟದಲ್ಲಿಯೂ ಕೂಡ ಅದನ್ನು ಮುಕ್ತಾಯ ಆಗ್ಲಿಲ್ಲ ಸರ್.
Hello, we are asking you whether in any of these appeals, have we anything to do with this land?
No sir.
Believe it.
ನೋ ಸರ್. ಸಬ್ಮರ್ಜೆನ್ಸ್ ಝೋನ್ ನಲ್ಲಿ ಸರ್ ಜಮೀನ್ ಅಕ್ವೈರ್ ಆಗಿರುವುದಿಲ್ಲ. ಮತ್ತು ನಾನು ಹೇಳಿದಾಗೆ ಸರ್ ನಿರ್ಣಯ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅದು 2 ಹಂತದಲ್ಲಿ ಮಾಡುವಾಗ ಬಹುಶಃ ಈ ಜಮೀನು ಮಾಚನೂರ್ ಹಲ್ಲಿನಲ್ಲಿ ಅಕ್ವೈರ್ ಮಾಡಕ್ಕೂ ಕೂಡ ನಾವು ಹೋಗೋದಿಲ್ಲ. ಯಾಕೆಂದ್ರೆ ವಿ ಹ್ಯಾವ್ ಟು ಅಪ್ರೇಸ್ ದ ಪ್ರಾಜೆಕ್ಟ್ ಕೀಪಿಂಗ್ ಇನ್ ಮೈಂಡ್ ದ.
ಅದನ್ನೆಲ್ಲ ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ದೀರಿ ನಮಗೆ ಏನು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
Only one submission.
Why all this is being told to us? We are not the government.
Intention is, my lord.
We are-
Which your lordships can do, my lords.
Yes, Mr. Advocate General.
I'm sorry, my lord, I was listening because he was making his submissions. I understand what your lordships are focusing on is there's an interim order passed by this court. Why the orders of this court are not being followed? Anta tav keltara.
And if government does not obey the orders, who should obey? How you can tell the subjects you obey? Unless Raja Pratyaksha Devata is all right. Yatha Raja Tatha Praja. If you do not follow, they will say, well, government is not following. Why you expect the subjects to follow the law, follow the court orders? Where do you stand?
Please, my lord, just answering only that, focusing only on that aspect and finding a solution to that aspect, my lord. Can I
Hello,
make
one nimisha. We have spent a lot of time now.
Yes, ma'am.
That's nice that you are here. Your honorable secretary is here.
No, I thought
good.
No,
We are
in fact,
asking
my lord, we have been
simple
working on this.
Very simple question. We are not that intelligent. Only we say from whatever we have read. You have taken land. True?
Correct, ma'am. Preliminary notification issued, final notification is issued. Award is passed, possession not taken, my lord, but we have acquired the land as on today.
You are entitled to take possession.
Please, my lord.
Now, as the law now stands, the lands have vested in the state.
No, my lord, vested is not, only after 16/2 is vested, my lord. As of now, it is not vested, they are cultivating the land on facts, my lord. So that is apart, my lord, as the lordship pointed, interim order has to be complied. I'm not arguing on that at all. I'm not saying.
Of the court should be complied with.
I'm coming to that, my lord. I bow down to what your lordships are saying, my lord. The only thing, my lord, can just one submission, the reference order, the award was passed for 5,44,000, my lords. And the reference court has passed an enhanced the compensation to 2.13 crores, my lords. From 5,44,000 to 2.13 crores, my lords. Based on just, I'm not going to the merit, just for your lordship's reference for 2 minutes, I'll take, my lord. Based on 9 sale deeds, my lords, which is subsequent to coming to know, and out of which 6 are agreement to sell, 2 are of plots. After coming to know, the land was thought to be acquired. So they came to know the land was thought to be acquired on 18 June 2013. The whole basis of the judgment is based on subsequent transactions, my lords. Our submission is, my lords, in fact, in the Gram Sabha, the amount which is sought to be relied documents is very, very high, my lords, which will on merits will be able to show. Now, what your lordships are saying, we have to, pending that we have obtained an interim order, out of which we have complied in more 50 cases, we have complied with the interim order, my lords. In some of them, there is no interim order. Few of them there are, which 4 of the cases before your lordships there are interim orders, we have not complied, my lords.
One second. In how many cases you say from 5,43,000 to 2.13 crore? In how many cases it has happened?
My lord, based only on one LAC order, all the cases have been passed. No material at all, my lord. Based on LAC number 8.
How many cases it has happened, Mr.
Out of 50 mile.
613.
In all the cases, same amount.
In all the cases,
630.
Same amount is
The 2 crore.
2.13 crore.
Yes, 5 to 2 crore, which is the land, lot which LAC 865, which they are referring,
Yes.
which has been deposited and they are permitted to withdraw.
One second.
They have approached directly to them, we have
I'll
approached.
just
the court.
clarify, Malad. I'll just,
Please,
It's a difference.
We have filed an.
Perhaps your secretary wants to say something.
No, Lordships, I would only like to say that we have been trying to acquire through a consent awards. And wherever consent awards is there, the kind of
No issue.
mischief, etc., does not happen. It may be from maybe lapse on our end or at some other level. And LLE, sir, interim awards agide, we will undertake to pay, sir. We will undertake to pay all cases wherever contempt is not there. Also, we'll undertake to pay. But however, the pleading before your lordships is that let us fix it at 10% of all the interim awards. Why? Because the interim award itself is the rate fixed are so exorbitant that they are much beyond the real value of the lands.
Mr. Advocate General,
Yes,
your Chief Secretary is saying, let it be reduced to 10%.
please.
So that it would do justice to both the sides. And in the meanwhile, main matter itself can be taken up for consideration.
Please, Malad. In fact, I suggested we are going to deposit, it comes up to, we have already deposited 400 and odd crores, Malad. We are depositing another 70 crores before your lordship, Malad. So that, Malad, let the matter be adjudicated, Malad. If you are liable to pay, we will definitely pay, Malad.
Bali, instead of 10%, 10% will be very frugal. It is not that amount is being released to the land losers. Let that, and for that there is a method. Why are you asking? Nam ಒಂದೇ ಪ್ರಶ್ನೆ. ಈ ರೈತರಿಗೆ ಲ್ಯಾಂಡ್ ಕಸ್ಕೊಂಡ ನಂತರ ನಾವು ಅವ್ರಿಗೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ಲಿದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? Just
I understand. For one site ಹೋದ್ರು ನಮ್ಗೆ ಎಷ್ಟು ಹಾರ್ಡ್ ಬರ್ನ್ ಅಂತ ಗೊತ್ತು ಅಲ್ವಾ? These are agriculture. I understand. I'm not on. My only thing is, as a secretary, it should be just, my lord, because the project is also.
We agree. We agree.
We are only on that.
We are, Mr. Advocate General. It was in your appeal after hearing that we made the order.
Yes, I understand.
It is not that we have made the order ex parte and you happen to be a respondent.
Yes, sir.
It is in your appeals.
I understand. I have no argument on that at all, my lord.
Number one.
And we have woken up only after you lordships gave.
Number two, will not say much now, but you should understand the difficulty of the farmers.
I understand.
ರೈತರಿಗೆ ತುಂಬಾ ತೊಂದರೆ ಇರ್ತದೆ. ಆಮೇಲೆ ನೀವು ಮೇನ್ ಮ್ಯಾಟರ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ. ಆದ್ರೆ ಆರ್ಡರ್ಸ್ ಆಫ್ ದ ಕೋರ್ಟ್ ಅನ್ನ ಯಾಕೆ ಒಬೇ ಮಾಡಲ್ಲ?
My lord, we are at your lordships and
not only this order, not only this order,
any order.
Much of our time is spent in contempt jurisdiction. Why you give that effort, the scope for that? Why can't you
mention
obey the
here
order
one,
unless that is stayed by some higher court?
No, your lordships, you are absolutely ತಾವು ಏನು ಹೇಳ್ತಿದ್ದೀರಿ that 100% ನಮಗೆ ಮಾನ್ಯ ಇದೆ, and we have highest regards for the majesty of the court, and we always implement the orders of the court. The only difficulty what has happened is ಇಲ್ಲಿ rates ಎಷ್ಟು ಜಾಸ್ತಿ ಆಗಿದೆ ಅಂದ್ರೆ it will.
You have said that. We have understood.
With only one kind.
My lord, one submission, my lord, here.
For the 2 minutes for the perusal. This is, we filed an IFR modification and that small chart pertaining to the 4 cases we have filed. Kindly see that chart. For a moment, that document number 3, page 76, this is a contempt petition number we have. Contempt petition number, concerned LAC number, survey number, the place we have mentioned. Kindly come to that row number 7, that is award of the SLO. In the first case, it is he has awarded 2,51,000.
Correct.
He has awarded on the basis of this is agriculture land. Kindly come to the next entry, that is on the column number 9.
2,13,34,700
per acre. Kindly mark this per acre. So like this, it has been done. The major problem in all these cases, this is an land acquisition initiated under section 2013 Act.
Just percent escalation.
Idu 100% ಆಗುತ್ತೆ ಸ್ವಾಮಿ.
100% ಅಲ್ಲ, 100 times.
100 times, sorry, 100 times. One reasons why it has been happened. The reason is that under the old act, my lord, there is no provision to determine the compensation. But now the section 26 is there. So section 26 guide the concerned LSLO to determine the compensation. My lord, as in today, my lord, there is no interpretation of section 26 either by the Supreme Court or any of the High Court. So because of that, my lord, because of the problem, in these cases, my lord, since the land is acquired for the purpose of the rehabilitation center, the court presumed that the land is any potential. Merely because of that land is acquired for the purpose of, that is the reason why, my lord, even if the payment.
Your learned advocate general is also here.
Please.
And secretary, it's a great thing that at least to the court's request,
No.
you have been here to explain what is what, although we may not agree completely with your explanation, how much it should be accepted, or always there are hyperbola, parabola, they operate even in court halls, is true. That cannot be discounted. Now, your secretary says 10%. 10% appears to be on a very lower side. So come out with some reasonable terms.
Let me make one request, Your Lordship. My lord, Your Lordship, will bow down to Your Lordship, my lord, any reasonable amount, because we don't want to haggle. My lord. Your Lordships are also interested in that state interest, public interest.
Well, Lordships, the land possession.
In this case, my lord, 10% amount to 7 crores.
70 crores.
10% comes to 70.
My kind submission.
70 crores.
In this case, Lordships, the land has not been taken possession. Furthermore, this land is not likely to be utilized because that village from where the people are going to be displaced, that also may not be there. So if the Lordship says we will drop the entire acquisition process, we'll drop the entire acquisition process.
Yes, kindly see page 108. The photos in the 108. Kindly see.
One more suggestion. Wherever land possession ನೀವು ತಗೊಳ್ತಾ ಇದ್ದೀರಿ ಅಲ್ಲಾದ್ರೂ ಪೇಮೆಂಟ್ ಮಾಡಬೇಕಾ?
ಅಲ್ಲ ಯಾವ್ದು ತಗೊಳ್ಳಲ್ಲ my lord, that is what the case. We don't want to take immediately because land is not required for some time, a couple of years also, my lord.
ಬಿಟ್ಟು ಹಾಕ್ಬಿಡಿ.
In fact, my lord, at the higher level, in fact,
Mr. Advocate General, you can't interdict alienation of the property. You will keep. There are cases on record of this court and on the record of the apex court which have come here also. For years you have not accomplished acquisition proceedings. You have notified, kept it under various legislations. It has happened under PDA Act,
KDB Act,
AIDB Act. It has happened under Urban Development Authorities Act 87.
Correct,
it has happened under House Sites Grant of House Sites Acquisition Act.
Correct.
There are some cases we have been seeing every day. You can't go on like that.
No, my lord, as your lordship rightly pointed, instead of deviating the whole thing, my lord, kindly, any reasonable amount, we are saying 10%, my lord. The reason is we'll argue the main matter or merits immediately after vacation.
Now they have come out with, there is some difficulty which the Honorable Learned Advocate General has said, Additional Advocate General said, Secretary himself is saying, why can't you be also walk a few miles that side?
One submission, kindly see the interim order passed by this court. The learned HGP has submitted that in connected matters, this court has stayed the judgment and award of the reference court subject to deposit of 50% of the award amount along with accrued interest, statutory deposit, etc. Taking note of that,
all they have been called. Now
one
they
thing,
have explained.
they have deposited the amount in most of the cases.
In many
and
cases
it is
they
withdrawn
have.
also.
But there are
Only
54 cases. Sorry, there are 54 cases as Advocate General has stated. Out of 54, 50 they have deposited, they have permitted to withdraw. They wanted to discriminate with these 4 persons because they have not approached us.
No.
Can you see
Approach them to seek early release. That way you are saying.
Let him file affidavit.
The whole entire application which they are now contending. Now,
let him file affidavit on that.
application, in entire application.
Let him file affidavit of
And
that action.
Yes,
Making
one more
allegation,
thing.
let him
You
file
paid.
affidavit.
You are paid.
They did not approach means they did not approach with a request to release it
To release.
early.
Out of
Nothing, no aspirations.
286 cases, interim order has been passed. Out of that, 50 cases, when the amount is available, we released it.
On what basis?
No. First come first basis,
How?
it has been released.
How that can?
Initially, it has been done. It is a mistake on our part. It is a mistake. I admit that it is a mistake on our part. If this mistake is continue, entire project of the UQP is never going to be completed.
But ಕೆಲವರಿಗೆ ಕೊಟ್ಟು ಕೆಲವರಿಗೆ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿ.
Well, if that is the reason, my lord, because of the exorbitant award, my lord, now the state is realized.
All right, ನಾವು ಒಂದು ಹೇಳ್ತಾ ಇದೀವಿ. ಇದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ. You
Please, my lord.
deposit, Mr. Advocate General.
We'll go by whatever your
20% deposit ಮಾಡಿ.
Lordships, my submission is where possession has not been taken, kindly accept 10% because we have not displaced people. And wherever, if suppose person has been displaced, we agree to your lordship.
ಅಲ್ಲಿ 25% ಮಾಡಿ. ಎಲ್ಲೆಲ್ಲಿ ಪೊಸಿಷನ್ ತಗೊಂಡಿರಿ 25%. ಎಲ್ಲೆಲ್ಲಿ ಪೊಸಿಷನ್ ತಗೊಂಡಿಲ್ಲ ಅಲ್ಲೇ 10%.
Again, it should not be lead to any
Here-
misconception.
They are depositing before the court.
Exponential increase. There is something what
Lord,
Secretary
one
said.
submission. They have to deposit before court. It is
No,
not the payment.
ನೋಡಿ,
So even
ಅದು
they
ಇಲ್ಲ,
are not ready to.
ಅದು ಇಲ್ದಂಗ್ ಮಾಡ್ಕೋಬಾರ್ದು ನಾವು. ನೀವು ಕಂಟೆಂಪ್ಟ್ ನಲ್ಲಿ ಇದ್ದೀರಿ. Contempt is any standard book on law of contempt would say it's a slippery jurisdiction. Who will slip when nobody knows.
No, even
Court itself is a matter of slippery
even in
jurisdiction.
compliance, there is a
One thing.
discrimination. Even in compliance of interim orders, there is a discrimination. That is the difference.
We'll come to that one. It is not that amount is, you see, we will,
withdraw.
or else you be ready to argue this matter.
We state want, my lord, state want early disposal because it's guide the entire nation also. Because section 26 is not interpreted by any of the high court. All this problem has come because of the interpretation of section 26.
The lordships
Today,
kindly,
your lordship has
ನಮಸ್ಕಾರ ಮಾಡೋಣ.
submission, my lord.
the interim orders which have been passed so far have not been finally adjudicated. None of these appeals have been taken up on merits. So only interim orders is giving so much of extra benefit to the people that they are not interested in pressing the matter at all. And they are allowed to withdraw. It is leading to travesty of justice.
ಈಗ 10% ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ do you allow them to withdraw? 10%? No, we are asking you. We do not know. We are just asking you. The escalation apparently going by our poor arithmetics, escalation is exponential. It's exponential. That being said, we feel ಈ 10% ಇದೆಯಲ್ಲ, ಈ 10% ಅನ್ನ ಕೊಡಬಹುದು ಅಂತ. What Mr. Advocate General, what do you say?
Well, I understand where your lordships are coming, but only thing tomorrow, if that is also set aside, some
Against
security or
guarantee,
some-
one more thing,
Please.
against guarantee.
Please, my lord, that would be subject to, I think that should be
Indemnity bond.
ಇದಕ್ಕೂ ಕೊಡ್ತೀವಲ್ಲ.
subject to guarantee, my lord.
ನೀವು ಗ್ಯಾರಂಟಿ ಕೊಡ್ತೀರಾ? ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಅಮೌಂಟ್ ಕೊಡ್ಸೋಣ.
It is indemnity bond.
ನಾಳೆ
We have
ನೀವು
to-
10%
we have to
ತೊಗೊಂಡು-
execute indemnity bond.
How? What we should do with the indemnity bond? You suppose you consume, you exhaust that money, where the government should go. That is the worry of the secretary.
So we will be
Secretary
more.
appears for all people of the state now. You hold brief only for few. Of course, your rights are your rights only.
If 25% is deposited, we are ready to give the guarantee for amount.
25% is.
25% ಗ್ಯಾರಂಟಿ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ ನಿಮ್ಗೆ, 10% ಕೊಡಕ್ಕಾಗಲ್ವಾ?
ಅಲ್ಲ 10% ಕೊಡ್ತೇವೆ.
ಕೊಡಿ,
But-
ಮುಂದೆ ನಿಮಿಷ ಕೊಡಿ. 10% ಕೊಟ್ಟ ತಕ್ಷಣ ನಾವು another 5 years ನಾವು ಇಟ್ಕೊಂಡು ಕೊಡಲ್ಲ. From 20, ಯಾವತ್ತು reopening is on 14th?
14th.
14th we are hearing these matters.
Please, my lord. We will be ready. We'll file a convenient compilation. We'll be ready for arguments, my lord.
Provided that you will deposit 10% wherever possession is not taken.
In terms of,
Please.
my lord,
And
again,
20% wherever possession is taken.
Please, my lord.
And
Please.
please, please.
Rest of the things
please,
to the
Please,
rest.
grateful. We are
We'll
very
be ready with
grateful.
the arguments
We are grateful.
on the
My
14th.
request would be kindly hear the main appeal on merits and club all the cases of one particular village because they have absolutely the same logic which has been applied, doctrine of
Provided-
parity or otherwise.
We'll do that. We'll
Abide
comply
by
with the lordship's
court
order.
order.
Yes, yes.
If you do not pay, then on that ground we will dismiss the.
We humbly comply with the orders of the.
Small.
We'll comply with your lordship's direction, my lord.
14th ಇಂದ we'll start hearing the matter.
Absolutely no problem.
We will be ready, my
In
lord.
the meanwhile 10% ಅವರು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ, ಆ 10% ಅಮೌಂಟ್ ತಗೊಳ್ಳಿ.
ಅಲ್ಲ, ಒಂದು ಸ್ಮಾಲ್ ಅವರು ಪೊಸಿಷನ್ ಎಲ್ಲೆಲ್ಲಿ ತಗೊಂಡಿಲ್ಲ, ಪೊಸಿಷನ್ ತಗೊಂಡಿದ್ದರಿಗೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಇಂಟ್ರೆಸ್ಟ್ ಬರೋದೇ ಪೊಸಿಷನ್ ತಗೊಂಡ್ರೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಕೊಡೋ ಪ್ರಶ್ನೆ ಬರಲ್ಲ.
ಅದು argue
ಅದಕ್ಕೆ ಫಾರ್ ದಟ್ ರೀಸನ್ ನಮ್ಗೆ ಅವಾರ್ಡ್ ಆಗಿ ನಾವು ತಗೊಂಡದಾದ್ಮೇಲೆ ಆ 10% ಕೊಡಲ್ಲ, ಬೇರೆಯವ್ರಿಗೆ 50% ಕೊಡ್ತೀವಿ ಅಂತ.
ನೀವು ಪೊಸಿಷನ್ ಕೊಟ್ಟಿರಾ, ಅದು ಬಿಡಿ, ಅದು ಆರ್ಗ್ಯೂ ಮಾಡಾಗಿದೆ. It is already argued. Don't repeat anything. We have that also in mind.
Yes, that is why what my request.
Any other
Lordships,
point?
you lordships
Any
are
other
taking-
point? Any other point?
We are at the
All
hands
right,
of you lordships.
you are only repeating.
No,
Let
no,
not
no,
help
no.
us.
We are at the hands of you lordships. Can
ಏನ್
you
ಬೇಡಪ್ಪ
consider-
ನೋಡ್ರಿ ನಾವೆಲ್ಲರೂ ಇನ್ ದ ಹ್ಯಾಂಡ್ಸ್ ಆಫ್ ಲಾ
No, but
ನಾವ್ ಇಲ್ಲಿದ್ದೀವಿ ನೀವಲ್ಲಿದ್ದೀರಿ ನಮ್ಗಿಂತ
No,
ಮೋರ್
no,
ಇಂಪಾರ್ಟೆಂಟ್ ನೀವೆಲ್ಲರೂ
Consider it that, Lord, you lordships, since you lordships are saying that.
ಬರ್ಕೊಳ್ಳಿ ಯು ಆರ್ ವೇಸ್ಟಿಂಗ್ ದ ಟೈಮ್ ಆಫ್ ದ ಕೋರ್ಟ್.
Lord, that should not be possession or with possession.
Modification. Science. These appeals call in question the order of the reference court, arguably enhancing the compensation. Please be seated. Please be seated. Kuthikadu. In multiples. First off, we had shown our red eyes to the acquiring agency stroke beneficiary of acquisition on the other day for not making deposit of 50% of the award amount as enhanced by the reference court in the appeals filed by the government or the agency concerned, laying a challenge thereto. First off, the several contempt proceedings have been filed on the ground that the interim stay was subject to the government stroke agency depositing 50% of the compensation amount as enhanced by the reference court. First off, whether such a contempt would lie or not is a matter of argument, and we will not say anything about that. First off, be that as it may. Next paragraph. On our request, the principal secretary, additional chief secretary, department so and so is before us, and he has explained in a greater detail than was required as to what all has happened in the matter. First off, he also said about the meetings having been held in the presence of Honorable the Chief Minister, the concerned minister and other stakeholders in the matter. First off, learned Advocate General also made submission drawing our attention as to the arguable unjustifiability of exponential enhancement of the compensation. First off, learned Additional Advocate General also passionately made his submission. First off, we have heard from the landlord's side as well. First off, truth lies. One second. The arguments appear to be bipolar. First off, truth lies somewhere in between. Maybe this side more or that side more. First off, that we can ascertain when the hearing of the main matter would take place, before long, as is agreed by both the sides. First off, next paragraph. Learned Advocate General, learned Additional Advocate General, and the learned Additional Chief Secretary, who is graciously present before us, submitted that the application seeking modification of the interim orders be favored. First off, that was vociferously resisted by the counsel representing the landlords. First off, they also raised an issue as to discriminatory treatment at the hands of the government, in the matter of releasing, depositing in the court and releasing the deposited amount of compensation in favor of some and not doing this in respect of others. First up, sometimes mistakes do occur, comma, is the explanation offered by the Additional Advocate General, and we to some extent agree with the same. Full stop. That is not the end of matter. Full stop. Next paragraph. Having heard all the stakeholders in the matter, we are of a considered opinion that the subject application supported by a narrative affidavit needs to be favored to a reasonable extent, and the requirement of depositing 50% of enhanced amount of compensation as done by the reference court below, comma, needs to be bit relaxed. First up, the Additional Chief Secretary said the reduction should be from 50% to 10%. And both the Advocate General and the Additional Advocate General echoed the same, giving some reasons, comma, not totally irrelevant to consideration. First up, they highlighted possession is a factor even in deciding what should be the amount to be deposited. First up, they said amount to be deposited may be a bit more when possession is already taken, and where possession has not been taken yet, comma, the reduction should be to 10%. First up. Next one. Having adverted to all the we are also mindful of the fact that the project was undertaken way back in the year 2012, comma, much time has run since then, as also much water under the bridges. First up, the escalation element is also kept in view. First up, in the above circumstances, we modify the interim orders granted by the court to the effect that instead of to the following effect. A, wherever possession has already been assumed pursuant to acquisition process, comma, the requirement of depositing 50% of the enhanced amount of compensation is relaxed and downsized to, and the amount is downsized to 20%, 25%. And of that, 10% release ಮಾಡೋಣ. 10% ಮಾಡ್ಬೋದಾ ಮಿಸ್ಟರ್ ಸೆಕ್ರೆಟರಿ? ಕೂತ್ಕೊಂಡು ಹೇಳಿ.
10% release ಮಾಡಬಹುದು against indemnity bond or some kind of guarantee.
Guarantee would be better, Manoj. Some guarantee, if it's given, that would be helpful, Manoj, by chance, because the amount, Manoj, is 100 times more, Manoj. And one other aspect, Manoj, there are 613 cases before your lordships. The award is based only on one reference order, Manoj. So there's no valuation of the property at all. Only on LAC number 860.
No, let us see.
I'm sorry on that. I'm not going on merit, Manoj. My apologies.
ಎಷ್ಟು ಅಮೌಂಟ್ ಈಗ ಎಷ್ಟು ಅಮೌಂಟ್ ಅನ್ನ ಅವ್ರಿಗೆ ಕೊಡಬೇಕು, ಮೊಡಾಲಿಟಿ ಏನು ಅಂತ ಹೇಳಿ, ಮತ್ತೆ ಅದ್ರ ಮೇಲೆ ಮತ್ತೆ ರೆಫರೆನ್ಸ್ ಕೋರ್ಟ್ನಲ್ಲಿ ಮತ್ತೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್, ಬೇರೆ ರೈತರು ಇದನ್ನ ಮಾಡ್ಕೊತ ಕೊಡಕ್ಕಾಗ್ತಾವ, ಹೊಲ ಉಳೋದೆಲ್ಲ ಬಿಟ್ಕೊಂಡು ಬೇರೆ ಕೋರ್ಟು ಅವ್ನ್ ಸೆಲ್.
Correct. ಅರ್ಥ ಆಯ್ತು ಮೇಡಮ್. Out of 25%, your lordship, 10% we will let them release against guarantee, Manoj, in so far as their possession has been taken.
Of this sum, semicolon, of this amount, 10% of the enhanced amount, bracketnally enhanced amount, of enhanced amount shall be released in favor of the land losers, against they executing indemnity stroke guarantee bonds,
Indemnity bonds.
indemnity bonds,
Yeah. Or indemnity is difficult to recover the money, Malad. That's the
guarantee.
problem.
ಹೆಂಗ್ ಮಾಡಿ ನಾಳೆಲ್ಲ ಮುಗಿಸಿ ಇಂಡಮ್ನಿಟಿ ಬಾಂಡ್ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ
Land,
we cannot do anything.
land will be there.
Huh?
Lands are there.
ಕರೆಕ್ಟ್ ಆ ಲ್ಯಾಂಡ್ಸ್
ಇವತ್ತು 25 ಲಕ್ಷಕ್ಕೂ ಬಾಳಲ್ಲ ಅದು. ಇವತ್ತೇ ಬಿಟ್ ಕೊಟ್ರೆ 25 ಲಕ್ಷಕ್ಕೂ ಬಾಳಲ್ಲ ಅದು land.
Land ಗೆ value
25 ಲಕ್ಷ. My lord, I told my lord, this land will be utilized in year 2050.
against the land losers against execution, due execution of execution and furnishment of the bond of guarantee. Sentence hang madidini no melinda. Wherever possession has not been taken, comma, the requirement of depositing the amount would be 10%. Even semicolon. Even this amount may also be withdrawn by the land losers, subject to the same condition as above, as stipulated above. Full stop. It is made clear. The amount to be deposited, the deposit of the amount shall be made. Yes, this tell martiri. Within how many days you are doing that?
Within 1 month. Within 4 weeks.
Last year, all contempts we are closing.
Within 4 weeks.
Within 4 weeks. All right. Within 4 weeks, within 5 weeks, within amount shall be deposited within 5 weeks. Within 5 weeks. Failing which, as is suggested by the additional chief secretary himself. Suppose if it is not done, your appeals will go.
Your Lordship may dismiss it, my lord. We will comply with it, my lord.
We will comply.
If you don't comply,
If you are complying, why are you afraid of our suggestion? Yes. Our suggestion, that will take, it will effectuate where you do not. And more often than not, you have not.
No, we undertake to comply with the orders of the court, and if the suggestion of honorable court is
Failing which the appellants are put to warning that the appeals would be treated as having been rejected. Yeah, in view of the above. Yes, Mr. AG.
we are sorry, my lord, to troubling your lordship for implement of the interim order, which is our duty to do it, my lord. I took stock of all the cases, my lord. I will see to that nothing happens. This such a situation
Now,
doesn't.
we are just thinking, amount deposit, government difficulty. It's not that we do not appreciate. These are all budgetary aspects. Huge project. Very, as the chief secretary, additional chief secretary said, it's a huge mega project it is. In the above circumstances, the contempt proceedings are liable to be and accordingly dropped. With the right of renewal of the same in the event there is non-compliance. Adnu idana plus appeal hogli. Erdu illi. Non-compliance by moving a simple memo. Full stop. Next paragraph. All the observations herein above made being relevant, being confined to disposal of these contempt proceedings shall not cast their light or shadow on the pending appeals, which shall be heard and decided on their intrinsic merits, provided the compliance is there. Compliance is there.
Deposit be made to before reference court.
The reference court.
The serial number 21 is another matter where you are not passed an award against the mandate of section 19. The the learned single judge has directed, my lord.
No, of course. We appreciate the assistance rendered by learned additional advocate general, additional advocate general, and the additional chief secretary who graciously came all the way from Bangalore to Dharwad to assist, to participate in the, to effectively participate in proceedings.
Again, we sincerely apologize to your lordships, my lords.
Please from pardon the next bench the argument ಮಾಡ್ಕೊಳ್ಳಿ.
Please, let's,
Please form.
And
They are very happy at least.
no, there are 613 cases.
We have shown the hands this side.
We respect and we express deep gratitude to the court, honorable court and lordships. You have saved this project, because if this project has to undertake all these lands acquisition at very high cost, it will by itself fail and it will derail the project. So ಇಷ್ಟು ಮಾಡಿದರಲ್ಲಿ ತಾವು ಸರ್ ಉತ್ತರ ಕರ್ನಾಟಕದಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ರೈತರ ಒಂದು ಕಲ್ಯಾಣಕ್ಕಾಗಿ ಇರ್ತಕ್ಕಂಥ ಈ ಪ್ರಾಜೆಕ್ಟ್ ಅನ್ನು ಉಳಿಸ್ಕೊಂಡಿದ್ದೀರಿ ಅಂತ ಹೇಳಿ ತಮ್ಮಲ್ಲಿ ನಾನು
ಕೇಳಬೇಕು. ಉತ್ತರ ಕರ್ನಾಟಕದ ಜನರಿಗೆ ಒಂದೆಲ್ಲೋ ಒಂದ್ ಕಡೆ ಮನಸ್ಸಿನಲ್ಲಿ ತಮಗೆ ಡಿಸ್ಕ್ರಿಮಿನೇಷನ್ ಆಗ್ತಾ ಇದೆ ಅನ್ನುವಂತ ಅದಕ್ಕೆ ಸ್ಕೋಪ್ ಕೊಡಬಾರ್ದು. ಅದು ನಿಜ ಸುಳ್ಳು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಬಟ್ ಅನೇಕ ಜನ ನಾವು ಪಾರ್ಕ್ ನಲ್ಲಿ ವಾಕ್ ಮಾಡುವಾಗ, ಹೊರಗಡೆ ಹೋದಾಗ, ಫಂಕ್ಷನ್ಗೆ ಹೋದಾಗ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಆ ತುಂಗಭದ್ರಾ ನದಿ ಆ ಕಡೆ ಹೋದಾಕ್ಷಣ ಸ್ವಲ್ಪ ಬೇರೆ ನಮ್ನಿ ಇರ್ತದೆ, ನಮಗ್ ಬೇರೆ ನಮ್ನಿ ಆಗ್ತಾ ಇದೆ ಅನ್ನೋ ಫೀಲಿಂಗ್ ಇದೆ. ಅದಕ್ಕೆ ಸ್ಕೋಪ್ ಕೊಡಬಾರ್ದು. ಇಡೀ ಸ್ಟೇಟ್ ಇದನ್ನ ಕರ್ನಾಟಕ ಗತ ವೈಭವ ಆಲೂರು ವೆಂಕಟರಾಯರು ಬರೆದಿದ್ದು, ಇದನ್ನ ಒಗ್ಗೂಡಿಸುವಾಗ ಎಷ್ಟು ಜನರು ಕಷ್ಟಪಟ್ಟಾರೆ. ಇದಕ್ಕೆಲ್ಲ ನಾವು ಆ ರೀತಿ ಒಂದಾಗಿರ್ಲಿಕ್ಕೆ ಏನೆಲ್ಲ ಬೇಕದನ್ನೆಲ್ಲ ಜನ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಸ್ವಲ್ಪ ಸರ್ಕಾರದ ಗಮನನೂ ಸ್ವಲ್ಪ ಆ ಕಡೆ ಹೋಗ್ಬೇಕು.
ಖಂಡಿತ
ಸ್ವಲ್ಪ ತುಂಗಭದ್ರಾ ಈ ಕಡೆ
ತಮ್ಮಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಅಭಿಪ್ರಾಯವನ್ನು ಮಾನ್ಯ ಸರ್ಕಾರಕ್ಕೆ
ಡಿ.ಎನ್. ನಂಜುಂಡಪ್ಪ ರಿಪೋರ್ಟ್ ಇದೆ. ಪ್ರೊಫೆಸರ್ ಡಾಕ್ಟರ್ ಡಿ.ಎನ್. ನಂಜುಂಡಪ್ಪ ಅವ್ರ ರಿಪೋರ್ಟ್ ಇದೆ. ನಾವೇನ್ ಹಂಗೆ ಹೇಳ್ತೀವಿ ಅಂತ ಇಟ್ಕೋಬೇಡಿ. ಸ್ವಲ್ಪ ಔಟ್ ಆಫ್ ದ ಕಂಟೆಕ್ಸ್ಟ್ ಆಗ್ತದೆ ನಮ್ಮ ಮಾತು, ಬಟ್ ನಾವು ಇದು ನಿಮ್ಗೆ ಅಲರ್ಟ್ ಮಾಡ್ಲೇಬೇಕಾಗ್ತದೆ. ಒಂದ್ ಸ್ವಲ್ಪ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಒಂದು ಅಂದ್ರೆ ಅವ್ರು ಅನ್ಕೊಳ್ಳೋದು ಎಲ್ಲೋ ಒಂದು
ಕರ್ನಾಟಕ ಮತ್ತು
ಫೀಲಿಂಗ್ ಇದೆ ಅವ್ರಿಗೆ. ಅದು ಸರಿ ತಪ್ಪು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಇದು ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ ನಮ್ಗೆ. ಬಟ್ ನೋಡಿ ಇದರಲ್ಲೇ ನೋಡ್ತಾ ಇದ್ದೀವಿ, ಇದೇ ರೀತಿ ಇದ್ದಂತಹ ಪ್ರಾಜೆಕ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ಗಳನ್ನ ನಾವು ಹ್ಯಾಂಡಲ್ ಮಾಡಿದ್ದೇವೆ
ಸರ್. ಉತ್ತರ ಕರ್ನಾಟಕ ಮತ್ತು ಕಲ್ಯಾಣ ಕರ್ನಾಟಕದಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಎಲ್ಲಾ ನೀರಾವರಿ ಪ್ರಾಜೆಕ್ಟ್ಸ್ ಅನ್ನು ಬಹಳ ಮಹತ್ವಪೂರ್ಣವಾಗಿರ್ತಕ್ಕಂಥದ್ದು, ಬಹಳ ದಿವಸದಿಂದ ಅದನ್ನು ಜನರು ಕಾದು ನೋಡ್ತಾ ಇದ್ದಾರೆ. ಅದನ್ನು ಅನುಷ್ಠಾನಗೊಳಿಸ್ತಕ್ಕಂಥದ್ದು ಒಂದು ಖಂಡಿತ ಒಂದು ನಿಲುವನ್ನು ನಾವು ತೆಗೆದುಕೊಂಡಿದ್ದೀವಿ, ಸರ್ಕಾರ ತೆಗೆದುಕೊಂಡು ಅದನ್ನು ಮಾಡ್ತೀವಿ.
ದಯಮಾಡಿ ಮಾಡಿ. ಇದು ಬಸವಣ್ಣನ
serial number 21
ಮಾಡಿ, ದಯಮಾಡಿ ಮಾಡಿ.
serial number 21 where the award has not been passed.
21
so serial number 21 ಅಲ್ಲಿ award pass ಆಗಿಲ್ಲ. ಅದಕ್ಕೆ that my lord, that is also some policy decision is required to be taken. It may be, we are also filed a writ appeal. Writ appeal we have filed. Writ appeal filed that the time limit under section 19 proviso was already extended. So therefore, madam, after vacation it may be called.
If it is after vacation, my lord, the thing is under section 25 of the act, the deputy commissioner shall pass an award within 1 year. If they have not passed an award under subsection 3, my lord, there is a extension of time. Now, the learned single judge, following that provision and also referring the judgment of this honorable court, as your lordship has passed an order, and also division bench, they preferred an appeal, my lord, and also division bench order stating that, my lord, the award should, in the meanwhile, they have passed an award in that case, in the writ appeal. Now, here, my lord, in the November is the last date. If extended time limit.
14th, ಈ ಹಬ್ಬ ಮುಗಿಸಿದ ನಂತರ ಫ್ರೀ ಆಗಿ
ಅಲ್ಲ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ, ಅವಾಗ ಅಷ್ಟು ದಿನದ ಒಳಗೆ ನಮಗೆ ಅವಾರ್ಡ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ. Initiates what happened, my lord, 2015, my lord, first acquisition proceedings is initiated. From 10 years, my lord, the farmers are the sufferers.
ಈಗ ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು. there is some point in what you are saying, we understand also. ನಮ್ ಸ್ವಲ್ಪ we are hard pressed for time. ಹಾಗಾಗಿ ನಾವೇ ಒಂದು ಅಜರ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇದ್ದೆ. ಅವ್ರದ್ದು ಬಿಡಿ, ಅವ್ರನ್ನ ತಲೆ ಕೆಡಿಸಬೇಡ್ರಿ. We are seeking adjournment at your hands now. Give one adjournment to us immediately after vacation, please. Call immediately.
Supreme Court says regarding contempt, my lord. So disregarding the court's order may be seen void.
ಈಗ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದ್ರು ಸೆಕ್ರೆಟರಿ ಅಡಿಷನಲ್ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ವಾಸ್ ಹಿಯರ್.
This is different case, my
ಅವರೆಲ್ಲ
lord.
ನೋಡಿದ್ದಾರೆ. ನೋಡಿ ಮಾಡೋಣ. Okay,
Lord,
ನೋಡಿ.
serial number
ಈ
32,
ಹೆಸರುಗಳನ್ನ
Your lordship, kindly have it on immediate after vacation, 14th, my lord. 14th.
Immediately
14th.
after immediate 14th ಅನ್ನೋದು ಬೇಡ, ಸ್ವಲ್ಪ ಅವಾಗ ಇನ್ನೂ
On date fix ಮಾಡ್ಬೇಕು.
ಒಂದು 2 ದಿನ ಫಸ್ಟ್ ವೀಕ್
ಅಲ್ಲ ಲ್ಯಾಬ್ಸ್ ಆಗಿ ಹೋಗುತ್ತೆ ಅದರ
ಆ ಟೈಮ್
for 10 years
ನವೆಂಬರ್ ನಲ್ಲಿ ಲ್ಯಾಪ್ಸ್ ಆಗ್ತದೆ. ಆಗಲ್ಲ
ಅಕ್ಟೋಬರ್ ಅಲ್ಲಿ ಲ್ಯಾಬ್ಸ್ ಆಗಿ ಹೋಗುತ್ತೆ.
15th ಹಾಕೋಣ, ಬೇರೆ ಬೆಂಚ್ ಇದೆ ಅದಕ್ಕೆ.
Please.
15th.
My lord, serial number 32, my lord. My application is pending for direction to disbursement of amount. At least we'll get to the 10% as per direction of this honorable court, my lord.
ಅದು
In ಕೆಲವೊಂದು ಕೇಸಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಕೇಸಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ ಸರ್. ಇದೆ 10% ಆರ್ಡರ್ ಮೇ ಬಿ ಮೇಡ್.
ಯಾವುದು?
In the connected case.
Serial number 32, my lord.
ಇದರಲ್ಲೆಲ್ಲ ಎಲ್ಲದರಲ್ಲೂ 10% ಮಾಡ್ಬೋದಾ? Please. Advocate General is also here, na?
Please.
In all these
ಮಾಡ್ಬೋದು. ಮಾಡ್ಬೋದು ಸರ್.
Only in the matters which are before your lordships, my lords.
That's what.
Delay. Already respondent is appeared, man.
Considering the interim order, order dated so and so you have passed in so and so. State into judgment and award of the not subject to appellant state depositing 10% of the amount which is permitted to be released in favor of the landowners in terms of the order dated so and so. Deposit shall be made before the reference court within a period of on or within the same 5 weeks. Same guarantee.
Same.
All these matters. Interim order illa.
Okay. 10%.
Please. Greatly obliged.
Grateful to my lords.
Very. Okay. State ಗೆ ನಾವು ಇದು ಇಲ್ಲ. State
ಅಲ್ಲಿ authority
ಇದೆ, ಅವ್ರದ್ದು ಕಾಸ್ಟ್ ಕೊಡ್ಬೇಕು. ಹೌದು ವಾಪಸ್ ಹೌದು ಸ್ಟೇಟ್ ಗೆ ಹೋಗಿ
reason ಏನು ಮಾಡೋದು?
Now, when it's brought to this is your lordship.
However, while disposing the appeal, court order, no order has to cost. Said order along with caution. And by inadvertence, considering the fact that appeals filed by the authority as well as the landowners are hardly allowed, these appeals are disposed of with costs. The registry shall make
Yes, Your Lord,
correction in the
wherever the court fees are paid, in some cases they are not paid. That's clarify ಮಾಡ್ಬಿಟ್ಟು.
Wherever court fees are paid.
Yes, sir.
This applies wherever court fees are paid.
Yes, sir.
Accordingly, memo is disposed.
Yes.
In this case.
Yes, brother.
One date may be fixed now.
Ready ilva?
Lord,
2007 matter.
Last time 23/7, my lord, 23/7 they released the order, my lord. 33 hostel workers swims matter, my lord. ತಮ್ಮಂದ ಪಾಟೆಡ್ ಆಗಿತ್ತದ 23/7 ಕ್ಕೆ ರಿಲೀಸ್ ಆಗಿದೆ.
ರಿಲೀಸ್ ಆಗಿದೆ.
ಬೆಂಗಳೂರಲ್ಲಿ ಇತ್ತು, ಈ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿ ಬಂದಿದೆ.
ಅಲ್ಲ ಕರೆಕ್ಟ್. 2007ನೇ ಇಸ್ವಿ ಮ್ಯಾಟರ್.
ಹೌದು.
ಏನ್ ಅನ್ಕೋತಾರೆ ಲಿಟಿಗಂಟ್ಸ್ ನಮ್ ಬಗ್ಗೆ? ನಿಮ್ ಬಗ್ಗೆನೂ ನಮ್ ಬಗ್ಗೆ ಏನ್ ಅನ್ಕೋತಾರೆ ಅವ್ರು?
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಹಾರ್ನಳ್ಳಿ ಸ್ವಾಮಿ ಅವರು ಅಟೆಂಡ್ ಆಗಿತ್ತು.
ಯಾರ ಬರ್ಲಿ ನಮ್ ನೋಡಪ್ಪ, ಎಲ್ಲರಿಗೂ ನಮ್ ಗೌರವ ಇದೆ. ನೀವು 2007ನೇ ಇಸ್ವಿ
2023/7 ರಿಲೀಸ್ ಆಗಿದೆ. ಪಾಟೆಡ್ ಹರ್ಡ್ ರಿಲೀಸ್ ಆಗಿದೆ, ತಾವ ಮಾಡಿದ್ದು ಸ್ವಾಮಿ.
ಆಗ್ಲಿ, ಈಗ ನಮ್ ಮುಂದ್ ಬಂದದಿಲ್ಲ.
One date may be fixed.
Kindly, my lord. Respondent 15 died, my lord.
We file memo.
15 respondent,
Respondent 15, my lord.
1-5.
Yes, my lord.
ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಅನ್ನು
No, memo, my lord. They will.
ಅವ್ರಿಗೆ ರಿಪೋರ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Yes, my lord.
ರಿಪೋರ್ಟ್ ಮಾಡಿ ಮಾಡೋ ಬದ್ಲಿ ಒಂದ್ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ರೆ ಕೇಸ್ ಬೇಗನೆ ಮುಗಿಸಕ್ ಬರ್ತಿತ್ತ. ಮತ್ತ ಅದ್ರ ಮೇಲೆ 1 ತಿಂಗಳು 2 ತಿಂಗಳು ಹೋಗೋದು.
No.
ಎಷ್ಟ್ ದಿವಸ ಎಷ್ಟ್ ಜನ ಸತ್ತ ಹೋಗ್ಬಿಡ್ತಾರ. ಈಗಾಗ್ಲೇ ನೋಡ್ಕೊಂಡ್ರೆ ಎಷ್ಟು ಜನ ತೀರ್ಕೊಂಡಾರೆ ಅನ್ನೋದು.
The Krupanand advocate is different, my lord.
Respondent number 15 is reported to have died. First, to this effect, the council has filed a memo. First, steps to be taken by the appellant immediately. Okay. Call this matter in the 3rd week of October.
Yes, my lord.
As requested. Yes, Shivraj.
Matter, my lord. Earlier, my lord, it was directed. Pay, my lord, 2,50,000 rupees deposit, 2,50,000 the first installment. The last occasion, my lord, only 1,30,000 was paid. But remaining amount, my lord, my party has got the amount.
Paraplegia.
He was, my lord, directed to appear before the.
After 1 month. Medical board ಮುಂದೆ ಹೋಗಿದ್ರಾ?
ಹೋಗಿದ್ದು 1 month ಆಗಿಂದ ಹೋಗಂತ ಡೈರೆಕ್ಷನ್ ಇದೆ, my lord.
ರಿಪೋರ್ಟ್ ಎಲ್ಲಿದೆ?
ರಿಪೋರ್ಟ್
ಬಂದಿಲ್ವಾ?
ಇನ್ನ ಬಂದಿಲ್ಲ. 1 month ಆಗಿಂದ.
ಅದಾದ್ಮೇಲೆ ಇನ್ನೊಂದು ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ವಾ? ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೋಗಿದ್ರು ನಾವು ಕೇಳಿ?
1 ತಿಂಗಳು ಇನ್ನ ಹೋಗಿಲ್ಲ. 1 ತಿಂಗಳು.
ಮತ್ತೆ ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೋಗಲ್ವಾ?
1 month ಆಗಿಂದ ಹೋಗಂತ ಹೇಳಿ ಇವಾಗ ಹೋಗ್ತಾರೆ ಸ್ವಾಮಿ.
ಸೆಕೆಂಡ್ ರಿಪೋರ್ಟ್ ಇದೆ.
2 days, my lord. 2 days ಬಿಟ್ಟು.
Balance amount, my lord, is got. Last time 1,30,000 was paid. Another 1,20,000, my lord, he has. I'll stay, my lord. Put you.
The appellant is paying rupees.
1,20,000 more.
1,20,000 cash to the parents, who are present before the court. Accordingly, the appellant has handed over cash of rupees 1,20,000 to the appellant's
Appellant. Claimant's father and mother.
Respond. Respondents. They are respondents.
Sorry. Respondent. Naveen is injured.
Injured.
Please.
Respondent. Respondent. The parents of the respondent. Respondent who are present to the parents of the respondent. They acknowledge the receipt of the same. Stop. Sri, amicus, learned counsel appearing for the respondent submits that within a period of 2 days' time, the parents would take the respondent Karnataka Institute of Medical Science Hubli for further examination. As per the medical board's advice, the said submission is placed on record. List.
Please.
After the list of science, ಮಾತಾಡಿಲ್ಲ
ಮಾತಾಡಿ.
ಅವ್ರಿಗೆ ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ಟು ಸೈನ್ ಮಾಡಿ.
Please.
ಲಿಸ್ಟ್
ಮಾಡಿಲ್ಲ.
ಕೊಟ್ರ ದುಡ್ಡು ನೀವು ಕೌಂಟ್ ಮಾಡಿಸಿ.
Please. ಇದೆ.
ಸೈನ್ ಮಾಡಿಸಿ.
Please.
On the sheet, the receipt acknowledges the receipt. What is it saying?
My lord, this is appeal preferred by this company challenging liability as a quantum. So far liability is concerned in view of the Mukund Jawan, it does not survive, my lord. Mukund Devangan.
Mukund Devangan.
Yes, my lord. Vehicle involved accident is in a light goods vehicle. The driver is authorized to drive LME non-transport. Like LGV, my light goods vehicle. The LME non-transport.
Is a transport vehicle, no?
It is a transport
But
vehicle.
that makes no difference now.
No, it doesn't.
Merit smell in the head.
And quantum is, again, quantum, my lord. There is small narrow compass between the claimant and insurance company that as per the document issued by the town municipality Chanagiri, he was working as an Paura Karmika and drawing the salary of 6,162, my lord. As against tribunal has taken the income at the rate of 7,000.
2015.
2015, 15, my lord. ಅದು ಒಂದು ಪ್ಲಸ್ ಇದ್ರ ಮೇಲೆ ಅಂದ್ರೆ ಅಡಿಷನ್ 50% ಮಾಡಿದ್ದಾರೆ 42 years old 42 years old ಮೇಡಮ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ 50% ಮಾಡಿದ್ದಾರೆ 50% ಮೈ ಲಾರ್ಡ್ ಹೌದು ಮೈ ಲಾರ್ಡ್ 25% ವಿಲ್ ಗಿವ್ ದ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮೈ ಲಾರ್ಡ್ ಓನ್ಲಿ ತಾವು ಇನ್ಕಮ್ ವೆದರ್ 6,000 ಅಲ್ಲ 6,160 ತಗೋಬೇಕಾ 7,000 ಅಂತ ತಾವು ಹೇಳಿದ್ರೆ ಅದಲ್ಲಿ ಫೈನಲ್ ವಿಲ್ ಗಿವ್ ದ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಆಯ್ತು ಮೈ ಲಾರ್ಡ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಡಿ.
Publish.
I represent Dharani. Next week, his wife is not well, my lord.
Not well.
My lord's claimant's appeal seeking enhancement of.
I appear for respondent, records are necessary. Even I have not filed Wakalat project. Take notice matter.
Since the order passed by the learned single judge lords, they had preferred lords, the corporation lords, the Buddha lords had filed a writ appeal. That was also dismissed. Against that lords, they had approached the Supreme Court, filed an SLP. That was also dismissed lords on 17th of this month. On the last occasion, this honorable court had directed for compliance or else bring an interim order from the Supreme Court. They had informed that the matter is pending before the Supreme Court.
My lord, I'm filing a counter affidavit. Counter affidavit.
What is the direction?
My lord, sir. Page 23 of the content. The content.
To allot authorized.
The land was acquired. There was a scheme, my lords, which says that either you receive compensation or they'll allot me an alternative site. I chose for an alternative site. And there was also an allotment in my favor. My land was, my lords, acquired for forming of a residential layout under a scheme called Scheme 40. Under that scheme, my lords, there was an option to either to receive the compensation amount or, my lords, for opting for an alternative developed site.
What have you done?
My lord, it was the contents of this respondent.
You have lost appeal. You have lost SLP.
Yes, I know.
Both have gone. Now
My submission is this is the point to file a review petition before Supreme Court. Review petition.
Review petition.
Review petition.
ಹಾಕೊಳ್ಳಿ ನೀವು.
No, this case is custom, my lord. This in the implement this learned single judge order, there was no time, period was fixed for compliance. Time limitation was not there. And this regard, this honorable court has passed two orders. When the time limit is not fixed, this contempt is not maintainable.
ಯಾರು ಕಂಪ್ಲೈ ಮಾಡಬೇಕು?
Buddha.
CW Shakul Ahmed.
No, now presently he is working.
He is presently
Yes.
working.
Accused number 1 is transferred.
Keep her present tomorrow.
Yes, please.
Accused number 2 is directed to be personally present before the court to answer as to why there is apparently a blatant non-compliance of the order of the learned single judge, as affirmed in the appeal, and the SLP of the respondents having been negatived by the apex court.
They have to.
day after tomorrow. Personal presence may not be necessary if in the meanwhile order is complied and report is submitted to this court 2 days after tomorrow, Thursday, correct? Thursday. Tell her otherwise.
No, now we are not only seeking to extension of time. Only review is being to filed. That's why I am asking for time.
You have filed appeal, you have filed SLP. Now we are seeing more than what I is meeting. Anyway.
Please.
Deliberately ಮಾಡ್ತಾ ಇದ್ದೀರಿ. ಆ ಇಂಪ್ರೆಷನ್ ಇದೆ ನಮಗೆ. Yes. Yes.
I am appearing for the complainant. In fact, the order passed by the learned single judge.
What is the order?
To issue appointment orders in favor of my lord the petitioner and to my lord. In fact, page number 24.
Any
Government is saying that my lord.
Filed against this?
It's there, connected.
My lord,
But,
connected
with
appeal,
respect to
writ
this
appeal.
order is concerned, but already contesting respondent has complied, my lord.
Complied.
Complied, my lord.
Not complied, my lord.
Comply ಅಂದ್ರೆ please.
Yes.
Order compliance ಅಂದ್ರೆ with and substance compliance ಆಗಬೇಕು. ಏನಂತ ಇದೆ ಆರ್ಡರ್?
Running page 23, my lord.
23.
Yes.
All. Writ petitions are allowed, rejection list dated so and so
by the
is quashed.
respondents whose management
Consequently, order of appointment annexed date so and so issued in favor of the private responsibility so and so approves issued by so and so response confirming of so and so the response are quashed. A direction is issued to the 5th and 6th respondents to consider the case of the petitioner for appointment to the post of English teacher in the 6th respondent institution run by the 5th respondent institution and issue appropriate orders. Yaru 5 6 yaru?
Not 5 are principal Karnataka Rural Education Society and
ask them to be present before the court.
ಅವ್ರು ಸರ್ವ್ ಆಗಿದೆ. No, they are private.
Private.
ಹೌದು.
Private ಇದ್ರೆ ಇರ್ಲಿ, ಮೊದಲು ಬರ್ಬೇಕು ಅವರು.
ಸರ್ವ್ ಆಗಿದೆ.
ಕೇಳಿ.
And moreover, my lord, I have produced the appointment order. My lord, set aside with the learned single judge. He paid appeal, that is also with.
Appeal is here.
Either connected. Mr. Halikeri. Halikeri.
ಮೃತ್ಯುಂಜಯ. ಈಗ ಆಸ್ ಆಫ್ ನೌ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು, ಹಂಗೆ ಕಂಟೆಂಪ್ಟ್ ಹೋಗಿಬಿಡ್ತದೆ. ಮುಂದೆ ಮೇಲ್ ನೀವು ಅವರ ಅಪೀಲ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡಿ. The
contempt, my lord.
The allegation
Only, my lord.
in the contempt case is, the complaint in the contempt case is as to non-compliance of a learned single judge's order dated so and so rendered dated 7/6/2023 rendered in complainant's WP number 115599 of 2019 connected with 100293 of 2022. Full stop. Relevant portion of the impugned order, the subject order reads as under 24 nalli. Idište hackಬೇಕು. Next paragraph. The learned GA appearing for the official appearing for respondent numbers?
Fourth.
Huh?
Fourth respondent.
Fourth respondent state submits that the order has been substantially complied with by issuing appointment order by the management itself on
4/11/2023.
4/11/2023. First off, he also answers the grievance of the complainant that there should be approval to this order, saying that there is no such direction. First off, a perusal of the papers shows that this submission is right. First off, ಎಲ್ಲಿ ತೋರಿಸಿ direction for approval.
ಅವರು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿರೋದೇ ಸಬ್ಜೆಕ್ಟ್ ಟು ಅಪ್ರೂವಲ್ ಆಫ್ ದಿ ಅಥಾರಿಟೀಸ್.
Subject to approval means it's against you. Without approval ಕೊಡ್ಲೇಬಾರ್ದಿತ್ತು ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿದೆ. ಹಂಗೆ hold ಮಾಡಿದ್ದಾರೆ. Subject to ಅಂತ ಜಸ್ಟಿಸ್ ರವೀಂದ್ರನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. Subject to approval means there is no direction for approval. Next paragraph. We are having heard learned counsel appearing for the parties and having perused the complaint papers. We are of the considered view that there is with and substance compliance of the writ of the learned single judge. And therefore, we drop these proceedings. First off, the issuance, we make it clear that the issuance of the appointment order is subject to result of the companion appeal in appeal number so and so, so and so. Okay. Call immediately after application. Idu drop aitu appeal na call out.
That impact maladi.
Next.
It is maladi subject the appointment order maladi so issued maladi.
Next.
My lord, in this I appear on behalf of the on request made by the learned AG. On the last occasion, the lordship has passed an order directing the learned AG to file the statement with regarding to wherever the Gairana lands have been granted to the throughout the state and to make an affidavit before this court.
Ellaru defense people, they have guarded our frontiers.
Yes.
You can't treat the defense people, ex-defense people that derogatively. We don't allow that.
Yes. Or on request, my lord, it can be taken tomorrow.
Tomorrow.
Age or illa.
Tomorrow.
Yes.
Call this matter. Reluctantly, request for adjournment is favored. Call this matter a day after. Please.
Please.
ಅವತ್ತು ಹೇಳ್ಬೇಕು
ಇಲ್ಲ
ಕಂಪ್ಲೇಂಟ್ ನೀವೆಲ್ಲ ಸೋಲ್ಜರ್ಸ್ ಅನ್ನೆಲ್ಲ ಆ ರೀತಿ ಮಾಡಿದ್ರೆ ನಾಳೆ ಯಾರು ನಿಮ್ಗೆ ಒಪ್ಪಲ್ಲ. ಓಕೆ.
For the complainant. Pay protection.
I made an
of
attempt to secure any bipartite agreement. I could not get anything.
On the point, my lords, there are two judgments. One of the Honorable Apex Court, my lord, 2003.
It cannot be less than the last pay drawn on.
Yes, my lord, Supreme Court specifically says, I'll just read and pass on, my lord, the intention, there was no intention to protect any particular scale of pay. That being the position, the demand for a corresponding pay scale has no rationale. The High Court was therefore clearly in error in holding that scale of pay was the determinative factor. This is what has been urged by my learned friend. Yes. And with my lord's kind permission, my lord, one judgment of the Kerala High Court single bench, which deals with the particular provision which my learned friend read.
Shared a copy of the
in advance, much in advance, I have shared.
Kerala High Court. They were sent to two Supreme Court judgments. Kerala High Court. Okay. Yeah. Yes.
ನಾಳೆ ಕಂಪ್ಲೈ ಮಾಡಿ tomorrow.
I may be permitted to rely on the single bench judgment.
By persuasive. After that, Kusum in God, any judgment on central law will be binding on all high courts, subject to some exceptions.
Particularly because that judgment considers the very 2.1 note.
That judgment, I can argue the matter based on this judgment also, my lord.
And one more clarification, sorry.
Now it's also, I am ready to argue the matter.
Only one clarification, sorry. ಅದ್ರ ಮೇಲೆ ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿದ್ರು, ರಿವರ್ಸ್ಡ್ ಮಾಡೋದು, ಡೈರೆಕ್ಟಿಂಗ್ ಫಾರ್ ರಿಕವರಿ. Now Supreme Court has stayed that. That also I have to place it on record. I should not only rely on one judgment which is passed.
Pending before the
Supreme Court now. Ali, the recovery is stayed.
Alla correct. Recovery is stayed antandra matter is being examined by the Supreme Court anta aitala.
Yes. That also I have to place.
Suppose Supreme Court, the recovery is on the premise
that
contrary to yours.
Yes.
contrary to argued premise.
Yes.
ಹಂಗಾಗಿ ವೇಟ್ ಮಾಡಿ. ಮತ್ತೆ ಹಂಗಿದ್ದ ನಾವ್ ಹೆಂಗ್ ಡಿಸೈಡ್ ಮಾಡಿ?
But earlier Supreme Court judgment is very clear, my lord.
ಅದನ್ನ ಹಂಗಿದ್ರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಯಾಕೆ ಹಂಗೆ ಹೇಳ್ತು?
2003.
We are told that against the order of the learned single judge, the writ appeal was filed and dismissed. And against the said dismissal, SLP Heli number is pending consideration on the file of the apex court of the country. And further that there is a direction. Kerala High Court ಮೇಲೆ appeal ಹೋಗಿ SLP
ಹೌದು ಹೌದು ಅಲ್ಲಿ ಹೋಗಿದೆ. ಅದಕ್ಕೆ that's what I was more not our more this thing.
Even then it requires consideration because identical matter is the same.
ಅಲ್ಲಿ ಮೇಲೆ para number 12 of the judgment.
The point being argued before us, comma, we are told, comma, is being debated on the floor of the apex court. In a case arising from Kerala High Court.
SLP copy.
In SLP High Court, first off, in SLP number 8223 of 2020, a 3-judge bench of apex court has issued notice and interim order staying recovery from the petitioners. From the ex-defense personnel. In view of that, the hearing of this matter is deferred sine die, and it's open to the parties to seek posting after the disposal of the said SLP. Yes, Mr. Misale.
Please, my lords. My lords, the petitioner's land has been occupied. Petitioner's land has been occupied in the
Issue
year
preliminary notification.
without issuing
Up
preliminary.
to page 25. Acquire the land. No appeal is filed against this order? Yaru?
No, my lord.
Notice. Sure. Notice. How can this kind of order be passed? Apex Court said in 86, Justice C.S. Venkatramaya, there cannot be a direction for acquiring the land. Anyway.
My lord, we have lost the land in the year 1989.
Damages
Since then,
acquire ಮಾಡಿ ಅಂತ ಹೇಳ್ದಂಗೆ. It's a power of eminent domain. Eminent domain should be exercised by the executive, not by the judiciary. Anyway, let us not input this. Yes.
In this, there is compliance modes. We have complied.
Compliance is done.
Please.
Both the sides submit very fairly that the order whose violation is complained of has been complied with. And a check for a sum of rupees 6 lakh,
60 lakhs.
60 lakh has been handed to the complainant. By the letter dated 19/9/2024, issued by the special SLAO, KIDB. First, in view of the above, these proceedings are liable to be and accordingly dropped.
One correction, Lord. It is credited to the complainant's account, Lord, through RTGS.
Complainant's account.
Please, account the like.
Check badli by RTGS.
Please.
RTGS payment are structure. Okay?
Please.
Next.
Please, your lordships. Please, your lordships, on the last occasion, your lordships were pleased to hear me on the merits of the case, your lordships. The matter is covered by the earlier decision of.
Not today. This is fit case for the succeeding bench.
Your lordships.
Because in the mid of, we are framing one important one, two important.
Tomorrow, your lordships. Tomorrow, your lordships, because he is.
Many morrows come. Calendar is full of dates. The third week of. Yes.
Kindly a date, your lordships.
Third
Even
week,
after.
we cannot fix date for the succeeding bench. Yes.
LR application I have filed, Lords. I have filed an application to bring in the LRs, Lords.
LR application.
Lords, there's a delay of 3,455 days, my lord. Copies are given to you last week, my lord. We'll file objections.
Notice, no notice has been given, Lords. To propose respondents, notice has to be given.
Notice ಹೋಗಬೇಕಾಗ್ತದೆ.
Notice
But there is an inordinate delay, my lord. 3,455 days.
ಅದಕ್ಕೆ explanation ಇದ್ರೆ? Objection.
I4 of 24 months.
I4 of?
24.
ಎಲ್ಲ ಏನು?
All I's, 1 to 4 of 24.
May I pass on the memo, my lords?
ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಅವ್ರಿಗೆ ಕಬ್ಜಾ ಕೊಟ್ರ ನಿಮ್ಗೆ?
What they are trying to interpret is, court has directed them to give the position. They themselves have undertaken to give the position.
ಪಾಪಿಗ ಆಫೀಸರ್ಗೆ ಆಮೇಲೆ ಆ ವಿಡಿಯೋದಲ್ಲೆಲ್ಲ ಕೆಲವು ಕಡೆ ಬರ್ತಾರೆ ಆ ರೀತಿ ಕಳಿಸಿದ್ರೆ ಏನೋ ಒಂದು ಡಿಸ್ಕಷನ್ ಮಾಡ್ತಿರ್ತೀವಿ. ಹಂಗೆ ಬರ್ದ್ರೆ ಹೆಂಗ ಹೌ ದಿ ಆಫೀಸರ್ ಶುಡ್ ಫಂಕ್ಷನ್ ಟುಮಾರೋ. ಅವೇನೋ ಒಂದು ಜಸ್ಟಿಸ್ ಮಾಡಬೇಕು ಅನ್ನೋದಕ್ಕೆ ಒಂದು 4 ಮಾತು ಮಾರ್ತಿರ್ತೀವಿ.
Intention of this court is to get the.
ಹಂಗೆಲ್ಲ ಮಾಡಿದ್ರೆ ಒಳ್ಳೊಳ್ಳೆ ಆಫೀಸರ್ಸ್ ಮುಂದ್ ಗತಿ ಏನವರು?
Including advocate.
ಈಗ ಪೊಸಿಷನ್ ಕೊಟ್ಟಾಗಿದೆ, ಕಂಪ್ಲೈನ್ಸ್ ಆಗಿದೆ. Compliance in the sense they have given back the land to you.
Land. And only thing is, damages have to be given. Because they have.
ನೀವು ಹೆಂಗ ಡ್ಯಾಮೇಜಸ್ ನೀವು ವರ್ಕೌಟ್ ಮಾಡ್ಕೆ ಹೋಗಕ್ಕಾಗ್ತದೆ.
ಮಾಡ್ಕೊಂತೀವಿ, but that liberty is already there in the earlier order.
ಆ ಪ್ರಕಾರ ನೀವು ಮಾಡ್ಕೆ ಹೋಗಕ್ಕಾಗ್ತದೆ.
ಮಾಡ್ಕೊಳಕ್ liberty, and we may approach the high court also, not civil court ಗೆ ಹಾಕಿದ್ರೆ ಮತ್ತೆ 20 ವರ್ಷ ಹೋಗುತ್ತೆ.
ಅದು ಹಂಗನ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಈಗಾಗಲೇ
ಯಾಕಂದ್ರೆ ನಾವೇನ್ ಹೇಳಲ್ಲ 300 ಕ್ಯಾಪಿಟಲ್ ಏನು ಇದೆ ಅಲ್ಲಿ. ಅವಾಗೂ ಸಹಿತ ನೀವು ಸಿವಿಲ್ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕಾ ಅಥವಾ ಹೈಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕಾ ಇದನ್ನೆಲ್ಲ ನೋಡಿ.
That liberty may be reserved.
Learned panel counsel appearing for the answering respondents have filed a memo this day. Along with 3 copies of documents accompanying the same. First of the documents is Panchama, second is of delivery of possession of the subject line to the complainant, and third one is the photograph in which the respondent commissioner of the local body and the respondent jurisdictional assistant commissioner do figure.
And also managing director, Smart City Corporation.
In addition to managing director of Smart City Corporation. First off, next one. In view of the above, the contempt proceedings are liable to be closed, and accordingly they are, liberty being reserved to the complainant to work out the other residuary remedies, if any, elsewhere in accordance with law. Full stop. In that connection, all contentions are kept open.
Your lordship's permission, my lord.
Of course.
With your lordship's permission, may I submit? They have illegally, they have taken the land, utilized, and they have spent on that land public money, our own money, nearly for 5 crore.
I have understood. Other day you said that. We have kept in our view. What officers can do? They are posted, they are executives, popular body takes the decision. How can we find fault with them? They are good officers. Navena subsidiary ಏನೋ ಮಾತಾಡ್ತೀವಿ. ಆದರೆ they are good officers. ಏನ್ ಮಾಡ್ಬೇಕು ಅವ್ರು ಹೇಳಿ ನೋಡೋಣ. What they could have done? They have done everything.
On the oral instructions of,
they have their own constraints. They have done, now they have given possession. What else they can do? Perhaps they have antagonized other popular bodies also, we do not know. Therefore, in fact, we have to appreciate them, to be frank with you. Anyway, that remains as a factor, which wherever you want to take, you can take that one.
In view of, one more, in view of handing over, acquisition proceeding which is initiated, 11 may not survive.
We do not know.
We will
Position
file-
ಕೊಟ್ಟಾರೆ, ಮುಗ್ದು ಹೋಗಿದೆ.
Please.
ಆಗಿ ಹೋಗ್ಬಿಡ್ತು. Equation proceedings ಡ್ರಾಪ್ ಆದಂಗೆ ಆಗ್ತದಾನ ಈಗ?
ಇಲ್ಲ, ಅದು
Virtually-
ಅದು ಗೊತ್ತಿಲ್ಲ ನಮಗೆ.
ಅಲ್ಲ, ಅದು notification ಇದೆ. That notification needs to be
Lapse ಆಗುತ್ತೆ.
ಸೆಂಟೆನ್ಸ್ ಬರಿಬೇಕು. ಇಲ್ಲಿ ಏನಂತ? On 17/9/2024, we had made certain observations. Which would pale into insignificance because of the above order. ಅನ್ಕೊಂಡು ಅದು ಲಾಸ್ಟಿಗೆ ಹಾಕ್ಬಿಡಿದ್ವಿ.
ಅಲ್ಲ, with your lordship's permission, my lord, the notification which they have initiated.
ಅದು ನಾವೇನು ಅದ್ರ ಮೇಲೆ ನಾವು ಮಾತಾಡೋದಿಲ್ಲ.
ಅಲ್ಲ, it became
ಇದ್ರ ಮೇಲೆ
lapse
ಮಾಡ್ತೀವಿ.
ಆಗುತ್ತೆ.
Otherwise, we will, if you file a memo,
Please, my lord.
we will say whether you want to drop the equation proceedings.
Please, my lord.
ಬಡಿ, ಒಂದು ಮೆಮೊ ಬಡಿ.
Please.
ಬರ್ಕೊಳ್ಳಿ. ಅಲ್ಲಿ ಒಂದ್ ಕಡೆ ಎಲ್ಲರ ಒಂದ್ ಕಡೆ ಮಾಡ್ಕೊ. Panel council appearing for the ಯಾರು
City Corporation Belagavi.
appearing for the City Corporation Belgaum has filed a memo stating that the subject acquisition proceedings
EC notify
are dropped.
notify ಮಾಡಿದ್ದು EC ಮಾಡ್ಯಾರ ಸರ್. Notification is issued by Assistant Commissioner.
ಮತ್ತೆ ಅವರು ಕೊಡ್ಬೇಕಾಗ್ತದೆ.
Please.
Submits that his client is interacting with the jurisdictional body as to whether the subject acquisition proceeding should be dropped. ಇಷ್ಟೇ ನೋಡಿ. Please ಜಾಸ್ತಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ, ನಿಮ್ಗೆ ಇರಲ್ಲ ಅದು.
It is understand.
First, the same is placed on record.
Please.
Memo ಅನ್ನೋದು ಬೇಡ, submits ಅಂತ ಹೇಳಿ ಮಾಡ್ಬಿಟ್ಟು.
Okay.
Okay.
Obliged.
All.
My lord, I have filed an application for revival of the contempt since it is a continuous contempt. My learned friend said that he has returned back the file. He refused to take the application. Shivraj Belak.
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾಗತ್ತಾನು? ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
He said that somebody else has filed. I'll find out who is there filed the wakalat.
ಯಾರು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡ್ಯಾರಿ?
Shivraj Belak is the my learned friend.
ಅಪ್ಲಿಕೇಶನ್ ಮಾಡೋಣ?
Please.
ನೋಟಿಸ್ ಹೋಗೋದು ಬೇಡವಾ?
If he is already filed wakalat.
ಅದು ರಿವೈವಲ್ ಫ್ರೆಶ್ ಪ್ರೊಸೀಡಿಂಗ್ ಆಗ್ತದೆ.
Please.
After vacation. ಏನ್ ಗುರು ಇದು?
Civil suit, my lords, between two parties. Suit, my lords, was one for partition and separate portion which was dismissed. Then, my lords, the RFA, my lords, was preferred. Before preferring the RFA, my lords, there was a relinquishment deed, my lords, and also the consent deed which was executed by them in favor of a person, my lords, who was subsequently purchased after the dismissal of the suit, the very same property. Then, my lords, they prosecute this regular first appeal and obtain an interim order not to alienate. In the meantime, my lords, the subsequent purchaser, my lords, has formed 5 residential plots, my lords, in the said land.
ಅವ್ರಿಗೆ ಗೊತ್ತಿರಲಿಲ್ಲನೋ ಹಿಂಗ ಅಥವಾ ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಡೀಡ್ ತೊಗೊಂಡ್ ಮಾಡ್ಯಾರ?
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಪರ್ಟ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ತಗೊಂಡಿದ್ರು. ಆಮೇಲೆ ನಾವು ಅಪಿಯರೆನ್ಸ್ ಹಾಕಿದ್ವಿ. ಅದಾದ್ಮೇಲೆ they have alienated the property. That is, I mean, there afterwards, my lords, the regular first appeal was also dismissed for default. Then they filed an application seeking for restoration. That is the issue. He appears, my lords, for subsequent purchaser. I appear for the co-partners, my lords, who have prosecuted the suit.
ಅಲ್ಲಿ ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಡೀಡ್ ಕೊಟ್ಟಿದ್ರಾ?
ಅದು ಕನ್ಸೆಂಟಿಂಗ್ ವಿಟ್ನೆಸ್ ಆಗಿ ನಮಗೆ ಇವ್ರಿಗೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ he was a consenting witness.
ಕನ್ಸೆಂಟಿಂಗ್ ವಿಟ್ನೆಸ್ ಇದೆಯಾ?
ಒಂದು ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ವಿ.
ಅದು ರಿಜಿಸ್ಟರ್ಡ್ ಸೇಲ್ ಡೀಡ್?
ಹೌದು, ರಿಜಿಸ್ಟರ್ಡ್ ಸೇಲ್.
ಕನ್ಸೆಂಟಿಂಗ್ ವಿಟ್ನೆಸ್ ಹಾಕಿ ಹಿಂಗ್ ಮಾಡ್ತೀರಾ? ಅಬ್ಯೂಸ್ ಆಫ್ ಲಾ.
Copies is not sir, my lord. Copies ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ ನಮಗೆ.
ನೋಡಿ ತೋರಿಸಿ.
Clear advocate.
It is abuse of law. ಯಾವ್ದೋ ಕೋರ್ಟ್ ಆರ್ಡರ್ ತಗೊಂಡು ಅದು ಮೊದಲಿಗೆ ಸಿಗ್ನೇಚರ್ ಮಾಡಿ, ವೇರ್ ಇಸ್ ದಟ್? ಕಂಟೆಂಪ್ಟ್ ನೀವೇ ಮಾಡ್ದಂಗೆ ಆಗ್ತದೆ. EMS GL Gaba versus ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಅದು? Take out GL Gaba versus GL Gauba versus so and so. Settle what had argued. ಏನ್ ನೀವಿದೆ ಸಿಗ್ನೇಚರ್ ಇದೇನು? ಇಲ್ಲಪ್ಪ ನಾವು ಫರ್ದರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತೀವಿ, ನಾಳೆ ನಿಮ್ಗೆ ತೊಂದರೆ ಆಗ್ಬೋದು. If you are a signatory to the, do you just see that?
My submission, Your Lordship, is they have just some impressions are there. And it is a consent deed. If they have written in the sale deed itself regarding the consent deed, then it could be considered that definitely we can't prosecute anything. So you
cannot, otherwise your client will be abusing the process of.
Definitely, certainly, sir. Certainly. I request Your Lordship kindly grant little time. I will go through it and will.
No time will be granted. Parkade. Kodi. No time will be granted.
Copy ಕೊಡಬೇಕು.
ಅಲ್ಲ ಅಬ್ಯೂಸ್ ಮಾಡ್ಕತ್ತೆ. ನಿಮ್ಗೆ ಹೇಳಿರಲ್ಲ ಅವರು. ಸಮ್ಮತಿ ಪತ್ರ ಯಾರ್ಯಾರು ಇದ್ದಾರೆ ಅದರಲ್ಲಿ?
All the parties, including them.
This complaint alleges violation of an interim order dated 30 May 2022, handed in complainant's RFA 100322 of 2019, pending on the file of a learned single judge of this court. Correct? Single judge mundidiya?
Division.
Before the coordinate bench of this court. Full stop. After service of notice, the answering respondents having entered appearance through their counsel have filed, idon memo ಹಾಕಿಕೊಡ್ಬೇಕು, a copy of affidavit ಜೊತೆ ಇದೆಯಾ? Have filed the reply affidavit sworn to by Mr. Arjun, son of Yellappa Hanchinal, who happens to be accused number?
Accused number 1. Arjun is accused number. He has not been added as a party. Subsequent purchasers are not.
8 ಇದೆ ಅಲ್ರಿ.
Only
accused number 8 ಇದಾರಲ್ಲ ಗುರು. So and so. Learned counsel ಗಚ್ಚಿನ್ ಮಟ್ and ನೀವು ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ದೀರಿ ಇದರಲ್ಲಿ? Budihal draw our attention to the consent witness column at page 20 of the registered sale deed dated
19/6/2020 and 11/6/2020.
Deeds dated 19/6/2020 and
11/6/2020 consent deed.
11/6/2020. 2020. Copies whereof are produced along with the reply affidavit. First up, it shows that the said alienation has taken place with the specific consent of complainant side.
Please, of course. May I am permitted to interrupt just.
Alienation.
That this particular person who has filed this petition is not a party to the proceedings.
He is not a party to the to the sale deed. You are not a party.
Not a party. He is there at page number 29 of my affidavit notes.
29,
29. Sammati Sakshi. Sammati Sakshi. Now Srimati Ningawa Tande Adivappa Hanchinal. She is, my lords, after marriage earlier she was Shankarava. She is now called as Ningawa. Second is ಮೇಲಿನ ಹೆಸರು ಶಂಕರವ್ವ ಕೋಮ್ ಕಲ್ಲಪ್ಪ
ಯಾರು ಕಂಪ್ಲೇನೆಂಟ್?
ಶಾರದಾಬಾಯಿ.
Kindly see Sharnava. ಶಾರವ್ವ ಶರಣವ್ವ.
ಮ್ಯಾರೇಜ್ ಆದ್ಮೇಲೆ ರೀಕ್ರಿಸ್ಟೈನ್ ಆಗಿರ್ತದೆ.
ಆಗಿದ್ದು ಇಲ್ಲಿ ಅಲ್ಲೇ ಫಸ್ಟ್ ಇದ್ರೊಳಗೆ ಬರ್ತಿದ್ದಾರೆ ಸೀಲ್ಡ್ ಒಳಗೆ.
That makes no sense.
Please.
Amongst Hindus, direct says, Duncan direct says.
But her name is
after the
not.
Huh?
No, your lordship kindly see that Srimati Ningavva ತಂದೆ ಅಡವೆಪ್ಪ ಹಂಚನಾಳ್ ಊರ್ಫ್ ಲಗ್ನ ಅಂಕಲಿ ಲಗ್ನವಾದ ಮೇಲೆ ಹೆಸರು ಶಂಕರವ್ವ ಕಲ್ಲಪ್ಪ ಮುಂದಿನ ಮನಿ. Whereas this.
She is the complainant.
No, complainant is Srimati Sharavva Yallappa Kardi.
Number 2 note. Complainant number 2 is Shankarava.
Sharavva is Kallappa.
First is Sharavva.
Second is complainant.
Sharada.
Together.
My lord,
Together.
next week, my lord.
Together.
Yes.
Consider ibru idare.
Sorry.
All right. ಹೆಸರು ಬೇರೆ ಇರೋದಕ್ಕೆ ನಾನು ಕನ್ಫ್ಯೂಸ್. Names very different ಅನ್ನೋದಕ್ಕೆ. ಮಕ್ಕಳು ಏನ್ ಬರೋದು? With the consent, inter-alia of the complainants herein who have got their names rechristened after the marriage. First, a person who acquiesces to the complained action is stopped from raising the complaint. Is the settled position in the realm of contempt law. First, in view of the above, these proceedings are liable to be and accordingly dropped.
Grateful.
Yes, Vidya madam.
2 weeks time may be granted.
Huh?
After the dismissal of the appeal, they have filed an application seeking a stay of that.
Because
Till
from
the appeal period.
31/7/2008, plus till the disposal of the writ appeal, because I was protected by an order of status quo laws regarding possession. Filed this application. Even before the learned single judge, after disposal of the writ petition in the presence of the counsel for the
You had
contesting rest. I had.
benefit of interim order.
Yes, till the disposal of the writ appeal I had from 31/7/2008.
Objection. Respondent 4 ಮೇಲೆ.
ಅವರು ಲೀವ್ ಕೇಳಿದ್ರು ಲೀವ್ ಕೊಟ್ಟಿಲ್ಲ ನಾವು. ಅಲ್ವಾ? We have disposed of this.
ಯಾವ್ದು?
But ಲೀವ್ ಕೊಟ್ಟಿಲ್ಲ ಅರ್ಥ small relief we can give. ಹಂಗ್ ಹೋಲ್ಡ್ ಮಾಡಿದೆ full bench of Andhra Pradesh High Court other day which at BL Hansaria on writ jurisdiction has discussed this. On 8 weeks ಹೊರನಂತೆ.
1ನೇ ತಿಂಗಳಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ತಾರೆ 5ನೇ ತಿಂಗಳ ಮಟ್ಟನೇ ಸುಮ್ಮನೆ ಅದು ಸ್ಟೇಟಸ್ ಕೋಡ್ ಬಗ್ಗೆ ಏನು
ಸ್ಟೇಟಸ್ ಕೋಡ್ ಇದೆಯಲ್ಲ
During the appeal period. During the appeal period.
appeal SLP 90 days ಅಣ್ಣ 3 months ಆಗ್ತದೆ
3 months.
This appeal this appeal was has been disposed of by us. Wide order dated
11/9 minutes.
11/9/2024. First off, the appellants desire to challenge our order before the apex court, and therefore they seek some reprieve in the form of continuation of the status quo order granted by the learned single judge and later continued by this bench.
Yes.
By this court in appeal. First off, an order, an affidavit is sworn to in support of application. First off, next paragraph. Learned HCGP appearing for the official respondents and the learned private counsel appearing for the private respondent oppose the application contending that once appeal is disposed of, court becomes functus officio. First, there is some elements of truth in this. First, however, law recognizes power of the court to grant a short reprieve to enable the parties to work out their remedies. First off, this view gains support from the full bench. ಯಾವ್ದದು ಗಿರೀಶ್ ಅಂತ ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿನಿ ನೀನು ಫುಲ್ ಬೆಂಚ್ BL ಹನ್ಸಾರಿಯಾದಲ್ಲಿ ರೆಫರ್ ಆಗಿ ತಂದು ಕೊಡಬೇಕು ನೀವು ಮಾಡಿಕೊಂಡದ್ದು support of the full bench judgment decision of the Andhra Pradesh High Court in so and so, so and so. ಅದು ಕೊಟ್ಟರೆ ಸಿಗ್ನೇಚರ್ ಆಗ್ತದೆ, ಇರಲಿಲ್ಲ. Next paragraph. In view of the above, this application having been favored, comma, parties are directed to maintain status quo till after the expiry of limitation for filing the SLP.
Yes.
Or SLP is filed, whichever is earlier.
Please.
SLP is filed ಅಂದ್ರೆ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ because it takes some time, diary number ಆಗಿ.
ಅದಕ್ಕೆ ನಾವೇನ್ ಮಾಡಿದ್ದೇವೆ?
ಅಲ್ಲ, ಇಲ್ಲ SLP is filed ಅನ್ನೋ.
ಅಲ್ಲ, you may suppose if you file SLP before, ಅವಾಗೂ ಕಂಟಿನ್ಯೂ ಮಾಡಕ ನಾವು ಬರಲ್ಲ ಅವಾಗ.
ಆರ್ಟಿಸಿ ಎಲ್ಲ ನಮ್ಮ ಹೆಸರು, ಇವತ್ತಿನವರೆಗೂ ಆರ್ಟಿಸಿ ನಮ್ಮ ಹೆಸರು
ನೋಡೋಣ, ಯಾವ ಸ್ಟೇಟಸ್ ನಿಮ್ ಬರೀದ್ರೆ ನಿಮ್ಗೆ ಆಗತ್ತೆ, ನೀವೇನ್ ಕಳ್ಕೊಳ್ಳೋದಿಲ್ಲ. IIT sport already.
అపిలేట్ మేలాడింది, సిస్ మేలాడింది, డిస్పోజ్డ్ మ్యాటర్ మేలాడింది, లార్డ్షిప్ మేలాడు, లార్డ్షిప్ యాస్ మేలాడింది, డిస్పోజ్ దిస్ అపీల్ మేలాడింది, సమ్ అబ్జర్వేషన్ మేలాడి షల్ నాట్ ట్రాన్స్ఫర్ ಅಂತ ಬರ್ದಿದ್ರು ಮೇಲಾಡಿ. ಎನಿ ಅಬ್ಸರ್ವೇಷನ್ ಮೇಲಾడింది ವಿತೌಟ್ ಎನಿ ರೀಸನ್ ಮೇಲಾడింది, ಟ್ರಾನ್ಸ್ಫರ್ ಮೇಲಾడింది.
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರೆ ಸಪರೇಟ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಆಗ್ತದೆ. ಇದ್ರಾಗ ಹೆಂಗ್ ಬರ್ತದೆ?
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ, ಅಬ್ಸರ್ವೇಷನ್ ಇದೆ.
ಅಬ್ಸರ್ವೇಷನ್ ಏನಂತ ಇದೆ?
ಈಸ್ ಮೇಲಾಡು 3.1 ಮೇಲಾಡಿದೆ, ಜಜ್ಮೆಂಟ್ 3.1 ಮೇಲಾಡಿದೆ, ಜಜ್ಮೆಂಟ್ ಮೇಲಾಡಿದೆ, ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ ಲಾಸ್ಟ್ 4 ಲೈನ್ ಮೇಲಾಡಿದೆ. Further, the apprehension of the London Council for the appeared for the appellants is that his client is likely to be transferred some
unless there are extraordinary circumstances. ನೀವು cause of action
ಅಲ್ಲ, ಏನು ಸ್ಟಾರ್ಟೇ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ವಿತೌಟ್ ಎನಿ ರೀಸನ್ ಮೇಲಾಡಿದೆ.
Application is misconceived and therefore liable to be rejected. First, accordingly rejected. There being a fresh cause of action.
ಅಲ್ಲ, ಬರೇ ಜಜ್ಮೆಂಟ್ ತಗೊಂಡಾಗ ಅಷ್ಟೇ ಆಯ್ತು ಸ್ವಾಮಿ, ಏನಾದ್ರು.
Next.
Wife's petition was dismissed by the trial court on the ground of. Please.
Please. They filed a vacating application. Not done. This present ಇಲ್ಲ. Delay was there, not some delay was there. Delay was there, not.
ಮತ್ತೆ ಅವ್ರು ಇಲ್ದಂಗೆ ಹೆಂಗ್ ಮಾಡೋದು?
Please,
ಅಲ್ಲೇ ನೋಡಿ, ರಾಜೇಂದ್ರ ಕುಮಾರ್ ಕಟಾರಿಯಾ served. Contempt he has remained absent. That's not a good symptom. ಅಲ್ಲಿ ಕಂಟೆಂಪ್ಟ್ ನಲ್ಲಿ 21.1 ನಲ್ಲಿ ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ ಅವ್ರಿಗೆ ಯಾರು ಅಪಿಯರ್ ಆಗಬೇಕು? ಏನು ಅಷ್ಟೊಂದು ಕೋರ್ಟ್ ಬಗ್ಗೆ ಡಿಸ್ರಿಗಾರ್ಡ್ ಸೆಕ್ರೆಟರೀಸ್ಗೆ? ನೋಡು, ಇದರಲ್ಲಿ 21.1 ನಲ್ಲಿ ನೋಡು, ಅಕ್ಯೂಸ್ ನಂಬರ್ 2.
Take notice, accept.
Shri Girish on instructions appears for accused number 2 na?
All the respondents.
All the respondents. All right.
Senior appears.
I'm sorry.
Yes.
Your Lordship, before commencing, Your Lordship, I appear for respondent number 3. There was a writ filed, Your Lordship, wherein I was made a party, but notice to me was dispensed with. So the facts in the present appeal have to be objected by the respondent number 3, Your Lordship. I have sought for the documents.
Formal party, my lord. In fact, my lord, no role, my lord, of respondent number 3.
3 ದಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿದ ಮೇಲೆ ಪಾರ್ಟಿ ಯಾಕೆ ಮಾಡಿದ್ವಿ?
ಅಲ್ಲ, ಪಾರ್ಟಿ, he was a formal party.
ಪಾರ್ಟಿ ಮಾಡಿದ ಮೇಲೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು. ಡಿಸ್ಪೆನ್ಸ್ ವಿತ್ ಅನ್ನೋದು ಆಸ್ ಅನ್ ಎಕ್ಸೆಪ್ಷನ್ ಅಷ್ಟೇ, ಅದರ್ವೈಸ್ ರೆಸ್ಟಿಫಿಕೇಟ್ ಅಪ್ಲೈ ಆಗ್ತದೆ. ಇಫ್ he is a party, whether notice is issued or not, the courts, of course, there is a divergence of opinion, but courts have
No, he
generally
is also not, my lord. In fact, my lord, he is, my lord, what he says is.
Yes, sir, Ravi Shankar. ಅಲ್ಲಿ ಹೋಗಿ ಬಿಟ್ರಲ್ರಿ.
Now, what they're trying to do is, Lord, by virtue of this order, Lord, they have served, Lord, the disqualification notice. They want to disqualify them, Lord, 4 members.
ನಿಮ್ಗೆ ಟೈಮ್ ಬೇಕನ?
Please, Lordship, I have to bring
may have
documents
this-
and objections on board.
ಯಾರು ಡಿಸ್ಕ್ವಾಲಿಫೈ ಮಾಡೋರು ಯಾರಿಗೆ?
Allah, disqualify the
Sorry,
directors of.
some.
Yes, Mr. Ravishankar. ಹಾ.
Not sir, page number 45 and page 46. Please.
46.
Yes. This is a credit structure society. The registrar directs under section 12(6) that I will have to restrict the operation of my society to a particular territorial limits.
He has altered the territorial, he has reduced the
Territorial limits. Let's now kindly have a look at section 98I, Lords of the Karnataka Cooperative Societies Act, 2009, 98 capital I.
ಕೊಡಿ, ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಇದೆ ಕೊಡಿ. ಯಾರು ಮಾಡೋದು ಪ್ರೊಸೆಸ್ ಏನದು? ಆ ರಿಡಕ್ಷನ್ ಆಫ್ ಏರಿಯಾ.
Lords, it says that so far as credit structure cooperative societies are concerned.
98A. 98 ಏನಾ? I.
98I.
I. Restriction regarding area of a cooperative society shall have the freedom of entry and exit at any time, and there shall be no mandatory restrictions of geographical boundaries for the conduct of its business operations. Amend ಆಗಿದೆ ಏನದು? 2013 amendment.
ಹೌದು, 2013 amendment.
What do you say, brother?
That so far as 98, section 98 is concerned, it applicable only to the societies with regard to credit cooperative credit structure ಮಾತ್ರ applicable. So far as these petitioners societies
ಇವ್ರಿಗೆ apply ಆಗಲ್ವಾ?
it's not a cooperative credit
Cooperative
structure society.
structure ಇರೋರಿಗೆ ಮಾತ್ರ.
ಇರೋರಿಗೆ ಮಾತ್ರ. So that's bank Miller. It is.
Yes, sir, Ravi Shankar, it applies to cooperative. Kindly see chapter 11 capital A. It does not apply to other societies at all.
Section, it is defined under section B2 Miller. Cooperative credit structure means includes primary agricultural credit cooperative societies by whatever name called central cooperative banks, state cooperative bank, agricultural and rural development bank, and state agricultural and rural development. It refers to banks, and those banks are regulated by the RBI regulations.
Not under
Not,
this at all.
not on this.
Only credit cooperative societies in the ಮಾತ್ರ ಇದು apply.
Apply.
And you are not a credit cooperative society, brother.
Let's kindly have a look at, this is a credit structure cooperative society. What it applies to, credit structure is defined under the act.
Defined under section B2.
B2.
2B2.
2B2 means and includes. It's an inclusive definition. Primary agricultural credit cooperative societies by whatever name called. Central bank, state bank, agricultural rural development bank, state agricultural rural development bank.
ನಿಮ್ದು ಯಾವುದು?
Ours is, yes, it's a primary credit cooperative society. ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘ ನಿಯಮಿತ. Agricultural credit structure society minutes.
ಇದು PKPS, primary ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರಿ ಸಂಘ.
Yes, ಪತ್ತಿನ means credit.
Credit cooperative society. ಪ್ರಾಥಮಿಕ ಅಪಾಯಗಳು ಅಂತ ಹೇಳಿದೆ. ಚಾಪ್ಟರ್ 11 ಕ್ಯಾಪಿಟಲ್ ಎ ದಲ್ಲಿ ಎಲ್ಲಾ ಕ್ರೆಡಿಟ್ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಕವರ್ ಆಗಿದೆ. ಜಸ್ಟಿಸ್ ರಾಮನಾಥ್ ಹೆಗಡೆ ಅವ್ರದ್ದು ಒಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ. All cooperatives, credit cooperative societies are covered under 98I ಅಂತ ಹೋಗ್ತಾರೆ.
Yes.
I think, okay, section says it's free for all. How can that be restricted?
I may take your lordship's kind attention to section 106 of this act, your lordship.
106.
106, your lordship. This provides for an appeal, and this provides for an appeal, your lordship.
We'll look into that. Please, legislative intent is it should be free. How can he make an order restricting that one? Correct, correct.
My submission is that, your lordship, there are pleadings made in the writ petition
Alternative remedy is only judicial intervention, the invention. ಅದನ್ನ ಬರ ಆಮೇಲೆ ಪ್ಯೂರ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಅಲ್ಲಿ ಏನಪ್ಪಾ ಈಗ ಫ್ಯಾಕ್ಟ್ಸ್ ಇದೆ ಅಡ್ಜುಡಿಕೇಟ್ ಮಾಡಬೇಕು ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಪ್ಯೂರ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಬೇರೆ ಏನಿಲ್ಲ ಯಾವ್ದು
Whirlpool Corporation's case.
ಅಲ್ವಾ
Then counsel for the appellant points out that section 98I not restrict the area of operation for the
society concern. Great cooperative society. Great
structure. Cooperative societies, which want to be structure. Structure. In view of the said submission, matter requires detailed consideration. Making interim order stay of the what stay which order?
Stay of
Stay of annexure F. Annexure F.
Stay of the stay of the order dated 11/1/2015 passed by the annexure F. And order of the single judge.
May I seek liberty?
Great. Objections, if any, to the writ petition.
Please.
Because he has not made objections to the writ petition. First of all, accepting the
I seek-
the absence of is interpreting the appeal is confirmed.
I appear to respond to Milada. I mean, file objection. There is a delay of 132 days in filing the appeal.
Great.
My lord, corporation appeal, my lord. There is a delay of 553 days. The
ಮೆರಿಟ್ ಮೇಲೆ ಏನಿದೆ
merit may yes. My lord, the writ petition is also dismissed on a delay, my lords. On a ground that, my lord, the order which is questioned in a writ petition is, my lord, past last 6.5 years delay in filing the writ petition. May I make submissions of the, my lord, this is the case wherein, my lord, the tribunal at the time of considering 33 2B application,
33 2B of ID.
ID Act, my lords, wherein, my lord, we have sought approval of the, my lord, dismissal of the employee. At the time of considering that application, my lord, hold issue number 1 negative, and my lord, immediately, my lord, IA has been filed for interim payment of wages, my lords. That IA came to be allowed. Now, my lords, let me kindly see, in the entire ID Act, there is no any such, my lord, procedure where, my lord, interim wages can be given to the employees.
But there is one judgment.
I'll come.
There is one judgment.
Mysore Bank. Mysore.
There is one judgment.
Yes.
Where interim order can be granted. Interim orders are now granted after
I'll come
Bhopal
to
gas
that. I'll
treasury
come to
matter.
that. It is there, my lord, in the Industrial Dispute Standing Orders Act, wherein I'll come to that. In the act itself, section 13 says this act is not applicable to the KSRTC, and that is there is proviso in the act itself. Now that act which
You have to stop after one sentence ಆದ್ಮೇಲೆ ನಿಲ್ಬೇಕು ನಾವು ಪ್ರೊಸೆಸ್ ಮಾಡೋದು ಬೇಡವಾ
sorry next
1946 act is not applicable.
ಅಲ್ಲ that Standing Orders Act is not
Act is 1946 act ಅದು.
ಹೌದು.
It is not
Only-
applicable to.
My lord, why that standing order is not applicable to those industries
Covered under
which,
the better disciplinary, better service conditions under the.
those who are not adopted those standing orders, my lords. There is a standing orders which certain welfare beings has to be taken place and adopted in their regulations. The chartered of
Standing orders act ಕೊಡಿ. Model standing orders apply ಆಗಲ್ವಾ?
ಇಲ್ಲ ನಮ್ separate
But the standing orders
we are
should
having
apply
our
on their
we are
own.
having our own separate independent standing orders which has been approved and
ಅದರಲ್ಲಿ ಇಲ್ಲ ಅಂತನಾ ಅಂತ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ.
ಅಲ್ಲ ಅದು I'll take it to my lord's kind permission to that act itself where what is that 10A says in that standing orders. 10A, my lords, which says
10 ಇದೆಯಾ ಸೆಕ್ಷನ್?
10A of the act says that, my lord, interim orders maintenance can be given
10A ಇದೆಯಾ ಸೆಕ್ಷನ್ ಇದೆಯಾ 10
ಹೌದು, ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಆರ್ಡರ್ಸ್
10A
1001.
payment of subsistence
Yes,
allowance.
subsistence allowances, that they say that only if my lords, issue number 1 is hold negative. ತೆಗೆದುಕೊಡು. 1000 ಎಷ್ಟು? 904. And section 13, my lords.
10A3
10A3.
3.
Notwithstanding anything contained in this foregoing provisions of this section, where provisions relating to payment of subsistence allowance under any other law for the time being in a force of in any state or
More
more
beneficial.
beneficial than the provisions.
ಎಲ್ಲಿ ತೋರಿಸಿ more beneficial ಇದ್ದಿದ್ದು.
Now, may I take my lord's kind effect, conditions, my lords, 12 may kindly be.
There are judgments. See, two things.
Yes, my lords.
It goes against you now.
I'll convince my lords.
So there is, if you have regulations which are more beneficial to the workman, they will be applicable.
No,
Not
my lord.
absence of this one, the very provision of this act.
Yes, my lords.
This act is made to protect those employees in the absence of any, not only in the absence of contra provision, your provision should provide for a better condition. ಏನಿಲ್ಲ.
My lords, may I take my lords, there is a provision which says that, my lords, delegation of power, section 13 interpretation, 14, my lord. 14 and
Section?
13. There is a separate provision which says that the act is not applicable to the, my lord, KSRTC, road transport and other things.
13B.
13B,
Okay,
ಅಲ್ಲ?
okay. Act not to apply to certain industry establishment. Nothing in this will apply to industry establishment. So far, been employed persons to whom the professional.
Mark ಮಾಡ್ಬೇಕಿತ್ತು ನೋಡಿ.
CCA rules apply ಆಗದಿದ್ರೆ, revised leave rules, civil service regulations, civil defense,
13B, my lords, sorry.
the railway establishment code, or any other rules or regulations that may be notified in this behalf by the appropriate government in the official gazette. Antorsi.
Yes. My lord, nothing in this act shall apply to
We have
an
read that now.
industrial establishment so far as.
We have read that now. Unless there is a notification published in the official gazette, a notification ಬೇಕಾಗ್ತದೆ. Road Transport Corporation Act signs. Then 45 Road Transport Corporation Act issue.
ಇವಲ್ಲ.
96(7) KLJ.
Yes, ma'am. That, my lord,
ಅದು ನೋಡ್ಕೊಂಡ್ಬರ್ಬೇಕು. ಅದು already there is a division bench decision
yes,
in your
division,
favor.
I'll come, division bench has, my lord, relied 3 decisions of the Supreme Courts where.
They are in your favor only. You want to still argue?
Judgments ಇದಲ್ಲ ಅಷ್ಟಿತ್ವಲ್ಲ. Okay, sorry. Yes, I'm having this.
Notice ಹೋಗಿ ಬರ್ರಿ.
ಎಲ್ಲ ಕೆಳಗಿಟ್ಕೊಂಡಿನಿ.
ಇದು ಚೇಂಜ್ ಇದೆ. ಓಕೆ. Yes. 42. 42. ನೋಡಪ್ಪ.
ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಮಾಡದ the request of learning counsel for the applicant. This next week, at least next immediately after vacation.
ಅಲ್ಲ ಫರ್ದರ್ ರೀಡಿಂಗ್ ಇಲ್ಲೇ ಮುಗಿಸು.
Further admission.
42.
Along with number signs.
After vacation.
Take care.
Yes, sir. Thirty-one.
It is for further hearing. The lordship has passed an order in respect of visitation rights. From last 3 weeks, every Sunday he is going to Tapavan and waiting 1 hour or 2 hours therein, but they are not at all coming. First 3 Sundays she came with the child. I have submitted a memo also, but thereafterwards she stopped. Every Sunday he is going there and waiting for 1 or 2 hours and coming back.
ಈಗ ಆಲ್ಟರ್ನೇಟಿವ್ ಹೇಳಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ನಾವು ಹಿಂಗಿದ್ದಾಗ ನಾವೇನ್ ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳಿ ಆ ರೀತಿ ಆರ್ಡರ್ ಮಾಡಕ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೇವೆ ನಾವು. ಈಗ ಸಿ ಪೇಮೆಂಟ್ ಬೇಕು ಅಂದ್ರೆ ಪೇಮೆಂಟ್ ಕೊಟ್ರು ಅವ್ರು. ವೆರಿ ನೆಕ್ಸ್ಟ್ ಡೇ ಹಿ ಮೇಡ್ ದ ಪೇಮೆಂಟ್. ವಾಟ್ ಈಸ್ ದಟ್ ರೆಗ್ಯುಲರ್ಲಿ ಪೇಯಿಂಗ್?
Up to end of the August we have paid.
ಸೆಪ್ಟೆಂಬರ್ ಕೊಟ್ಟಿಲ್ಲ. ಇನ್ನು ಸೆಪ್ಟೆಂಬರ್ ಅಕ್ಟೋಬರ್ನೇ ಕೊಡ್ಬೇಕಾ?
ಅಕ್ಟೋಬರ್ ಕೊಡ್ಬೇಕು.
ಸೆಪ್ಟೆಂಬರ್ ಹೆಂಗ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ? ಇನ್ನೂ ಮುಗುದಿಲ್ಲ ಸೆಪ್ಟೆಂಬರ್. ಆಗಸ್ಟ್ ಕೊಟ್ಟಿಲ್ವಾ? ಆಗಸ್ಟ್ ಕೊಟ್ಟಿರಾ?
ಕೊಟ್ಟಿದೆ.
ಕೊಡ್ಬೇಕಾ?
20,000 extra we have paid.
ಕೊಟ್ಟಿದ್ದಾರಂತ.
ಕೊಟ್ಟಿದೆ 20,000 extra we have paid. His calculation was there.
ಅದು ಹೋಗ್ಲಿ, ಮಗುನ್ ಯಾಕೆ ವೈ ಆರ್ ಯು ಹೋಲ್ಡಿಂಗ್ ದಟ್ ಚೈಲ್ಡ್ ಫಾರ್ ದ ರ್ಯಾನ್ಸ್ಯಾಕ್? ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಟುಮಾರೋ ಕೀಪ್ ಫಾರ್ ಪ್ರೆಸೆಂಟ್ ಟುಮಾರೋ. ಕಾರ್ವಾರ್ ಯಾಕೆ? A day after.
It is a case of restitution of conjugal rights. In the statement of objection, she admits that she is ready and willing to join. But now,
ಗಂಡ ಅದ್ ಬಿಡಿ. ಈಗ ದುಡ್ಡು ಏನ್ರಿ ಎಷ್ಟು ಇರಲೆವೆಂಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್. ಈಗ ದುಡ್ಡು ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಅವ್ರು, ಕರೆಕ್ಟಾ? ಆರ್ಡರ್ ಮಾಡಿದ ಪ್ರಕಾರ 20,000 ಎಕ್ಸ್ಟ್ರಾ ಕೊಟ್ಟಾರುತ್ತೆ. ನೀವು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಡಿ ಅಲ್ರಿ. ಮಗುನ್ ಯಾಕೆ ತಂದೆಗೆ ಮಗುನ್ ಯಾಕೆ ತೋರಿಸ್ತಾ ಇಲ್ಲ? ನಾಡ್ದು ಬರಕ್ ಹೇಳಿ. ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಫಸ್ಟ್ ಆಫ್ parties are to be present before the court. Mother to bring the child as well. ನಾಳೆ ಶಾಲೆ ಇರುತ್ತೆ ಅದಕ್ಕೆ ನಾಡ್ದು. ಏನ್ ಕಾರವಾರ ಅಂದ್ರೆ ಏನು? ಅದೇನು ಅಲ್ಜೀರಿಯಾದಲ್ಲಿ ಇಲ್ಲ, ಇಲ್ಲೇ. ಬರಕ್ ಆಯ್ತು. ಫ್ರೈಡೆ ಬರಕ್ ಹೇಳಿ. ಫ್ರೈಡೆ ಬರ್ಬೇಕು. Mother to come, appellant mother to be present before the court along with the ward. First off, absence may result into discontinuation of the maintenance order. Okay. Ha. 36 ಪ್ರೆಸೆಂಟ್ ಇದ್ದಾರಾ? ಕರೀರಿ. ಮೆಟ್ರಿಮೋನಿಯಲ್ ಅಧ್ಯಯನ ಮಾಡ್ಲಿಕ್ಕೆ ಟೆಂಪಲ್ಗಳು ಬೇಕು, ಮಠಗಳು ಬೇಕು, ಅದರಲ್ಲಿ ವಿದ್ಯಾರ್ಜನೆ ಮಾಡ್ಕೋಬೇಕು, ದಾಸೋಹಕ್ಕೆ ಬೇಕು. ಆದ್ರೆ ಈ ಡಿಸ್ಪ್ಯೂಟ್ ಬಂದಾಗ ನಾವ್ ಅಲ್ಲಿ ಹೋಗ್ಬಾರ್ದು ಅಂತ ವಾದ ಮಾಡೋದಿದೆಯಲ್ಲ, ಅದನ್ನ ನಾವು ಒಪ್ಪಲ್ಲ. ಎನಿವೆ ನೀವ್ ಹೇಳ್ರಿ, ನೀವ್ ಯಾರನ್ನ ಹೇಳ್ತೀರಿ ಅಲ್ಲಿ ಕಳ್ಸೋಣ ಅಂತ. ಒಂದ್ ಕಡೆ ಮಾತಾಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಎಷ್ಟೋ ಪ್ರಾಬ್ಲಮ್ಸ್ಗಳಿಗೆ ಕುತ್ಕೊಂಡು ಶಾಂತವಾಗಿ ಕುತ್ಕೊಂಡು ಮಾತಾಡಿಬಿಟ್ರೆ ಸೊಲ್ಯೂಷನ್ ಸಿಕ್ಬಿಡ್ತದೆ. ಎಷ್ಟೋ ಜೀವನದ ಅನೇಕ ಸಮಸ್ಯೆಗಳಿಗೆ ನಾವು ಈಗೋ ಮೇಲೆ ನಿಂತ್ಕೊಂಡ್ರೆ ಆಗಲ್ಲ. ಒಂದ್ ಸ್ವಲ್ಪ ಈಗೋ ಡೈಟಿಂಗ್ ಮಾಡಿ, ಈಗೋ ಬಿಟ್ಟು ಹಾಕಿ ನಾವು ಒಂದ್ ಕಡೆ ಹೋಗಿ, ಅಲ್ಲಪ್ಪ ಭಗವಂತ, ನಾವೆಲ್ಲ ನಿನ್ ಮಕ್ಕಳು, ಏನೋ ನಮಗೆ ಸಮಸ್ಯೆ ಆಗಿದೆ, ಒಂದ್ ದಾರಿ ತೋರಿಸು, ಬಂದೇವಿ ನಿನ್ನ ಹತ್ರ ಅನ್ಕೊಂಡು ನೀವು ಒಂದು ಒಳ್ಳೆ ಒಂದು ಟೆಂಪಲ್ಗೆ ಹೋಗಿ ಪ್ರಾರ್ಥನೆ ಮಾಡ್ರಿ ದೇವರನ್ನ. ಎಲ್ಲೋ ಒಂದು ಸೊಲ್ಯೂಷನ್ ಸಿಗ್ತದೆ. ಅಲ್ಲಿ ದೇವ್ರು ಇದ್ದಾನೋ ಇಲ್ಲೋ ಈ ಜಿಜ್ಞಾಸೆ ಬಿಟ್ಟು ಹಾಕಿ ನೀವು ಲ್ಯಾಬೊರೇಟರಿಯಲ್ಲಿ ಇದರಲ್ಲಿ ಇದನ್ನೆಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ. ಆದ್ರೆ ಜೀವನದಲ್ಲಿ ಕೆಲವು ನಂಬಿಕೆಗಳು ಬೇಕಾಗ್ತದೆ. ಡಿ.ವಿ.ಜಿ ಹಂಗೆ ಬರ್ದಾರೆ. ಸ್ವಾಮಿ ಜಗದಾತ್ಮಾನಂದರು ಬದುಕಲು ಕಲಿಯಿರಿ ಅನ್ಕೊಂಡು ಪುಸ್ತಕದಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಎಷ್ಟೋ ರೋಗಗಳಿಗೆ ವಿಲಿಯಂ ಓಸ್ಲರ್ ಅನ್ನುವಂಥ ಒಬ್ಬ ಗ್ರೇಟ್ ಡಾಕ್ಟರ್ ಬರೀತಾನೆ, ಫೇತ್ ಹೀಲ್ಸ್ ನಾಟ್ ದ ಮೆಡಿಸಿನ್. ನಂಬಿಕೆ ಆರಾಮ್ ಮಾಡಿಬಿಡ್ತದೆ. ಅದೇ ರೀತಿ ಇದಕ್ಕೆ ಸೊಲ್ಯೂಷನ್ ಸಾಧ್ಯ ಇದೆ, ನಾವು ಹುಡುಕೊಳ್ತೇವೆ. ಮಗು ಬೇರೆ ಇದೆ, ಯು ಹ್ಯಾವ್ ಎ ಪ್ರಿಟಿ ಚೈಲ್ಡ್, ನೋಡಿ ಎಷ್ಟು ಒಳ್ಳೆ ಮಗು ಇದೆ. ಆ ಕಾರಣಕ್ಕೆ ನಿಮ್ಮಿಬ್ಬರನ್ನು ಅದು ಒಂದು ಇಬ್ಬರ ನಡುವೆ ಒಂದು ಕೊಂಡಿ ಆಗ್ಬೇಕು, ಬ್ರಿಡ್ಜ್ ಆಗ್ಬೇಕು. ಬರೀ ನಿಮ್ ಜೀವನ ಅಷ್ಟೇ ಅಲ್ಲ, ನಮ್ ಜೀವನ ಅಷ್ಟೇ ಅಲ್ಲ, ಮುಂದಿನ ಮಕ್ಳು ಇರ್ತಾರೆ ಅಲ್ವಾ, ಅವ್ರ ಬಗ್ಗೆನೂ ಮಾಡ್ಕೊಳೋದು ಬೇಡವಾ? ಬರೀ ನಮ್ದೊಂದು ಆಗ್ಬಿಟ್ರೆ ಮುಗಿದು ಹೋಗ್ಬಿಡ್ತಾ ಹಂಗಾರೆ? ಆ ರೀತಿ ಇರಲ್ಲ. ನಮ್ಗೆ ಅವರೊಂದು ಭಗವಂತ ಒಂದು ಕೊಂಡಿ ಕೊಟ್ಟಿರ್ತಾನೆ. ಗಂಡ ಹೆಂಡತಿ ನಡುವೆ ಸ್ವಲ್ಪ ಅಟ್ರಾಕ್ಷನ್ ಕಡಿಮೆ ಆಗ್ತಾ ಆಗ್ತಾ ಹೋದಂಗೆ ಅದು ಗ್ಯಾಪ್ ತುಂಬಲಿಕ್ಕೆ ಭಗವಂತ ಮಕ್ಕಳು ಕೊಡ್ತಾನೆ ಅಂತ ಬರೀತಾನೆ. ಯಾರು ಫೇಮಸ್ ಲೆಬನೀಸ್ ಆಥರ್, ಐ ಫಾರ್ಗಾಟ್ ಹಿಸ್ ನೇಮ್, ಖಲೀಲ್ ಗಿಬ್ರಾನ್ ಸೇಸ್ ದಿಸ್. ಭಗವಂತ ಇಬ್ಬರ ನಡುವೆ ಒಂದ್ ಕಡೆ ಬದುಕಲಿ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ಮಕ್ಕಳನ್ನು ಕೊಡ್ತಾನೆ ಅಂತ ಹೇಳ್ತಾನೆ. ಒಂದ್ ಕಡೆ ಕೂತ್ಕೊಳ್ರಿ, ಹೋಗಿ ನೀವೇ ಚೂಸ್ ಮಾಡಿ ಯಾರ ಹತ್ತಿಗೆ ಹೋಗ್ಬೇಕು ಅಂತ ಚೂಸ್ ಮಾಡಿ. ಅಂದ್ರೆ ನಾವೇನು ಡಿಸಿಷನ್ ಅವ್ರಿಗೆ ಕೊಡ್ರಿ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ, ನೀವು ಅಲ್ಲಿ ಒಂದು ಪ್ರಯತ್ನ ಮಾಡ್ಕೊಂಡು ಇಲ್ಲಿ ಬನ್ನಿ, ಮುಂದೆ ನಾವು ಡಿಸೈಡ್ ಮಾಡೇ ಮಾಡ್ತೀವಿ. ನಾವು ನಮ್ಮ ಅಧಿಕಾರ ಬಿಟ್ಕೊಡ್ತಾ ಇಲ್ಲ. ಓನ್ಲಿ ಏನಪ್ಪ ಆಲ್ಟರ್ನೇಟಿವ್ ಡಿಸ್ಪ್ಯೂಟ್ ರೆಸಲ್ಯೂಷನ್ ಇದೆಯಲ್ಲ, ಆಲ್ ಏಜೆನ್ಸೀಸ್ ಕ್ಯಾನ್ ಬಿ ಎಂಪ್ಲಾಯ್ಡ್ ಬೈ ಅಸ್. ಆಲ್ ಏಜೆನ್ಸೀಸ್ ಯಾವುದು ಡಿಸ್ಪ್ಯೂಟ್ ಅನ್ನು ರಿಸಾಲ್ವ್ ಮಾಡ್ತದೆ, ಹಾಗೆ ನಿಮ್ಗಿಬ್ಬರಿಗೂ ಅನಿಸ್ತದೆ, ಅಂಥ ಏಜೆನ್ಸಿಗೆ ನಿಮ್ಮನ್ನು ಕಳಿಸುವಂಥ ಅಧಿಕಾರ, ಕರ್ತವ್ಯ ಎರಡಿದೆ ನಮಗೆ. ಬರೀ ಅಧಿಕಾರ ಅಲ್ಲ, ನಮ್ಮ ಕರ್ತವ್ಯ ಇದೆ. ನೀವಿಬ್ರು ಕೂತ್ಕೊಂಡು ಹೋಗಿ ಮಾತಾಡಿ. ಯಾರ ಜೊತೆ ಹೋಗ್ತೀರಿ ಹೇಳಿ? ನೋಡಿ, ಪಾರ್ಟಿ ಜೊತೆ ಮಾತಾಡ್ಕೊಂಡು ವಾದ ಮಾಡಬಾರ್ದು. ನೋಡೋಣ ಪಾರ್ಟಿಗಳು ಏನಂತಾರ, ಆಮೇಲೆ ನಿಮ್ಮ ವಾದ ಬಂದಾಗ ನಾವು ಕೇಳ್ತೀವಿ. ಅವ್ರು ಹೋಗಂಗಿದ್ರೆ ನಾವು ಒತ್ತಾಯ ಮಾಡ್ತೇವೆ ಅಂತ ಇಟ್ಕೋಬೇಡಿ, ನಿಮ್ಮಿಬ್ಬರಿಗೂ ಬಿಟ್ಟಿದ್ದು. ನೀವು ಒಂದ್ ಕಡೆ ಹೋಗ್ಕೊಂಡು ಮಾಡಂಗಿದ್ರೆ ಉಪಯೋಗ ಆಗತ್ತದ. ಆಗಿದೆ ಅದು. ನಾವ್ ಇದು ಹಂಗೆ ಹೇಳ್ತೀನಿ ತಿಳ್ಕೊಬೇಡಿ. ನಮ್ಮ ಹೊತ್ತಿಗೆ ಎಂಪಿರಿಕಲ್ ಡಾಟಾ ಇದೆ. ಈಗ ನಮಗೆ ಸಾಲ್ವ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ಲಿದ್ದನ್ನ ಎತ್ತರದ ವ್ಯಕ್ತಿಗಳು ಸಾಲ್ವ್ ಮಾಡಿದ್ದಾರೆ. ಪ್ರೊಫೆಸರ್ ಕೃಷ್ಣೇಗೌಡ ಮೈಸೂರು, ಅವ್ರಿಗೆ ಕಳಿಸಿದ್ ಸಾಲ್ವ್ ಆಗಿದೆ. ಒಬ್ಬ ಮೌಲ್ವಿಗೆ ಒಂದು ಮ್ಯಾಟರ್ ಅನ್ನು ಕಳಿಸಿದ್ವಿ, ಸಾಲ್ವ್ ಆಗಿದೆ. ಮೊನ್ನೆ ಇನ್ನೊಂದು ಕೇಸನ್ನ ನಮ್ಮ ಗವಿಸಿದ್ದೇಶ್ವರ ಸ್ವಾಮೀಜಿಯವ್ರಿಗೆ ಕಳಿಸಿದ್ದೀವಿ. ಮೋಸ್ಟ್ಲಿ ಸಾಲ್ವ್ ಆಗಂಗ್ ಕಾಣ್ತದೆ ಲಕ್ಷಣಗಳನ್ನು ನೋಡಿದ್ರೆ. ಜನ ಏನ್ರ ಮಾತಾಡ್ಲಿ, ಅದ್ರ ಬಗ್ಗೆ ತಲೆ ಕೆಡ್ಸೋಬೇಡ್ರಿ. ನಿಮ್ ಜೀವನ ಅದು. ಆ ಕಮೆಂಟ್ ಮಾಡೋರನ್ನ ಬಿಟ್ಟು ಹಾಕಿ, ಅವ್ರು ಯಾರೂ ನಿಮ್ ಹತ್ರ ಬರಲ್ಲ. ಅವ್ರು ಆರಾಮ್ ಐಷಾರಾಮಿಯಲ್ಲಿ ಕುತ್ಕೊಂಡು ಕಮೆಂಟ್ ಮಾಡುವಂಥವ್ರು. ನಿಮ್ ಜೀವನ ನೋಡ್ಕೊಳ್ಳಿ, ನಿಮ್ ಜೀವನ ನೋಡ್ಕೊಳ್ಳಿ. ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು, ಎಲ್ಲಿ ಹೋದ್ರೆ ಸೊಲ್ಯೂಷನ್ ಸಿಗ್ತದೆ. ನಿಮ್ ಸಂಬಂಧಿಕರು ಇರ್ತಾರೆ, ಯಾರೋ ನಿಮ್ಮ ಮನೆತನದ ಗುರುಗಳು ಇರ್ತಾರೆ, ಅಥವಾ ಒಳ್ಳೆ ಟೀಚರ್ ಇರ್ತಾರೆ. ಏನೇನೋ ಕಾರಣಕ್ಕೆ ನಮ್ಗೆ ಅವ್ರ ಮೇಲೆ ನಂಬಿಕೆ ಇರ್ತದೆ. ಯಾರಾದ್ರೂ ಹೇಳಿ ಒಳ್ಳೆಯವರು, ಅಲ್ಲಿ ಹೋಗಿ ಬನ್ನಿ. ಯಾರು ಹೇಳಿ, ಒಬ್ರು ಯಾರ ಹೆಸರು ಹೇಳಿ, ಇಬ್ರು. ಹೇಳಮ್ಮ. ಮಾತಾಡ್ಬೇಕು. ಮಾತಾಡ್ದಂಗಿದ್ರೆ ನಾವೇ ಬೇರೆ ಮಾತಾಡೋದಾಗ್ತದೆ.
Whatever is suitable for him should be fine.
Yeah.
Petitioner ಯಾವ್ದು suitable ಇದೆ, we can go there.
ಇಬ್ರಿಗೂ ನೋಡ್ರಿ, ಅವ್ರಂತಾರೆ ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕು ಅಲ್ಲಿ ಬರ್ತೇವೆ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ ಹೆಣ್ಣಿನ ಕಡೆಯವರು. ನೀವೇನ್ ಮಾಡ್ತೀರಿ? ಅಗ್ರಿಕಲ್ಚರ್. ಓಕೆ, ಒಳ್ಳೇದು. ಈಗ ಯಾರ ಹತ್ತಿಗೆ ಹೋಗ್ತೀರಿ? ಮೀಡಿಯೇಷನ್ ಸೆಂಟ್ರು ಇದೆ, ಅದು ಮೀಡಿಯೇಷನ್ ಎಕ್ಸ್ಪರ್ಟ್ಸ್ ಇರ್ತಾರೆ, ಅಲ್ಲಿಯೂ ಪ್ರಯತ್ನ ಮಾಡ್ಬೋದು.
2-3 rounds in mediator center was tried, my lord. Whatever is suitable for him, whatever his preference of thing should be fine.
ಹೇಳಿ, ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಕೊಂಡು ಅಂತೀರಾ? ಆಗಲ್ಲ.
ಇಂದ ನಮ್ಗೆ ನುಗ್ಗಿ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ನಾವು ಡೈವರ್ಸ್ ಕೇಸ್ ಹಾಕಿಲ್ಲ. ಡೈವರ್ಸ್ ಕೇಸ್ ಹಾಕೊಳ್ಳೋಗ ಇವರು 498 ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ 6 ತಿಂಗಳು. ಮತ್ತೆ ಈಗ ಡ್ರೈವಿಂಗ್ ಕೋರ್ಟ್ ಮ್ಯಾಗ್ರಿ ನಾವು ಕೇಸ್ ಮಾಡಿದ್ವಿ ಅದೇ ಸ್ವಲ್ಪ ಬರ್ತೀವಿ ಯಾನ್ ನಕ ಅದ್ರಾಗ ಹಾಕ್ಬೇಕು ವಕೀಲ ಚಲೋ ಇಲ್ಲ ನಮ್ದು ಕೇಸ್ ಬಂದಿದೆ ಅದ್ರಾಗ ಅಭ್ಯಾಸ ಇಲ್ಲ ಹಿಂಗಾಗಿದೆ ನಮ್ಗೆ ಇವ್ರು ಸಿಂಗಾಕ ಒಂದು ಅಣ್ಣಾಗಿಲ್ರಿ ಮತ್ ಸಾಕಲ್ಲ ಇವ್ರು ಬಂದಿದ್ದು ಯಾನ್ ಮಾಡೋಕೆ ಅದೇ ಜಗಳ ಸುಖಾಯ ಮಾಡೋದು ನಮ್ದು ಇವ್ರಿಗೆ ಏನಾಗ್ತದೆ ಯಾನ್ ಹೋಗ್ತದೆ ಅವಾಗ ಹೋಗಿ ಬೈತಾರೆ ಅದೇ ಜಗಳ ದೊಡ್ಡ ದೊಡ್ಡ ಮಂದಿ ನಗ ಹಾಕಿದೀವ್ರಿ ಒಂದ್ ದಿವಸ 2 ದಿವಸ ಸಿಲಿಂಡರ್ 3 ದಿವಸ ಹಂಗೆ ಮತ್ತೆ ಇದ್ರ ಮುಂದೆ
ಹಾಗಾದ್ರೆ ಈಗ ಆಗಲ್ಲ ಇದನ್ನ ಯಾವ ಇಯರ್ ಇದೆ 23 yes in the third week of October on request come on suggestion for mediation having not been taken by the parties okay yes next
I accept notice for both the respondents. I accept notice. Delay shall be condoned. And delay shall be condoned. 18 days delay. Instructions, my lord, by 25th they are going to release the. If he goes and communicate that they are ready to release the. In spite of a request having been made before the learned single judge, by I have instructed the officer to release, but the appellant did not visit it. But he has made an allegation again that he has, though he has visited, none of the officers have tried to release the vehicle, and now he is claiming the only ground damages. Since my lord, the second prayer in the writ petition was claiming damages against the officer.
The trial court has directed the respondent to release my vehicle. I have gone there, I have asked them to release my vehicle, they have not released.
Please ಮಾಡಿದ್ದೇವೆ ಅಂತ ಹೇಳ್ತಾರೆ
ಅಲ್ಲ ನಾಳೆ 25ಕ್ಕೆ 25th
ಇಲ್ಲಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ
Since last 2 years
ಈ ವೆಹಿಕಲ್ ತೊಳಿ ಮೊದಲ ಆಮೇಲೆ ಮುಂದೆ ಅದನ್ನ ಡಿಸೈಡ್ ಮಾಡೋಣ ಇನ್ನೊಂದು ಡೇಟಿಗೆ ವೆಹಿಕಲ್ ಆರು ತೊಳಿ ಮತ್ತೆ ಅದು ತೊಗೊಂಡೋಗಿ ರಿಪೇರಿ ಮಾಡಿಸ್ಕೊಂಡು ಅದನ್ನ ಇಟ್ಕೊಂಡ್ರೆ ನಾಳೆ ಅದನ್ನ ಇಟ್ಕೊಂಡು ಕ್ಲೇಮ್ ಹಾಕ್ಲಿಕ್ಕೆ ಬರ್ತದೆ ಕಾಲ್ ಆಫ್ಟರ್ 4 weeks ನೆಕ್ಸ್ಟ್
amount deposit versus and they need to deposit before the bank because the other DRT is not that's the reason.
ಸತ್ಯವತಿ ಕೇಸ್ DRT ಹೋಗಬೇಕು
DRT has granted once and within 6 months on the 2nd of October deposit before the amount
ನಾವು ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕು ಪಬ್ಲಿಕ್ ಮನಿ ಅದು
that's deposit before this put my same fund notes I will deposit before the bank.
ಅಲ್ಲೇ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಇಲ್ಲಿ ಮಾಡಿದಾರ
at the time of granting the interim order he might will deposit money single judge ಮುಂದೆ ಅದಕ್ಕಷ್ಟೇ my lord one submission
ಮಾಡಿದ್ದಾರೆ ಡೆಪಾಸಿಟ್ the court shall be transferred to so and adjust to the loan account of the petitioner. It's also made clear that the order will not come in the way of respondent.
I'm sorry order ಇದೆ
So and so ಏನ್ ತಪ್ಪಿದೆ ಇದ್ರಾಗ ಆರ್ಡರ್ ನಲ್ಲಿ ಇದು more convenient. We would not have granted that order had we sat single. ಅಷ್ಟೇ ಯಾರು ರೆಸ್ಪಾಂಡ್ ಬೇರೆ ಬ್ಯಾಂಕ್ನಿಗೆ ಯಾರು ಇರ್ತಾರೆ ಹೇಳಿ
ಬ್ಯಾಂಕ್ಸ್
ಇಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ ಅಮೌಂಟ್ ಅನ್ನ ಅಲ್ಲಿ DRT ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೇವೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು ಅಲ್ಲಿ ಟ್ರಾನ್ಸ್ಮಿಟ್ ಮಾಡಿದ್ರ ಅದು
ಇಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್
ಕೇಳ್ಕೊಂಡು ಹೇಳ್ತೀರಾ
ನಾಳೆಗೆ
ಡೇ ಆಫ್ಟರ್
ಪ್ಲೀಸ್ so and so notice
For 1 and 2, I accept notice. 1 and 2, I accept.
Six of immediate control order, where priority has been given to the applicants who have applied for the license or fair shop. That came to be original order passed by the joint act. My society is registered. PDS control order. 2016 order, yes. 92 order, ಯಾವುದು?
16.
1992 is the original order, it is being amended 2016 and 18 also, there is some amendment. My society is registered under the Sauharda Act. Sauharda. Yes, sir. The contesting respondent, private respondent society is registered under the Cooperative Societies Act. ಅವು ಎರಡು ನಡುವೆ ಡಿಫರೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡ್ಯಾನ ನಾನು. It is affirmed by the division bench. Section 80P of the Income Tax Act ಕೆಳಗಡೆ ಈ ಇಶ್ಯೂ ಹೇಳ್ತು. ತೆಗಿರ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ಎಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಓದಬೇಕು ಅಂದ್ರೆ ಗೊತ್ತಾಗ್ತದೆ, ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಅದು ಒಂದು ಸಿಂಗಲ್ ಓದಿದ್ರೆ ಗೊತ್ತಾಗಲ್ಲ. Have you brought that judgment? Bring that judgment. First one, go to library and bring. The division bench has affirmed that judgment. Section 80P of Income Tax Act ನಲ್ಲಿ ಬಂದಿದೆ judgment. Huh? Canada increment rules. ಅದು ಯಾವಾಗ ಕೊಡ್ತಾರೆ ರೂಲ್ಸ್ ಏನಿದೆ ತೋರಿಸಿ.
I have affects my lord amended rules where note this benefit has been withdrawn.
Page
number notes. Annexure A is 17. Page number
43.
Type copy. These rules may be called as Kannada Service and Kannada language examination amendment rules. They shall come into force on the date of so and so. Omission of Rule 6 of Karnataka. This addition was made in the year 1987.
87.
Because they much prior to that. My appointment is in the year 1981.
ನಿಮ್ಗೆ ಎಲಿಜಿಬಿಲಿಟಿ ಯಾವಾಗ ಬಂತು ಅದ್ರ ಕೆಳಗಡೆ? ಆ ರೂಲ್ಸ್ ಕೆಳಗಡೆ when you got the eligibility?
I got eligibility from the date of my appointment itself. And the
ಯಾವ ರೂಲ್? ಟೆಕ್ಸ್ಟ್ ಆಫ್ ದ ರೂಲ್ ಓದಿ. Which is that rule?
Rule 5 which says that which says that I have to make an application intimating the authority saying that I have got the eligibility under Rule 5 since I have passed an SSLC examination in Kannada language. It is a mandate from the part whoever passes an exam they are expected for this increment.
Notice told judgment is a justice ಅದಲ್ಲ ಎನ್ ವೆಂಕಟಾಚಲ ಅವ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತನಕ ಹೋಗಿತ್ತು ಮ್ಯಾಟ್ರು. ILR 94 ಕರ್ನಾಟಕ ಅಂತ ಬರ್ಬೇಕು.
Reason for rejection by the tribunal at the time of initial appointment, Lord, on her pay scale, already Kannada increment has been granted.
It was granted to.
Granted. So
merge ಆದ್ರೆ granted ಆದ್ರೆ merger ಆಗ್ತದೆ. So scale ಅನ್ನೇ
ಮಾಡ್ತಾರೆ. Please.
ಮರ್ಜ್ ಮಾಡಿದ್ರು ಅಂದ್ರೆ ಸಿಗಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡ್ಯಾರ. ಜಸ್ಟಿಸ್ ಎನ್ ವೆಂಕಟಾಚಲ ಅವರು ತಮ್ಮ ಪ್ಲೀಸ್ ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ ಪ್ಲೀಸ್ ಅದಕ್ಕೆ ಬರಲ್ಲ ಅಂತ ಹೇಳಿದಾರ ಅವರು. ನೋಡಿ ಸಿ ನೋಟಿಸ್ ಲಿಸ್ಟೆಡ್ ವರ್ಕ್ಸ್ ಆಫ್ ನೋಟಿಸ್. ನೆಕ್ಸ್ಟ್ yes. ಏನು ಯಾವ ಕಾರಣಕ್ಕೆ ಮಿಸ್ಟರ್ ಕುಲಕರ್ಣಿ ಸಸ್ಪೆನ್ಷನ್ ಮಾಡಿದ್ದು? ಎಸ್ ಹೇಳಿ ತೋರಿಸಿ. ಸೀರಿಯಸ್ ಆರ್ ನಾಟ್ ಇಸ್ ಅ ಮ್ಯಾಟರ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್. 54
ಪ್ರಸ್ತುತ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಅನವಶ್ಯಕವಾಗಿ ಆಡಳಿತವನ್ನು ತೊಂದರೆ ಕೊಡುವುದು ಮತ್ತು ಸಹಿಷ್ಣು ವಾತಾವರಣವನ್ನು ಹಾಳು ಮಾಡುವುದು ಎಲ್ಲಾ ವಿಚಾರ ನಾನು ಹೇಳಿದ್ದು ಕೇಳಬೇಕು. ವೇಳೆಗೆ ಸರಿಯಾಗಿ ಕಾಲೇಜಿಗೆ ಬರದೇ ಇರುವುದು ಮತ್ತು ಕೆಲವು ವಿದ್ಯಾರ್ಥಿಗಳು ಹಿತಾಸಕ್ತಿ ಬೆಳೆಸಿಕೊಳ್ಳುವುದು, ಕಾಲೇಜಿನಲ್ಲಿ ನಡೆಯುವ ಪರೀಕ್ಷೆಗಳ ಬಗ್ಗೆ ಉತ್ತರ ಪತ್ರಿಕೆಗಳನ್ನು ವಿದ್ಯಾರ್ಥಿಗಳಿಂದ ಮೌಲ್ಯಮಾಪನ ಮಾಡಿಸುವುದು, ಕ್ರೋಢೀಕರಿತ ಅಂಕಪಟ್ಟಿ ವಿದ್ಯಾರ್ಥಿಗಳ ಕಲಿಸುವುದು, ಇದನ್ನು ಪ್ರಶ್ನಿಸಿದರೆ ಅಸಂವಿಧಾನ ಅತಿ ಉಪನ್ಯಾಸದ ನೇಮಕಾತಿಯಲ್ಲಿ ಪ್ರಭಾವ ಬೀರುವ ಪ್ರಯತ್ನಿಸುವುದು ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮವನ್ನೇ ಪೂರ್ಣ ದೋಷವನ್ನು ಪ್ರಚಾರ ಮಾಡುವುದು, ಪ್ರಾಚಾರ್ಯ ಸಭೆಗೆ ಸಮಯಕ್ಕೆ ಸರಿಯಾಗಿ ಹಾಜರಾಗದಿರುವುದು, ಹಾಜರಾಗಲು ಸಭಾಗೃಹವನ್ನು ಪಾಲಿಸದೇ ಇರುವುದು,
ಎಲ್ಲ ಸೀರಿಯಸ್ ಇದಾವೆ. ಎಲ್ಲ ಸೀರಿಯಸ್.
Number 1, my lord, as it reads, my lord, allegations upon my lord, so serious.
ವೇಳೆಗೆ ಸರಿಯಾಗಿ ಕಾಲೇಜಿಗೆ ಬರದೇ ಇರುವುದು ಮತ್ತು ಕೆಲವು ವಿದ್ಯಾರ್ಥಿಗಳನ್ನು ಹಿತಾಸಕ್ತಿಗೆ ಬಳಸಿಕೊಳ್ಳುವುದು. We do not know.
Number 2, very important is, there is no 10-3 compliance with that. 10-3 rule 10-3 of the law of the CCA rules, my lord, contemplates, my lord, that the material, if it is placed before the law, we should apply the independent and pass out to a number of judgments of that.
Read 10-3.
10-3 rules, my lord, CCA rules. In fact, on these grounds, my lord, these judgments were supplied to not submitted to the appellate tribunal, 3-4 design judgments. Or very same tribunal dismisses it, my lord, as well as the number of matters something allowed in that tribunal. 10-3, my lord, very. 10-3 reads, my lord, the authority competent the authority competent to place a government under suspension shall examine the relevant material relating to the case and consider whether there is a prima facie evidence to support the charges made against the government officer servant, and it is satisfied on such examination that prima facie evidence exists, it may place the government concerned under suspension. My understanding is, my lord, report is placed.
Please read. Read the provision.
An order of suspension made or hint to have been made under this rule shall continue to remain in force.
ಯಾವುದು ಎಲ್ಲಿ ಓದ್ತಾ ಇದೆ ನೀವು? The authority competent to place a government servant under suspension shall examine the relevant material relating to the prima facie evidence to support the charges made against
the government servant, and it is satisfied on such examination that prima facie evidence exists, it may place the government under concerned suspension. On these, this provision, the law has comes across every day almost before Karnataka Service Administrative Tribunal. Number of judges are supported. I have produced them. They were very much here. They were very much here.
ಅಲ್ಲಿ ಏನೋ ಒಂದು ಸಸ್ಪೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
These annexures were produced for Article 14, page 56 onwards. 56 the interim order. Then annexure A5 on 10-3 only it has been done. Then annexure A6 division bench judgment of case.
Order of suspension ತೋರಿಸಿ.
Order of suspension very simple, page 54. That's what. Page 54. ಈಗ ನಾನು ಓದಿದ್ದು what is done is ಅದನ್ನ ಆ ಕ್ಲಾಸ್ ಹಾಕೋತಾರೆ. 6 clauses ಆದ್ಮೇಲೆ next time ಈ ಮೇಲೆ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕಾರಣ ಕೇಳಿ ನೋಟಿಸ್ ಹೊರಡಿಸಿ ತಿರಸ್ಕರಿಸಿ ನೋಟಿಸ್ ಹೊರಡಿಸಾದ್ಮೇಲೆ ತಮಗೆ ತಕ್ಕದಲ್ಲದ ಆದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನಿಯಮವನ್ನು ಉಲ್ಲಂಘಿಸಿ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ತರವಲ್ಲರಿಗೆ ತೆಗೆದುಕೊಂಡು ಕಾಲೇಜಿನ ಶೈಕ್ಷಣಿಕ ವಾತಾವರಣ ತೊಂದರೆ ಉಂಟು ಮಾಡುವ ಪ್ರಯುಕ್ತ ದೇಶಾಯಗಳ ಇಲಾಖಾ ಉದ್ಯೋಗ ಕಾಯ್ದಿರಿಸಿ where is the application of fine for him to object to this submission. Independent application should be there to show that the law really requires suspension. Departmental inquiry charges are different. These judgments are very much the Supreme Court. Of course, your Lordship knows that a number of lawyers might have argued. Question is, authority shall consider the mandatory.
ಯಾರು ಸಸ್ಪೆಂಡಿಂಗ್ ಅಥಾರಿಟಿ ಯಾರು?
Government. Of course, yes, this authority will not ನಿರ್ದೇಶಕರು ಶಿಕ್ಷಣ
Government may make notes. There is serious complaint was made against these persons. So before making suspension him, my lord, a report was called for.
ಯಾರಿಂದ ರಿಪೋರ್ಟ್ ಆಯಿತು?
Not by the
ಅದೆಲ್ಲಿದೆ ಆರ್ಡರ್ ನಲ್ಲಿ?
ಇದೆ, ಅದನ್ನು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. Not
ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
by the director of, by them, not deputy director, my lord, did he ಹೇಳಿದ್ದಾರೆ. Not the complaint was made on that basis, my lord, before making suspension, the report was called. He visited them, my lord.
The basis of the
Yes,
report.
it is not that, my lord, simply, my lord, not applied mind. Lord, if you see the, my lord, charges, all the charges after these charges were issued, my lord, he issued a notice. He even, my lord, not received the notice.
ಆ ರಿಪೋರ್ಟ್ ತಗೊಂಡು ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
ರಿಪೋರ್ಟ್ ಯಾರು ಕೊಟ್ಟರು?
Deputy director. He visited the spot. My lord, kindly see the complaint, and all the, my lord, elected complaint was made against these persons. You can understand, my lord, if there is one person, my lord, making allegation, it can be termed as, my lord, personal. If the entire management, elected representative, made a complaint.
ನಿಮ್ಮ ರೆಕಾರ್ಡ್ಸ್ ತೋರಿಸಿ ನಮಗೊಂದ್ಸರಿ.
Please, Thurston.
The DG is requested to accept notice for respondents. Records ತೋರಿಸಿ.
Please.
We want to look into the
Please,
records.
please.
Call on 14th. Huh?
Right now, 90 days of appeal.
90 days of?
90 days will right from suspension.
ಅಲ್ಲ 14th ನೋಡೋಣ, ಅದು ರೆಕಾರ್ಡ್ ನೋಡ್ರಿ ಗೊತ್ತಾಗ್ಬಿಡ್ತದೆ ಏನು ಅಂತ. ನೋಡ್ಕೊಂಡು ನೋಡ್ ನೆಕ್ಸ್ಟ್ ನಿಮ್ಗೆ KET ಆರ್ಡರ್ ಇತ್ತನು ಸ್ಟೇ ಆರ್ಡರ್ ಇತ್ತಾ?
ಇಲ್ಲ
ಅದೇ
Not.
ಬಡಿ ಸರಿ. ಆಗಿದೆಯಾ? ಎಲ್ಲಿದ್ದಾರೆ ಪಾರ್ಟಿ? ಎಲ್ಲಿದ್ದಾರೆ ಪಾರ್ಟೀಸ್? ಎಲ್ಲಿದ್ದಾರೆ?
Next, we note the copy of the joint bill along with below the history. Application that's
ಹಾ, ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇರ್ಬೇಕೋ ಬೇಡ? ಆ ಲೈವ್ ಸ್ಟ್ರೀಮ್ನಾಗ ಎಲ್ಲ ಮುಖ ಎಲ್ಲ ತೋರಿಸೋದು ಇದನ್ನೆಲ್ಲ ಮಾಡ್ತಾರೆ ಪಾರ್ಟಿಗಳದ್ದು. ಏನಾಗ್ತದೆ ನಾಳೆ ಅವ್ರು ಮಾರ್ಕೆಟ್ ಗಿರ್ಕೆಟ್ನಾಗ ಹೋದ್ರೆ? ಬೇಡವಾ? ತೆಗಿರಿ. ಹಾ.
One is that exhibit 27 and 28, which are said to be two sale deeds, and the admissibility of P27 and P28, and the admissibility of value of that your lordships will attach to it. That is one.
The second, you said the cash was paid in, consideration was paid in cash. It was 25 lakh, 25 lakhs, idangittu.
Correct. Yes, but there is
a bit of
a very small portion of land, 600 square feet or so. But square feet. But I think, there's a more compelling fact which is available to dispel that entire document. And that, my lord, is available in the records itself as Exhibit R3. And if I may only trouble my lord to kindly take the order in appeal now. This entire issue has been considered at great length by the court.
But on that basis, one clarification, on that basis, award was passed to which KIDB was a party, and that was rejected, meddled with by this court, coordinate bench. Matter went in SLP, and apex court reversed the judgment of coordinate bench. This what is
My lord,
coming
may I
out.
just explain this? My lord? How it happened was, there is a particular determination made by the reference court. That was challenged, my lord, in a miscellaneous first appeal before this honorable court. When it was challenged before this court, the court set aside the award on only one ground, not on the ground of valuation. It set it aside on the ground that the CEO KIDB was not heard because he was not made a party. That question was challenged before the Supreme Court. Supreme Court said that that finding is incorrect because the beneficiary, who was ArcelorMittal, did not challenge the order of the reference court. Therefore, the judgment, my lord, of ArcelorMittal does not become today a judgment that has been affirmed by the Supreme Court or by your lordships, because your lordships have not gone into the question of correctness of the valuation at all. That, my lord, is the answer insofar as the judgment of this honorable court and the Supreme Court is concerned. This court never had that opportunity to go into it. But, my lord, interestingly, the honorable, the reference court examines this, and I would respectfully submit, my lord, quite well, in saying that I'm not bound by that order because it's not an order of a court of record. I'm only pointing this out not because there are only two ways in which it can be made applicable. Either it has to be res judicata, and therefore section 40 of the Evidence Act will apply, a judgment in rem, which is section 41, or a judgment under section 42 of the Evidence Act, which is relevant but is not determinative of the facts that are contained there. If my lord kindly takes the Evidence Act for a minute.
Evidence Act.
Or my lord, I think now the
41, 44 tanka.
41 to 44, my lord. Absolutely right. 40 to 44. Would your lordship kindly look at 40, my lord, first? Lord, 40, previous judgment relevant to a bar, that is res judicata, my lord. 40 is res
40 is
judicata.
not applicable to you.
Not applicable. Then,
No, but
Lord,
one thing.
yes.
One thing. 40 parties are not same.
Parties are not the same. Land is not the same. So subject matter is different. Then 41, relevancy of certain judgments and probate, there is in rem orders. There is matrimonial, admiralty, insolvency. Then 42, my lord. 42 may have some relevance. I'll just read that to your lordships.
41
Judgment
is judgments in rem.
Yes, 41 are judgments in rem. And
So
this has
that
been
question will not.
That's not right, because it's in persona. 42, judgments, orders, or decrees other than those mentioned in 41 are relevant if they relate to matters of a public nature relevant to the inquiry, but such judgments, orders, or decrees are not conclusive proof of that which they state. And finally, my lord, 43. Judgments, orders, or decrees other than those mentioned in 40, 41, and 42 are irrelevant unless the existence of the judgment, order, or decree is a fact and issue or is relevant under some other provisions of this act.
Where the very existence of judgment is put in issue, then you have to produce it and say judgment is there.
Exists. That's it.
That is 43
Therefore-
scope.
Yes, my lord. Therefore, this, in my respectful submission, at best can come either under 42 or, according to me, under 43. There seems to be one judgment on this point, my lord, which I took out. I don't think I can. I'll have it placed before my lord. A free judgment in land acquisition officer versus Narayanaya considered this question and held that section 43 would apply, and that these judgments 1976. No, I'm sorry, no, I just took it out. 1976, 4 SEC, page 9.
1976 for SEC, page
9.
They considered this aspect of the matter.
Yes, my lord. They considered specifically 43 of the Act. May I just read 2 paragraphs, if your lordship permits? I'm so sorry, my lord. I was sitting here and I did some research, and this is my. Para 25 and 26 are relevant. We find that the High Court did not consider it for some other reason. There could be no question of res judicata in such a case, because an earlier judgment.
40 is excluded, no res judicata.
Yes,
Judgment between parties different.
not between the parties. Further, applicant was not given any opportunity showing that the land judgment related to land which was at some distance from land whose value so and so. Such judgments are not judgments in rem. The second point.
Therefore, 41 is excluded.
Correct. They are judgments in personam. General provision of law governing admissibility of all judgments, whether they are judgments in rem or judgments in personam, operating as res judicata, is section 43 of the Evidence Act, which reads as follows. Which my lord just now read. It is apparent that section 43 enacts that judgments other than those falling under 40 to 42 are irrelevant unless they fall under some other provision of the Evidence Act. And even if they do fall under any other provision, all that is relevant under 43 is the existence of such judgment, order, or decree, provided it is in fact an issue or is relevant under other provisions of this Act. An obvious instance of such judgment is a judgment falling under section 13 of the Evidence Act. Illustration to 13 indicates the kind of facts on which the existence of judgment may be relevant. Therefore, my lord, they did not find in favor in simply referring to an earlier judgment, which is what, in my humble submission, is the case with this judgment. And of course, my lord, there may be one exception. If it is a judgment of a court of record, like this honorable court, my lord, or the Supreme Court, then the finding there may have different impact in making a determination. But a determination of a reference court can never be have any precedential value, since it is not a court of record.
No, we are not on presidential. Precedent concept relates to law
Yes.
made by the courts.
Yes.
We are not on that. We are on the evidentiary aspect of the judgment.
Correct. Therefore, my lord, my humble submission is the reference of what is contained there will only be applicable between those parties. Unless as a general principle, your lordships have laid down some principle which would apply across the board for all these lands. Which is why, my lord, the facts, my lord, it may happen in one particular case, the court makes a determination where sufficient evidence has not been placed on record by the respondent. But in another case, I may place evidence on record to show that the calculation that has been made in some other judgment is completely erroneous. And in this case, I'll show your lordships the finding of the reference court, which I think, my lord, will practically answer the entire argument of the other side. In this case, we produced Exhibit R3, which had the entire set of transactions which have happened from 2006 or 7 till 2011 to show the actual value of the property in this area. And that, my lord, the court has examined at great length. May I humbly request, my lords, to only look at 2 or 3 paragraphs in the reference order.
Page number?
Not page number 175. Para 36.
75.
175, my lord. The internal page of my appeal, I'm so sorry, of the appeal, my lord. 175, internal page 134 of the judgment. Para 36. It is pertinent. To note here, Manoj, that the petitioners only produced the documents pertaining to 2010. What prevented petitioners produce documents sale deeds prior to 2010 to show that the cost of value of land is increasing rapidly from year to year? Further, it is pertinent to note that if really the land situated at Kudithini was sold at 25 lakhs per acre in the year 2010, one of the documents P27 has been produced before the court. What prevented petitioners to produce sale deeds for the year 14, 15, 16 before the court to show that the land at Kudithini, which costs at 25 lakhs or more per acre, to disprove the said contention? RW1 has produced Exhibit R3, that is Market Value Assessment Register Extract issued by the sub-registrar, which clearly shows that during the year 2008, 10/1/2008, 2.32 acres in survey number 337 is alienated 1,62,000. On 11/2/2008, 1 acre was so alienated 80,000. 28/1/2008, 1.41 acres alienated at 85,000. On 26/2/2008, 4.98 acres alienated at 3,33,000. On 11/8/2008, survey number so and so alienated at 6,51,000. On 28/2008, lands in survey number 902 measuring 6.8 acres alienated at 6,18,000. And if you'll just come straight down to the bottom last line, because 2008-9 is there, last line 4/6/2009, the land in survey number 154 measuring 3.15 acres was alienated at rupees 2 lakh. I'm sorry, my lord's got it.
Yes.
Last line 2,84,000. Then 13/8/2009, 2,24,000. 12/4/2009, 12.66 acres at 12,15,000. Then 2010, Manoj. On 24/4/2010, land in survey number 217/4 measuring 1.5 acres alienated 1.25 lakhs. On 25/2010, land in 77 measuring 5.15 acres alienated 3,87,000. 27/5/2010, 1 acre at 2 lakhs. Said lands are all situated at Kudithini village. Likewise, on perusal of market value of land situated at Vivipura from 26/2008 to 27/5/2010, none of the lands were sold more than 3 lakhs. Likewise, on perusal of market value of land situated at Haragina Dhoni from 10/4/2007 to 17/3/2010, none of the lands were sold at more than 3 lakhs. Likewise, on perusal of market value of land situated at Yarangali village from 17/5/2007 to 22/4/2010, none of the lands were sold more than 3 lakhs. So perusal of documents Exhibit R3 discloses that the approximate value for which the lands have been alienated in the year 8 to 10 is not more than the amount between 2 to 4 lakhs per acre. It's actually 2 to 3 million. Hence, if we compare the transaction in 2007 to 10 as per R3 and P27, there is a lot of difference in the amount of sale consideration, which is highly inconsistent. As per P27, 1 acre in survey number 670 was sold for 25 lakhs. That, of course, not is on a calculation. It is not correct to say 1 acre was sold, only 600 and odd square feet was sold. But in the same village, in the same area, none of the lands have been sold more than 3 lakhs as per Exhibit R3. So there's a lot of inconsistency in the sale consideration with respect to the sale transactions. Moreover, R3 is more probable than P27 because R3 was issued by Sub-Registrar Kurugodu. So the perusal of the said descriptions regarding the alienation of lands in the year 2008 to 10 discloses that the land were alienated for the amount of 1.5 to 3 lakhs per acre, and there is inconsistency in the value of the property. It is pertinent to note here the market value of land situated at Kudithini village, Venivura village, Yeranigondan village, Yarangali village, not having same price. It varies from area to area. Hence, without there being any evidence to prove market value of P27, P28, contents cannot be accepted as genuine because of the reason when petitioner claimants approach before the court for enhancement of compensation amount on various grounds, then the burden is on the claimant's petitioners to prove the same before the court by placing convincing, cogent, and probable evidence before the court. I've already discussed above, except producing P27, P28, claimant did not lead evidence of either the vendor or the purchaser of P27, P28. It is also pertinent to note that when the petitioners approach the court by stating that the lands are worth more than 25 lakhs and more per acre, at least they have to produce a sketch before the court to show that the lands are situated abutting to P27, P28, or the lands are situated abutting to national or state highway or railway track situated in the vicinity of any industrial area. It is also pertinent to note here, when the petitioners are very much relying on P27 enhancement of compensation, petitioners have to prove before the court regarding the special features which are available in the land mentioned in P27 for its higher market value, also prove the similarities between land of the petitioners acquired by the LAO at very low rates and the lands alienated at P27 and P28. Similarities in the acquired land and land shown as per 27-28 for fetching lesser value and also fetching higher value of thrown. So absolutely no documentary evidence is placed by the petitioners to prove that this 25 lakh. Then, Manoj, there was another sale deed which we placed before the court. a sale deed, my lord, which was a property sold in the vicinity to as for industrial purposes. That, my lord, will find has been considered by the court at page 189, Exhibit R9. In the middle of the page, my lord, Exhibit R9. My lords have that?
Yes.
Exhibit R9 is a sale deed dated 31/2010, executed by so and so in favor of ACC Limited for a valid sale consideration of 46,20,000. On perusal of same, it reveals said amount of 46,20,000 is paid for 23.1 acres of land situated within the registration district of Bellary and sub-registration district of Bellary in Kudithini village. Further, during course of cross-examination, she admitted that the lands are acquired for the purpose of industrial factory and also admitted that at the time of acquiring the lands, they have taken into consideration the prior market value of 3 years from sub-registrar office. Further, she clearly deposed lands in so and so measuring 1 acre sold for 25 lakhs is created only for the purpose of get more compensation amount. Further, denied that lands of petitioner comes to national highway. Also denied all lands of petitioner were adjacent to main road. She clearly deposed that Exhibit 179 and other health current matters has remanded the case in the High Court. Now, my lords, have on this exemplar sale deed, my lord, which is a concept which we repeatedly speak of. The exemplar sale deeds clearly show that the total value of the land at the relevant period was only between 2 to 3 lakhs, except for these two stray sale deeds, which show consideration as having been paid in cash, which seem to have been, my lord, created for the purposes of trying to make out a case. Which is why, my lord, ultimately the court says.
Where is that apex court judgment which went from, which reversed the judgment of coordinate bench?
That I have produced it along with the memo, Your Lordship, on
So filed it
17th
already?
September. I'll pass on.
In that SLO had stepped into witness box.
Please.
And the beneficiary company was not a party to this?
Beneficiary company was a party, you know. Only the
Beneficiary means
thing is
who?
that the state was not made a
Allotee.
party. Sorry,
Allotee was a party.
was a party.
Now which party?
Respond number 3, my lord. Your Lordship may kindly peruse page number 1 of the judgment, my lord. From below, fifth line.
Beneficiary means allotee. Allotee is not. in one judgment. Which other day you said beneficiary means board only, not allottees.
Please, my lord. Pirapa's judgment and Gregory's judgment, that is very clear, my lord, wherein can I demonstrate those judgment, my lord, for 2 minutes, my lord. Even there also, my lord, in Pirapa's case and Gregory's case, the specific land has been acquired for the purpose of the company, my lord, prior to the notification, my lord. There was an agreement between the KIDB as well as the company, my lord. Subsequently, my lord, the state acquires the land for the purpose of the company, my lord. And after that, my lord, there is an acquisition proceeding initiated for the specifically for the company, and then they approach the court saying that they are the interested parties, my lord. The court has
Not agree with that.
no, my lord. I have produced those judgment along with my written submissions, also along with the memo also, my lord. It is very clear, my lord.
Not the allotee. Allotee is not the beneficiary. Board is the beneficiary. Beneficiary. Correct.
Correct. Fails to implement project, can refund back to the beneficiary.
Some other person
This logic
will not hold it.
May I make one small submission, my lord, with regard to allottees?
Not simple. How do you bother it through?
Chapter 3 of Karnataka Area Development Regulation Board, my lord, 1969, wherein Chapter 3, Regulation 15, allottee as a licensee. May I read it, my lord? Till the agreement for lease, sale, or lease cum sale is executed, the allottee will be considered as mere licensee, who shall
They
have
will not have
license.
any concrete right at all till that event
No,
happens.
and after the award, they have got into an agreement, sale, lease cum sale agreement, my lord.
But when you are allotting, will you stipulate in that allotment letter, the compensation or price which you are paying is likely to be altered in the event 18-1 or now section 74 or SLP? Do you, is there any such stipulation, Guru? Huh? It's liable to undergo change of the condition ಇದೆಯಾ
An agreement.
allotment letter ಅಲ್ಲಿ? ಈಗ ನಿಮ್ಮ KIDBಗೆ land acquire ಆಯ್ತು. You are the beneficiary in the eye of law in the light of that judgment. Suppose when you allot to Mr. X, whether do you stipulate saying that the price which you are going to pay for this is likely to undergo change depending upon the outcome of 18-1 like that? Is there such a condition?
Yes, yes. It is, my lord. Ultimately, we have to bear the entire cost of acquisition.
It's a tentative price.
So the condition of same or any enhancement if it is there.
Will be subject.
So it will have to be.
And my lord, now in any event, the SLAO is before the court. He is of course a proper party, my lord. Therefore, although I'm making submissions now.
No,
in
no,
so
ಏನು
far-
ಹೇಳ್ತಾರೆ ಅಂತ ನೋಡೋಣ. ಈಗ ನಿಮ್ಮ argument ಆಯ್ತು. Provided he argues all this. What is your argument? ಕೊಡಿ. ಆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ನಿಮ್ದೇನಿದೆ ವರ್ಷನ್?
How the judgment has to be construed, paragraph 15.
ಅರಾ? The awards and judgments.
The awards and
Manoj Kumar
judgments
case.
in cases of other not being able to say are not valuable. Recently, we have seen the trend of the courts to follow them blindly, probably under the misconception of concept of equality and fair treatment. The courts are being swayed away in this approach in the absence of and of similar nature, and situations of the land is causing both injustice and tantamount to being equal treatment. In case of promises, as per situation of village nature of the land, its values differ from distance to distance. 2 or 3 kilometers distance belongs to the interior land. Land about highway methods clear, but not land situated in interior villages. The previous awards judgments are only piece of evidence at par with comparative skills and sales transaction. Similarity of the land covered by the previous judgment award is required to be proved by any of the comparative adjustment. Again, previous award judgment is based on exemplar, which is not similar or acceptable. Previous judgment or award of the court cannot be said to be final. Such determination has to be outrightly rejected. In case some mistake has been done in awarding compensation, it cannot be followed on the ground of clarity, and illegality cannot be perpetuated. Such awards are effectively wholly irrelevant. There is yet another serious infirmity seen following the judgment or award passed in acquisition, made before 10 to 12 years, and price is being determined on that basis by either flat increase or security increase as per the choice of individual judge, without going into the complete dynamic. Such method of compensation is available only when there is the absence of state transaction. Before issuance of notification under section 4 of the Act and for giving annual increase, evidence should reflect that price of the land had appreciated regularly and did not remain static. The recent trend for several years indicates that the price of the land is more or less static if it has not gone down. So that there is no appreciation of value. Thus, in our opinion, it is not a very safe method of determining compensation. To base determination of compensation on the previous judgment or award, evidence considering the previous judgment or award and its acceptability or judicial parameters has to be necessarily followed. Otherwise, gross injustice may be caused to any of the parties. In case some gross mistake or illegality has been committed in previous judgment and award of not making deductions, etc., sufficient evidence has not been produced, and better evidence is produced in case of them. Previous judgment and award being not inter-alia, not inter-parties cannot be followed, and if the land is not similar in nature in all aspects, it has to be outrightly rejected, as in the case of comparative examples. Bailies are at par of for evidentiary value with such awards.
ಪ್ಯಾರಾ 19 ದಲ್ಲಿ ಕೋರ್ಟ್ ಆಗಿದ್ದು ಧ್ಯಾನ್ ಕೋರ್ಟ್ ಮಾಡಿದ ಜಜ್ಮೆಂಟ್
Yes, it is 1964 SEC 9. Yes, exactly. But judgment plots is followed. This is the judgment plots of the year 2017.
ಶಾಂತನಗೌಡ ಸಾಹೇಬ್ರದ್ದು.
To rely upon judgment award in case it does not follow the path of evidence recorded by reference court. An application under Article Rule 27 is to be filed to produce evidence, and if it is allowed, opposite parties to be given an opportunity to view the evidence and debate. The award judgment should not be taken into consideration by hearing arguments unless they form the part of evidence in the case. Therefore, the judgment not now that has been relied upon by the other side.
ಸ್ವರ್ಣ ಸಿಂಗ್ ಕೇಸ್ ನಾವು ಸೇಮ್ ಕನ್ಸಿಡರ್ ಮಾಡಿನ ಕೊಟ್ಟಾರ ಇದ್ರೊಳಗೆ ಏನು ಮಾಡ್ಯಾರ ಇದು ಮತ್ತೆ ನಾ ಇದನ್ನ ಓದೇನಿ ಇದು ಸ್ವರ್ಣ ಸಿಂಗ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಾರ this is not applicable. Correct, sir. In this particular case, na compilation ಮಾಡಂಗಿ ಇದ್ರೊಳಗನು ಇದೆಲ್ಲ ಸೇಮ್ ಕೊಟ್ಟಾರ ಅದೇ ಇದು ನನಗೆ ಇದನ್ನ ಮಾಡ್ಬೇಕು ನನ್ನ ಹತ್ರ ಇದೆ ಅದು ಸೇಮ್ ಹೇಳಿದ್ ಕೊಟ್ಟಾರ ನನಗೆ ಗೊತ್ತೈತಿ 100% ಐತಿ
ಪ್ಯಾರಾ 20 ನೋಡಲ್ ಪ್ಯಾರಾ 27 ಗುರು ಪ್ಯಾರಾ 27 ನೋಡಿ ದೇ ಆರ್ ರಿಲೆವೆಂಟ್ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು ಪ್ಯಾರಾ 27 ದಲ್ಲಿ See that. Neither under section 11 nor under 13.
Questions relating to value of similar pieces of land depend upon the evidence in the particular case in whose facts are true, in which those facts are true. The embodied findings or opinions relating to facts and issues and investigated in different cases. The existence of the judgment would not prove the value of some piece of land or help with at all in the judgment admitted in evidence. Even slightest difference in situation can sometimes cause considerable differences in value. We do not
Slowly. We do not think restrictive a view of the provisions of 11 and 13 as to exclude such judgments altogether from evidence, even when good grounds are made out for their admission.
judgments to be relevant if they relate to similarly situated problems and contain definitions of values.
They have followed full bench 63 judgment. Completely exclude ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಇವ್ರು. That appears to be too broad a proposition. Your 76 Supreme Court is interpreted by 2017 Supreme Court. So they have referred to Bombay High Court judgments. You cannot simply construe.
No, which is why I'm saying, my lord, it could come under 42, which is why I said it could come under 42 as relevant, but can be shown to be wrong. Because 42 has two parts. If your lordship sees 42, 42 speaks of relevancy, but judgment or decree not conclusive proof of what they state.
That is 41.
42.
Yeah, of course, judgments, their evidentiary material is never conclusive. Even admission is not conclusive. Section 30 or 31 is there. Evidence Act.
Correct.
Evidence Act says
Yes,
admissions are not conclusive evidence of what is admitted. Section says that way.
No, why I'm saying this is because if you want to take the benefit of a particular judgment, then you must also show as to how that judgment will apply to you and whether the judgment is right or wrong. So it is not simpliciter to file a judgment and say, I have filed the judgment, now give me that compensation.
No, that will not be sufficient. The factors on which the said judgment is structured, those factors need to be proved is your worship.
Correct. And not
because those judgments are not taken as res judicata, nor as a precedent. They are taken only as evidentiary of what has been stated in that.
Yes, and they may only come under 11. If your lordship says section 11 of the Evidence Act, at best they'll come under 11. Not 12 and 13, because custom and right is not in question.
It's more like plea of alibi.
That's it.
This is called doctrine of plea of alibi. This is how Professor our Hiregaudra sir used to teach us plea of alibi. Section 11 used to be taught extensively in the court hall, in the classroom. Thirteen is custom.
13 is custom.
No, 13 is custom specific. Case is not that way, therefore 13 is not applicable. We can understand. But 11 plea of alibi is a big literature has been developed on that. In fact, plea of alibi, field on evidence. Field on evidence discusses extensively. Whole volume is, almost one volume is dedicated for that. All right, let us. You are adopting argument. Anything more to be stated?
Your lordship, in exhibit P20, my lord, wherein in the judgment of the Mittal's case, exhibit P13 is there, my lord.
P32.
13.
31 is, here it becomes P
In my case, exhibit P,
28, 7 or 28? 28.
20 minutes, sorry. Exhibit
20?
P20.
P20.
P20. And in the judgment of Mittal's case, it is exhibit P13.
Identical, same.
Please, my lord. Wherein, my lord, the last occasion I shown about this chart, my lord.
Exhibit P20 in this case.
In this case, and exhibit
becomes exhibit P31.
13.
In
13.
13.
Please, my lord.
In that Supreme Court
Taking into
judgment.
consideration, please, my lord. Taking into consideration of this, my lord, the market value has been fixed, my lord. But your lordship, in that particular sale transactions which has been produced by the SLAO of 2009 and 10, my lord.
Yes.
As per the case of Meherwal Kehvajia case, the highest sale deed is to be taken into consideration, my lord.
Yes.
But even assuming that if the sales statistic of 2009 and 10 of NA land is taken into consideration, the market value goes higher, my lord, which I have stated in my written submissions, my lord, as your lordship in the last
2009?
9 and 10. Written submissions. Page 7 of my written submission, my lord, I have stated with your para 18, my lord. Page 7, ink page 7.
In your written submission.
Written submission, my lord.
Page number?
7, my lord. Para 18. I have just narrated with regard to the sale deeds, my lord, that as per exhibit P20, that is compilation page number 63, the NA land rates are serial number 7 is sold for rupees 2,43,93,600 per acre, measuring 625 square meter on 7/9/2009, my lord. And that if we deduct it with the 33% towards development charges as per Ashraf's case.
That comes to 1 crore 62 lakh.
That comes to 1 crore 62 lakh 63,213 per acre, my lord. And another sale deed, which is at serial number 10, is sold for rupees 1 crore 35 lakh 30,000 per acre, measuring
But only 660 square meters there.
Even, my lord, as
it is also 625.
Please, my lord, I have produced the judgment of the Honorable Apex Court, wherein even a small bit of land can be considered for the large chunk of land. If there is no sale deed with regard to large extent of land, can be considered with the minimum deductions, my lord. So accordingly, I have produced the judgment with regard to that, my lord. That is the Trishila Jain's case and another.
2011 Supreme Court.
Please, my lord, 2011 Supreme Court, para 828, para 82, my lord. There only 10% was deducted. 20%, my lord. And Atma Singh case, specifically this particular case, my lord, wherein agriculture land has been acquired for the purpose of industries, my lord, wherein there is an observation made by the Honorable Apex Court stating that when the land has been acquired for the industrial purpose, there will be income generated subsequently, my lord, for which para 15, my lord, may I read it, my lord? An industry established on acquired land, if runs efficiently, earn money or make profit every year. The return from the land acquired for the purpose of housing colony or offices or institution cannot even remotely be compared with the land which has been acquired for the purpose of setting up factory or industry. After all, the factory cannot be set up without the land, and if such land is given substantial return, there is no justification for making any deduction for the price exhibited by the exemplar, even if they are of small plots, my lord. And the deduction was made only 10%, my lord. And even my third judgment is Meherwal Kevajia Trust Farida Court versus State of Punjab and others, reported in 2012 5 SCC 432, my lord, para 17, my lord, wherein several exemplars with reference to similar lands. It is the general rule that the highest of exemplar, if it is satisfied that it is a bona fide transaction, has to be considered and accepted when the land is being compulsory taken away from the person he is entitled to the highest value which similar land in the locality is shown to have fetched in a bona fide transaction entered into in the
Highest value should be taken
highest to be taken into consideration, my lord. And accordingly, the highest say deed has been considered, my lord. And in Ashraf case, my lords, in this particular case, my lord, different villages arise, different areas, my lord. There were deduction of 70, 60, 30, 40, 15, 10. All different states, my lord, taking into one compilation and has deducted 33.33 towards development charges, my lord.
Which is that?
That is at page number 10, my lord. Ashraf and others versus state of
Yeah, no.
Karnataka and another reported in AR 2013 SC 3654, my lord. The land acquired in different state and in different areas, even within the different states, principles of deduction is applied to all the cases at 33.33% towards development charges, my lord. And coming to here, we are specifically relying on this particular exhibit 179, that is the judgment of the Mittal's case, my lord. Taking into consideration of these say deeds, my lord, the SLO, wherein, my lord, the deputy commissioner has directed the SLO to reconsider the document, and subsequently, after taking the average say deed of 13, my lord, the price has fixed to 50 lakh, and in the Mittal's case, my lord, the 40% has been deducted, my lord. So it comes to 30 lakh 20,270 per acre, my lord. And this particular land, my lord, as per the maps, my lord, wherein the land is particularly situated within the vicinity of industrial area, my lord. My land, though it is an agriculture land, it is having an industrial potential land, my lord. So once there is one more judgment which I have produced is with regard to the conversion of land, my lord, there are n number of judgments. Only one judgment I have produced before this honorable court for consideration is that once the land comes within the urban municipal limits, then it has to be treated as NA land, my lord. Though it is an agricultural land, but it has to be considered as NA potential, my lord. And coming to one more judgment which I have produced at page number 13, my lord. That is Nagpur Improvement Trust versus Vittal Rao 1973 1 SCC 500. The Constitutional Bench of Honorable Apex Court, my lord.
Very famous judgment in land acquisition.
That is very famous case, my lord.
All right.
There Article 14 which attracts, my lord, that once and moreover, my lord, in the Mittal's case, my lord, the major Kurtini land have 4,000 acres has been acquired, my lord. And Hargindoni is of 700 odd, my lord, has been acquired, my lord. They themselves admitted that there is no such say deed beyond that, my lord. But still the land value was given to the land loser for those villagers was also of 30 lakh only, my lord. Though their land is also an agriculture land, my lord, in Mittal's case, my lord. And I have produced the judgment wherein your lordship in the last occasion has questioned that whether for the same notification, entire same notification, same rate is to be given. For which I have produced at page para 30, my lord. Sorry, para 30, sorry, page 16, my lord. I have produced Ali Muhammad Beg and others was a state of Jammu and Kashmir 2017 for SCC 717, my lord. Union of India versus Balram.
Mr. Shastri proceeding to service.
Sorry.
Mr. Shastri proceeding to service. No.
And one more, my lord, there's Union of India versus Balram AI 2004 SC 3981, my lord. There, my lord, 13 villages acquired under the same notification for the very same purpose, my lord. Arising out of that, my lord, out of same notification, same purpose of acquisition, it was held that it would be unfair to discriminate between landowners to pay more or less to others when the purpose of acquisition is same and the lands are identical and similar, though laying in a different villages, my lord. And one more very important judgment for my particular case is, my lord, this Ali Muhammad Beg and others was state of Jammu and Kashmir and Union of India versus Harindra Pal Singh versus and others 2005 to 12 SCC 564, my lord.
Yes.
These are the judgments which I have relied, and insofar as Nandram's case also. All these are, and this particular Ali Muhammad Beg, my lord, there, my lord, in that particular case, my lord, SLO has awarded 3 different rates, reference court awarded 3 different rates, and the High Court has considered fixed only one rate, my lord. And though there are 3 notifications of same year, same amount has been fixed to the particular lands, my lord. Because the lands are of arising out of same survey, same same purpose.
You have filed your written submission, na?
Yes, please. My lord. And practically, my lord, insofar as these technical issues with regard to my appeals, my lord, since I have filed first appeal arising out of first judgment by the reference court, my lord, I have preferred this appeal, my lord. Subsequently, after review petition, I have filed one more appeal because under impression that there should be any technicalities, since the separate award was passed, my lord, I have challenged that under the this particular case. So my claimants' appeals are of two appeals which are pending on arising out of same LAC, my lord.
Okay.
So I have paid the court fee in two different portions, my lord.
Okay.
So that is to be taken into consideration.
Anything you want
And
to
my
say?
lord, one more submission. There are in 7 cases, the claimants have died, my lord. So I'm 7 cases,
Your
7
application
appeals.
is filed.
Today I have got it, my lord, but I could not file it. It was delayed, my lord.
ಏನು ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್
Please, my lord.
ತೊಳಿ ನಿಮ್ಮ ಅವ್ರ ಪಾರ್ಟೀಸ್ ಅಲ್ಲೂ ಇದರಲ್ಲಿ
ಇದೆ. Memo have.
ಅಲ್ದೇ ಎಲ್ಲಾರು ಸರ್ ಬ್ರಾಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಯಾವ್ದೋ ಎಲ್ಲಾರು ಸರ್ ಇವರು ಪಾರ್ಟಿ ಏನೋ ಡೆತ್ ಆಗಿದೆ ಅಂತಲ್ಲ ನಿಮ್ದ್ರಲ್ಲೂ ತರಬೇಕಾಗ್ತದೆ ಅಟ್ಲೀಸ್ಟ್ ಒಂದು ಮೆಮೋರ್ ಹಾಕ್ಬೇಕಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಏನಾರ ಒಂದು ಹಾಕ್ಬೇಕಲ್ಲ. Then let them file application tomorrow, day after tomorrow.
We'll do that. We'll do that.
ಅದೊಂದು ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
I have, sir. Please.
ಅದ್ರ ಜೊತೆಗೆ ಮಾಡೋಣ ಆರ್ಡರ್.
One
Day after tomorrow. Friday? Huh? You have argued, we have, don't confuse us. We have somehow.
Are not sale deeds. One is the mortgage deed, one is the gift deed, and they are not the value mentioned in the mortgage deed and the gift deed is referred to as if it's the sale deed. That's the reason why everything else is a
Yes,
small
ma'am.
amount.
The document is, one is a mortgage deed for 3.5 lakhs of loan. That is taken as the value, then that is multiplied, giving a 2.5 crore value. The second one is a gift deed. In the gift deed, a value is shown.
Where have you mentioned in your reply? Or at least ಮಾಡಿಕೊಡಿ ನಮಗೆ. You have to say that.
Yes, Lord. Which is why we can demonstrate that the judgment is wrong in principle.
We have produced P13 and all the enclosures that have been referred to in
Now you have seen each other's argument.
Please.
You prepare additional reply.
Please.
You prepare your statement also. Then everything needs to be updated.
Please.
Both legal and factual.
Please.
Yes, Chaitanya.
I appear in 2 connected appeals on behalf of Sri G.B. Shastri, my lord, producing the citations. My lords, in the list of authorities itself, my lords, I have stated the gist of the.
Friday.
Please.
In the Friday, ಕೊಟ್ಬಿಡು ತಗೊಂಡು ಮತ್ತೆ ನಮ್ಗೆ ಓದಲಿಕ್ಕಾಗಲ್ಲ ಅದು ಕೊಟ್ಟು so that you can make that submission.
Please.
Yes.
Grateful.
ನೋಡಿ ಈಗಾಗಲ್ಲ after vacation.
Serial number 41, already connected matter was there.
40.
41. 41 we connect the lab. Connected cases take 50%.
Judgment ಸಿಕ್ತಲ್ಲ
Yes, madam.
ಯಾವ್ದದು
But Swabhimana Cooperative.
ಅದು ಗವರ್ಮೆಂಟ್ ಎಡುಕೇಟ್ ಕೊಡು.
I've given, madam, I've given the copy, madam.
Lord, I'm for respondent number 5. 2 days time may be given, my lord.
For the tribunal within a period of 8 weeks, the tribunal is requested to invest the said amount, recurring and fixed deposit for initial period of 1 year to be declared new.
ಯಾವ ಇಯರ್ 2019 ಈಗೆಲ್ಲ ಈಗ ಆಗೋದಿಲ್ಲ ಇವೆಲ್ಲ ಇಷ್ಟೆಲ್ಲ ಬರ್ತಿದೆ ಇದು
Notice WhatsApp version. Parties are appointment of guardian.
Appointment of guardian is 40, serial number 40. My lords have directed me to file affidavit.
Right, next. ಇನ್ನೊಂದು ಯಾವ್ದು ಹೇಳಿದ್ರು? ಹಾ, ಇದ್ರಲ್ಲಿ 43 ದಲ್ಲಿ 43 ದಲ್ಲಿ ಎಮರ್ಷನ್ ನೋಟಿಸ್, 40 ಅಪ್ಲಿಕೇಶನ್.
ನೆಕ್ಸ್ಟ್ ಬೆಂಚ್ ನಾವೇಂಗ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೋದು? ಅದು ಕೊಟ್ಟಿರಿ, ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಟ್ಟಿರಿ, ನೋಡೋಣ. Immediate application.
May I request it tomorrow notes? Interim order I have sought notes. Interim order I have sought, but they have license if it is given to respondent number 5. Notes, the financial viability has been not proved by them. Notes. Tomorrow,
All matters are posted.
interim order may be granted, notes, covered by decision of your lordships only. Notes.
ಯಾರು appear ಆಗ್ತಾರೆ?
Government advocate notes and.
What do you say? We have held that Sauvarda and cooperative are one and the same.
Yes.
ಎರಡು ಸೇಮ್ ಫೋಲ್ಡ್ ಮಾಡಿ ಅಪ್ಲೋಡ್ ಆಗಿದೆ.
And that is being confirmed notes by the division bench also. Please.